6 Central, Yellow County.
642.
Transmission to Yagan 4 has stopped. Attention. Satellite beyond NKS1 is now overhead at 2241.500 MHz. Elevation 49.6 degrees. Attention. Satellite Cosmos 2548 is now overhead at 2241.000 MHz. Elevation 56.1 degrees.
649T. One 24. Can you open me up a jar check, please?
Yes.
Attention. Satellite World View 2 is now overhead at 2257.000 MHz. Elevation 15.3 degrees.
Zero 07 County 23 Joe.
Hi, Tim Anthony.
Okay, good morning, everyone. As Mayor Pro Tem, I call this meeting to order. City Secretary, would you please call the roll of the required charter officers?
Mayor Pro Tem Kaylin Paxson.
Present.
Councilmember Sylvia Campos. Here. Eric Andu. Gil Hernandez. Here. Mark Scott. Here. Carolyn Vaughn. Here. And for the record, Councilmembers Roland Barrera and Everett Roy have recused. Assistant City Manager Ernesto de la Garza.
Here.
And Assistant City Attorney Lisa Aguilar.
Here.
Okay, we do have a quorum present to conduct the meeting.
And thank you very much. At this time, the council will go into, I apologize. To commence the hearing, again, I apologize. At this time, I open public comment, and to stay consistent with the previous meeting, public comment will be limited to 1 minute per speaker. If we can bring our first speaker forward.
May respondent be heard prior to the start of public comment?
Yes, sir.
Thank you. Respondent has a motion for continuance that he'd like to file with the city secretary right now, and I have a copy of that I'm going to file with the city secretary, and I'd be happy to explain that. And I just, at this point, also have to state my objection. Respondent renews her continuing due process objection that members of this tribunal are material witnesses with personal knowledge of disputed adjudicative facts, and therefore cannot simultaneously act as neutral fact finders. Respondent further objects on admission of any evidence on previously asserted evidentiary grounds. May I approach the city secretary and opposing counsel and the dais with my motion for continuance and explain?
You may approach us.
Thank you.
Flight 784 number.
Ms. Rebecca, did each of you receive a copy of this motion?
Ma'am,
Did each of you receive a copy of this motion?
I have the motion now, yes, ma'am.
You have it.
But prior, no. Yeah, this is the first we've seen it, but yes.
Thank you. Can I request for a copy for each of our board here?
And I apologize. I brought 5 copies, and I apologize. I probably should have brought one for everybody.
We can make copies.
Electronic trend.
Yeah, we'll make copies.
Thank you.
Sort of a point of order, if I may. I would think public comment should go first because it's a meeting that's already been opened. But irrespective of that, totally your discretion. There's other motions that are first filed that I think we ought to get to before this. In other words, I think we should do them in the order they've been filed because that would be appropriate to follow that order.
And just as a very brief response, there was, from the respondent's position, there's a risk of not presenting a motion for continuance as early as possible, and that it can be waived. And so I had to, under procedural rules and under due process, present this to the tribunal as soon as possible. So that's why I did it that way. It's not for any other reason.
I can cure that so that we can do the motions in the order they were filed. I'll agree he's not waiving anything. I'll agree he's not waiving anything.
What we will do next then is, while we wait for everyone to get a copy of this, I would like to still move forward with public comments to save time. So that's what we will do at this time. We'll wait for those copies. And for public commenters, if our first commenter will make their way to the front,
And with all respect, I just want to renew respondent's motion for continuance at this time, because even with council's statement, do run the risk of waiving the substantive rights that are contained within that motion. So
Noted.
Urge its ruling prior to any further proceedings. Thank you.
Noted. Thank you. Our first public commenter this morning is Mr. Mo Chavez. Mrs. Mo Chavez. Thank you.
It's okay. It happens all the time. Good morning, Mayor Pro Tem and council members. Mo Chavez from District 4. I've had the unique opportunity to observe our mayor over the years, not just in public, but behind scenes. Character is revealed when no one is watching, and I've watched Mayor Guajardo when there was no camera, no microphone was present, and there was no political advantage to be gained. But I was watching, and what I saw was someone who treated every person with kindness, respect, and dignity, regardless of their position or title. Integrity is measured on how we treat people when there is nothing to gain, and that is exactly what I have witnessed. I have also watched her stand her ground in rooms filled with influential business leaders in the midst of very difficult conversations. She was never intimidated. She was prepared, informed, poised, and steadfast in advocating for what she believed was in the best interest for Corpus Christi. Public service is ultimately about people, and I've seen her put people first. Whether someone agrees with every decision she has made is not the point. Leadership is not about avoiding difficult conversations. It's about facing them with courage and professionalism. Based on what I've personally witnessed, I believe this council removing the mayor is a mistake.
Thank you, Ms. Chavez. Next, we have Jennifer Hedgedorn.
Good morning. My name is Jennifer Hagedorn. I am from District 3, and I'm here this morning. I rise today in strong opposition to this effort to remove Paulette Guajardo as mayor. This hearing stems from the same matter where 5 different law enforcement agencies found no criminal, ethical, or legal wrongdoing. If there was no wrongdoing, there should be no basis to remove the duty elected mayor of Corpus Christi. The removal petition also ignores key sworn testimony that City Manager Peter Zanoni testified that the mayor did not know the information being alleged. And the Economic Development Director, Heather Holbrook, stated in writing that she placed the agenda item herself. Those facts matter. The public also deserves confidence that this process is fair. And when the attorney leading this removal effort is also involved in related litigation against the city, and individuals identified as witnesses are participating in these proceedings, it raises serious questions that cannot simply be ignored. Today, the council is considering removing the mayor just months before voters have their say. And the office of mayor belongs to the people, not to the council.
Thank you.
Unless there are clear legal grounds, the voters, not politicians, to decide who serves this office.
Thank you, Ms. Hedge.
All right, thank you.
James Allman.
Hi, good morning. My name is James Allman. I'm in District 5. I'll go quick. Please do not remove the mayor, our duly elected mayor. This is political, petty, and pathetic. We have wasted time focusing on the wrong issues. This group who is pushing this circus, you have destroyed the city's reputation, credit, and economy. Every minute spent on this is a minute not spent on real issues. Mr. Gum, you can look at me if you don't mind. You're my councilman. Are you an election denier? Because the city is about to vote. The city voted for the mayor. Do you realize she got 46,759 votes? Ms. Pro Tem, you got 4,400 in a runoff. Mr. Gill, who still won't look at me, who's my councilman, you got 11,000. Maybe Ms. Vaughn, you got 33. But again, how can any of y'all remove a mayor who has more votes than y'all got? What are we doing here? So again, I respectfully ask, let the citizens of Corpus Christi make that decision, not election deniers. Thank you.
Thank you, Mr. Allman. Polly Harris.
Hi, my name is Polly Harris. I live somewhere, anywhere. Anyway, good morning. I rise today in strong opposition to this effort to remove Mayor Paulette Guajardo. This hearing is about far more than one person. It's about whether the extraordinary power of removal should be used when there has been no finding of criminal wrongdoing, no finding of ethical wrongdoing, and no finding of legal wrongdoing by the agencies that investigated these allegations. The attorney leading this removal effort, Doug Allison, is also representing hotel developer Ajit David in litigation against the city of Corpus Christi. At the same time, mediation has been taking place involving the city and members of the council regarding that lawsuit. Residents deserve to ask whether those overlapping roles create a conflict that undermines the confidence in this process. Public trust requires that these proceedings be fair, impartial, and beyond question.
Oh my God.
And you know, I have
11
friends
was
from
my
all over the country that are talking about U5,
Thank you.
and it's pathetic.
Sharon Custer-Sedgwick.
Good morning, Sharon Sedgwick, District 3. I'm going to try not to lose my temper today, I really am. Today, you are considering removing the duly elected mayor approximately 90 days before voting begins. That decision belongs to the voters, not to you guys. I know there's a lot occurring for that mayor seat, but it doesn't belong to you people. The people of Corpus Christi elected their mayor. You've heard the numbers. And absent clear legal grounds, which they have been found none, they should also be the ones who decide who sits in that chair. The public will draw its own conclusions about today's actions. They're not good. They will decide whether this process protected the integrity of our government or weakened public confidence in it. And it's all on you guys.
Thank you, Ms. Sedgwick. Alex Harris.
Good morning, Mayor Pro Tem and council members that are here. Alex Harris, 2138 State Highway 286. I'm up here in opposition to what you are doing. Who should be on trial today is Carolyn Paxton. Carolyn Vaughn, Caitlin Paxton, y'all should be on trial, not the mayor. What about the ethics violations I filed against you? For wrongful contributions, for taking contributions and not reporting them, for taking contributions from corporations, that is a corporation that's not allowed to do that. That's what all of these are. I look to the media that is here today. I have all of those on this thing. I'd like a copy of them because I think the public is entitled to see them and to hear them because that's what this is about, Eric. You know what it's about, just like the video that's out there about you. These are things that y'all are hiding from, completely hiding from. Well, let's disclose them to the public. Let's show the public these violations. Let's open them up so let's see what you've been doing.
Thank you, Mr. Harris. Melinda de los Santos.
Good morning, Melinda de los Santos, District 2. After listening to this, I constantly remind myself God intentionally uses flawed and broken people to carry out His divine plan. What I've learned regarding these 5 agencies they keep talking about, the government, the medical, the judicial, educational, law enforcement has brought not only a mistrust, but a true sickening to my core of what people are capable of doing out of greed and power. People want to bring truth to light or suppress through harassment, retaliation, and death threats. Our city, state, and nation has been infected with a disease called fraud. We need to applaud Rachel for her courage to bring truth to light. Regarding the votes, Mayor won, she only won on the mail-in votes, and we have all learned that that is the most fraudulent part of the voting. She did not win in early voting and did not win on election day. Thank you.
13 traffic.
Mr. Todd Norton. Mr. Todd Norton. Mr. Todd
Yokelman
Norton.
Harrison with a
Kathy
Florida
Fulton.
plate Frank Tom Charles, Victor 41, Frank Tom Charles, Victor 41, Yokohama Harrison.
Before I start, I'd just like to point out that it says 1 minute or 3 minutes on the agenda. Not 1 minute, but I'm just pointing that out. My name is Kathy Fulton. I'm from Port Aransas, Texas. I'm here in support of the mayor. I think that this farce of a hearing going on is vindictive, trying to get back at I don't know who. You think something's wrong, but there's other people on this panel right now who were all a part of the vote back in 2024. Okay? So everybody was aware of everything, and that includes you, Ms. Campos, and you, Mr. Hernandez. This is being led by some people who are the puppeteers, and one of them is sitting right here next to me, and that is Mr. Allison. He is the puppeteer, and you guys are the puppets. So is the public, and let's just be clear, the public is being duped by false allegations against a very reputable and a woman of integrity. The mayor is a good person and is not the one at fault for what's going on. Everybody should be held accountable if that's the case. Everybody that was on that boat back in 2024 should be held accountable. Thank you.
Ms. Fulton. Mr. Kevin Benton. Mr. Kevin Benton. Mr. Kevin Benton. John Hanzelick. John Hanzelick. John Hanzelick. Rachel Caballero. Wave, thank you. Miss Sandra Meyer.
Good morning, Sandra Meyer from D4. Thank y'all for what y'all are doing as far as being city council people. Just as a reminder, we still have a city ethics policy that says that you are not allowed to vote if you have received campaign contributions within the last cycle. I learned about it coincidentally from Mr. David's lawsuit. That's how I even found the policy. It was in a little footnote. So with that, but the thing I want to say today is y'all are writing your legacy today because the audit office got weaponized. Evidence suggests is what y'all are doing is going to become the topic.
13 DL coming back to Lauren Renee Segovia Brown. She is eligible and clear, has a license to carry.
Any ethics class for people that go to
LP
college.
is coming back to a rental car. It's going to be Enterprise. Showing a 2026 Chrysler van vehicle is clear.
Accounting professor last year.
Thank you, Ms. Meyer. Ms. Rebecca Huerta, I have one signed up for WebEx. Do we have them online?
I believe so. Melody Cooper.
Can you hear me?
Yes, ma'am, we can.
Okay. Melody Cooper, District 5. I'm sorry I can't be with you in person via litigation out of town. I will be brief, which most of you will no doubt appreciate. There is no mystery that I am firmly in support of Mayor Fajardo and against his repugnant and unjustifiable removal action. I've made this crystal clear. This came from the court of your being petitioner, judge, witness, juror, and executioner is beyond the pale of legitimacy. It is particularly galling in view of your simultaneous attempt to change the removal provisions of the city charter to make yourselves safer if a removal action is brought against you, and believe me, it will be. I do not believe anything I say today will make a difference to you. I'm not stupid, but neither are the citizens of our great city. You may very well achieve your goal of removal, but the voters will not forget this week, next month, or next decade. This is your legacy with which you will have to live. The debacle is far from over. Savor your victory.
Thank you, Ms. Short. Ms. Rebecca, do we have any further requests for public?
No, ma'am. That concludes the public comment period.
Okay, thank you very much. At this time, I'll allow Mr. Flood to address his motion for continuance again.
Thank you. Yesterday afternoon, today is the 22nd, yesterday afternoon, the 21st, while my client, the respondent, was presiding over a council meeting, The petitioners added 19 additional exhibits to their already extensive exhibit list. 1,922 pages of documentation, 5 videos and 1 audio. Between that time and now, it has my client to review those. Prior to the start of this hearing, it was impossible for me to review them prior to the start of this hearing. And respondent requires additional time to review this new evidence prior to the initiation of this hearing. In addition, this provision of nearly 2,000 additional pages of evidence is a further violation of my client's due process. Receipt of new evidence offered against her that she can't review and can't prepare to respond to prior to the start of the hearing violates her procedural and due process and substantive due process rights under Texas and federal law. And in addition to the previously stated, and I will restate, and you will get used to me restating, my objection on due process grounds that members of this tribunal are material witnesses with personal knowledge of disputed adjudicated facts, and therefore cannot, under our Constitution, sit simultaneously as neutral fact finders. And so, on the grounds stated in the motion for continuance, my client respectfully requests a continuance of this hearing in order to provide time to review that evidence before the start of the hearing.
Thank you, Mr. Flood. Could you identify which exhibit you're referencing?
What are those numbers? I believe it was exhibits. I didn't even print them because it's literally 50 through 68. No. Well, the total number of exhibits were petitioners' exhibits 50 through 68. I kind of took your question to ask about the ones that were 1,900 pages. Do we have those numbers? Oh. If you're wondering why that young man behind me looks a lot like me, it's because it's my 34-year-old son, Peter.
Well, 54 is 378.
54 is 378 pages.
951.
53 is
951 pages.
951 pages.
Yeah.
And 51 is 486. And the delta between that and the 1922 is minor, but it's just some other exhibits. And so I would just respectfully ask that the tribunal, for that reason and for also my other stated reasons, continue this hearing for that reason. Thank you.
Thank you, Mr. Flood. Mr. Allison, now if you will respond.
Yeah, thank you. First of all, with regard to the due process piece of it, he's talking in his motion about the same argument you've heard before, where they complain that you can't have due process because you guys are the judges, and he says witnesses. I don't think so. But let's put aside his different view of that and my different view of that. That's the same argument that they made to the federal judge when they wanted a temporary restraining order and the federal judge denied it. That's the same argument they made to the federal judge in Galveston when they asked for the federal judge in Galveston to grant a preliminary injunction because of a failure of due process for the same reasons, made the same argument. That federal judge denied it. Then they asked that federal judge to give a permanent injunction so this hearing could never happen. Rather than rule on that, the federal judge elected to sign an order dismissing the federal case with prejudice. That means never come back again and make this complaint. That means you do not have the right to ever complain about that again in federal court. You're done. Your case is dead. Your argument is finished. They've appealed that, which everybody has a right of appeal. They've appealed that to the Fifth Circuit, United States Fifth Circuit Court of Appeals. That's in New Orleans. And they asked that court, for the same reasons, a panel of judges, federal judges at an appellate level, to stop these proceedings. Yesterday, they know that the federal judge again, that panel of judges at the Fifth Circuit said, no, we're not going to stop these proceedings. There's no reason to think there's a due process violation. So it's not just Doug Allison versus John Flood. There are several judges who have looked at this very seriously and rejected those arguments. Now, with respect to the pages, could I get this, or am I on yet? Thank you. I'll remind you, and he's right, most of these, not most, all of these documents really have been produced in the litigation for Ajit David versus the city. The depositions were taken in the case of Ajit David versus the city, okay? The documents that he's complaining about, oh, I can't be ready, you just heard him, I can't be ready because I have all these documents to read. I know you know this, but you'll recall that discovery was stopped in that case in January of 2025, okay, because they filed a mandamus to the 13th Court of Appeals. And remember, they're all happy. They call it a win. It's just a delay. They're all happy. The mayor
Lincoln
was
0887, Paul Victor Lincoln 0887, you'll go first.
She's hiding. And so all of these documents, these thousands of pages of documents that they're talking about, were developed in a case before January of 2021.
Just letting you know that
at a point in time when the mayor was a party to the litigation and always had access to all of these documents, most of which were produced by the city of Corpus Christi. And her lawyers, and John Flood is one of her lawyers in that litigation, has had access to all of those documents always. He came in later, but always in that litigation. Now, I extend courtesies, and so when this started getting scheduled, this matter, you'll see on the screen, and I'll make sure it's a part of the court's record. I say those things naturally. It's the court to me, sorry. On the screen, you will see, as soon as Mr. Flood, and this started getting pressed, this impeachment proceeding, on hold on 1 second there. I thought I saw May date or July.
Go ahead.
Pardon? May. Yeah.
1403.
I'll get it right.
6053. Again, that's 1403 6053.
I don't know why it's not there, but it's May. I have it right here.
At the chief at work. Don't go run it off. Gotta help me. I know. We're up. Thank you. On May 20th of 2006, I sent him as a
13 deal coming back to Tracy Kinsel. She is eligible and clear. LP is going to be a 2017 Mercedes 4-door. It is current clear and insurance is confirmed.
Sir, can you speak into your microphone? Sorry.
Pardon?
Can you speak into the microphone, please?
Thank you.
Sorry. Thank you.
This email shows that on May 20, 2026, Kim Brunkenhofer works for my office, sent a letter to Mr. Flood, said, Dear John, per Mr. Allison's instructions, below is a Dropbox link with discovery from the city and QOF, referring to the case, along with the transcript of all depositions taken in the case. Everything he's complaining about he's had for months. When you click on it, cleverly named David, meaning Ajit David, Docs for Flood, meaning John Flood. When you click on the link,
You can see 4 folders: depositions, discovery, exhibits, videos. And you can see when you click on the deposition link, he was provided the deposition way back in May, not yesterday, not the day before. It's okay. He was given He was given depositions of Alan Wilson, Everett Roy, Heather Holbert, Mike Culbertson, Paulette Guajardo, Peter Zanoni, Philip Ramirez, Roland Barrera, and Sony Purnell. He was also, if you click on the discovery file, he was given, if you click on their 2 sub-files, and sub-files, you can see the production, all the different documents filed relating to the city. You can see all the different documents that he's complaining he's saying he didn't get for the mayor. You can see all the different documents produced by Intervenor QOF. He was also given, because we had been ordering and numbering exhibits, he was given an exhibit file that had all of the exhibits that had been marked by DAA, that's me, all of the other exhibits, all of the exhibits to the official transcripts, and all of the exhibits with transcripts. Okay. And he was given also the videos. In fact, there's just several sub-files you can see in the video file. And the point is very they keep asking and asking and asking for something that the federal judge has told them they're not entitled to. And they keep not telling you the truth about things, like trying to make you believe that we gave them documents for the first time. They have had a tremendous opportunity to prepare for this. You all know that you initially tried to set this hearing within, I think, 45 days, and they objected, and then you extended the date to, I think, set it about 60 days out. This is a matter that has been going on for well over a year, with the mayor having been a party and having full access to all of the information. So respectfully, we would ask that the motion be denied. And I'll get that and mark it as just an exhibit to this motion for continuance hearing, what I just presented.
Mr. Flood, would you like to offer a response?
Yes, thank you. So the conflation of a lawsuit against the city brought by Mr. Allison's client, Mr. David, which seeks declaratory judgment that was filed, I believe, in 2004 and has its own separate track. The conflation of that proceeding with this proceeding presents this council with a big problem. And that is what he is suggesting, is that the provision of process in that matter is sufficient for the provision of process in this matter. And that is a legal concept with no basis. In this matter, this proceeding, my client stands to run the risk within a charter provision at the city level in this conflicted tribunal. She received 1,922 new pages of documents this proceeding. It cannot be that due process is going to be based upon some sort of argument that there was a provision of materials from some other proceeding.
Texas,
This
Tom
proceeding
William Lincoln 4549, Tom William
is
Lincoln
presumably going to
4549.
receive evidence. That evidence needs to be provided in such a manner that the respondent has an opportunity to review it and respond. I haven't even looked at those exhibits because it would have been impossible to do so. I don't have the duty to go try and see if it matches up with something from another case. That's a different case. It's not this case. This case is different. It's not the same proceeding. And so, for that reason, I needed to receive something like that well in advance of a proceeding like this, so that under the Constitution, we would have time to review it. This was not a choice my client made. This was a choice that the petitioners made, and that was to provide this volume of evidence on the eve of a removal proceeding. And so we would simply ask for a continuance of the proceeding on that ground. Thank you.
24175837 against 24175837.
Ms. Jackson, do you have a response or any further comment?
I mean, my only additional response would be, I guess he's abandoning his earlier argument that he didn't have them. I mean, it's pretty convenient.
I have no idea whether these documents, I'm hearing a representation, but without any sort of opportunity to review them, I have no idea whether they are or not. That's the whole point. They weren't provided in this proceeding timely.
Okay, thank you, gentlemen. Does this panel, have you received your copy of this motion? Yes. Okay, then at this time, I see there's a comment, but I would like to recommend denial of the request for continuance because I believe a remedy is in striking.
And clear. LK is going to be
striking the added
2024 Honda van. Expired December of 25, December of 25. Vehicle clear, insurance is confirmed.
Christi, thank you.
My apologies while we cleared that up. Then with our legal recommendation, it'd be a motion to deny that continuance, but I will take comments from this board first. Mr. Scott, you can go first.
Thank you, Madam Chair. So I guess a question and a comment. What is our, so you're working your way through it, and I think we're all working our way through it. I didn't know if we're going to deliberate that request here or go into closed session and listen to our legal counsel. It would seem to me that what happens, so my comment is to protect the integrity of the process. If people are watching, like, yeah, it makes sense. You shouldn't submit something. I'm not a lawyer, right? And I avoid court at all times, to the best of my ability. That something submitted the day before a hearing is probably not a bad look, not a good look. Sorry, I think it's a bad optics, and it affects the integrity of the process. But it would simply, the answer would, I think, would be to eliminate the exhibits and move forward, or provide some time for council to review said exhibits. We're here for 2 days, so I thought the answer would be just to either provide the continuance or remove the exhibits submitted yesterday, because it eliminates the issue if we don't. So that's my position is, and I'm okay with just eliminating the exhibits, because it would seem to me if they should have been submitted all at the same time or in the same general time frame, because I just think it's bad optics. So my position would be to either grant a continuance or deny if we can, the exhibits submitted yesterday.
Thank you, Mr. Scott. Did I hear a motion from this side?
28 Frank Robert Henry 236 expire April 2019.
To deny the continuance. Okay. Mr. Hernandez, you have a comment?
Douglas Hager, Black and Color Registers for Michael David Smith out of
most of this information has been out there for a long time, and we're just continuing to delay the process, and I don't think that we need to continue to delay. We were originally going to do a 30-day thing, and we extended it to 45.
X-ray Charles Lincoln 5449. X-ray Charles Lincoln 5449.
So I think we should continue. Thank you.
Okay, we have a motion on the second and a second on the floor. Do we need to take a voice vote, Ms. Rebecca? Okay. Then all in favor of the motion, say aye. Aye. Any opposed, say nay.
Nay.
Thank you. Then to commence the hearing, we will have announcements from the parties. First from legal counsel for the petitioners, and then from legal counsel for the mayor.
Douglas Allison, Your Honor, presiding. We're ready.
John Flood, counsel for the respondent, for the reasons previously stated, not ready.
And for opposing counsel?
For 7.01 Frank Nora Henry King 36, also expired July 27, 2016, Gooseneck. Brian Cole registered for Corpus on
Excuse me. Apologies.
No, you're fine.
Do the petitioners wish to offer exhibits into evidence? It's my understanding, Mr. Alexander,
That I have exhibits?
Yes.
I do, and just for the record, I submitted most of my exhibits about 2 months ago, and I think I got their exhibits probably a few days ago, and all that's still ready. If it facilitates things, I will tell you all, the presiding and members, we get better at that. We're here obviously committed to transparency and full disclosure of all information. And with that in mind, we do not have any objections to any of their exhibits so that the public can have a full public hearing. And we do have a motion. We filed it way back 2 months ago, and then we recently supplemented it with the additional exhibits. And we do have a motion with the appropriate affidavit following the city rules of procedures that you guys adopted, I think, June 2nd. Following that protocol and having an affidavit to prove up those proposed exhibits or those pieces of evidence that have been presented by us. And those are exhibit numbers 1 through 68. And we would offer those at this time because they are supported by an appropriate affidavit and that is specifically what the city rules adopted on June 2nd ask for. So we would offer those exhibits at this time.
Thank you. Mr. Flood, are there any objections?
Yes, sure. Yes. And
if you could state those at this time.
Respondent objects to admission of exhibits. And I do have to state that the repeated inference that the insistence of due process is somehow repugnant is something I need to level an objection to on behalf of the 14th Amendment and on behalf of our people. The fact that the respondent in this situation is insisting and objecting is not something that should be weaponized and tried to use against her. It should be respected with all due respect. And so she does have objections to the evidence, and I'm going to continue to object to the evidence because that's what she should do, what I should do.
124, I'm going to be checking with you, King.
And so petitioner's exhibits, Exhibit 32, is an email from Mr. Ajit David. And plaintiff's objection to Exhibit 32 is a hearsay objection. This tribunal's rules strictly prohibit the admission of hearsay evidence. And this email is an out-of-court statement offered for the truth of the matter, inserted, including his own opinions regarding this project, this competing hotel project, FEMA, and the incentive application. The email also consists largely of his own personal opinions, conclusions, and speculation regarding fraud and FEMA requirements, economic development policy, developers' notice. That sort of hearsay is not reliable evidence. It's simply his out-of-court accusations, opinions, theories about what he believed was occurring. And that is the type of hearsay evidence that is not admissible, and so we object to Exhibit 32. And request a ruling sustaining that objection.
Specific objections to all the exhibits that he wants to, so you can take them all as a group.
Mr.
Yes, and I'm sorry. Thank you. I do have one more objection that I needed to have leveled already. I didn't realize it, and Ms. Cantu, who's been with me for 25 years, handed me a note. The affidavit referenced by counsel a moment ago, purporting to substantiate the authentication of their exhibits, only cover number 1 through 45. They do not cover the numerous exhibits provided after that. So that would be another objection that I would ask the tribunal to specifically rule on, and that is any exhibits after 46 or after 45 lack foundation.
Mr. Flood, I'm going to request at this time if you will list your objections to all exhibits so that we can handle them at this time.
That's fine. Happy to do that. So that last objection was a global objection. It's based on a lack of foundation, and those are from 46 through 68. So I just went over, and the record will reflect an objection made on Exhibit 32. The next objection will apply to Exhibits 34, 57, and 58. This is an audio recording made by Mr. Ajit David, and I think 57 is a redundant copy, and then I believe 58 is a transcript of that. The objection to this is also hearsay. According to this court's procedures, hearsay is not admissible. This recording is an out-of-court statement offered to prove the truth of the matters asserted in it, including that there was tampering, a scheme, a narrative, and these other alleged misconduct. And Mr. Zanoni's statements do not fall within any hearsay exclusion or exception applicable to this proceeding. And also, within the hearsay rules, and those are found in 801, 802, 803, 804, and 805 of the Texas Rules of Evidence. 805 is a rule against having hearsay embedded within other hearsay. And we also object to Exhibits 34, 57, and 58 for that reason, because there is multiple hearsay embedded within the hearsay in those exhibits. For example, Mike Culbertson said, somebody told me today, references to what the applicant said. The recordings also contain lay opinion, which is also inadmissible opinions, and it contains a bunch of speculation. So for those reasons, we would ask that the objections to Exhibits 34, 57, and 58 be sustained. And I am a little reticent about not asking for a specific ruling on each one of these objections at the time. I'm sure your counsel, Judge Shamsey, understands that. So I am going to request it with full knowledge that I understand that you're not going to grant it at that time. So I'm going to request a ruling on the objections already made. Having heard no ruling, I'll move on. Exhibit 36. This is a exhibit that's been submitted by the petitioners. It is a email from September 2025. It's simply incomplete. It does not contain all of the information that was provided in the email from Mr. Risley, and so it's therefore misleading. And request an objection on that. Respondent has actually submitted the entire email, and so I would simply request that exhibit, the objection to that exhibit, be sustained. Exhibit 39 and 40 are statutes or penal code provisions. One is the forgery statute, the other is the criminal party liability. That they're simply not evidence. That's law, and so we would object to them as they state what the law is. They're not relevant or admissible, and requested a ruling on those exhibits. Exhibit 43. I'll skip 43. The next one are exhibits 46 through 48. These are the Facebook posts by my client, and my objection is that as evidence in this matter, those are the epitome of pure political speech. They consist of criticism of elected officials, discussion of government procedure, commentary on public affairs, explanation, and advocacy directed to constituents. Those are at the core of First Amendment protections, and they don't have anything to do with what happened in 2024, which is what the articles of impeachment have to do with. They concern what the mayor has said publicly after these removal proceedings have begun. And whether you disagree or agree with her opinions, they don't tend to prove or disprove any allegations in the articles. And so they're not relevant, and I ask that the objection to those be sustained. Exhibits 51, 53, and 54, as I've stated previously, are the incredibly voluminous exhibits. The continuance has been denied, and so I would ask that those exhibits be excluded. 51 is 486 pages, 53 is 951, and 54 is 378 pages, and it's just been impossible for me to look at them, so I just ask that those that an objection to those be sustained. Because I can't even, under the 14th Amendment, have an ability to look at them yet.
2430-1899-2430.
And without waiving my objection to the failure to grant a continuance based on the late filed exhibits, and subject to my earlier objection that there has been no foundation laid for exhibits 46 through 68 from an authenticity standpoint. Exhibit 63, it appears to be a text message between Peter Zanoni and I don't know who. It lacks foundation, and so I would reject it on that basis. Also, Exhibit 68 is a spreadsheet of phone logs that also lacks foundation, so there's no reliability under what we call Rule 1006, which is a compilation rule. Petitioners have not established that this is a complete compilation rather than a selective one, and without that showing the exhibit risks a distorted picture of the communications. I'm going to request that each of those exhibit objections be addressed individually and ruled on specifically on the record, either being granted or sustained by the presiding officer or tribunal. Thank you.
Thank you, Mr. Flood. If I can ask Mr. Allison for a response.
Thank you. I'm going to try to do this in a way that helps us keep organized. So bear with me. With regard to Exhibit 36, I think I understand he's saying mine is incomplete and he has a complete exhibit. And if he has a complete exhibit, I don't have any problem withdrawing my current exhibit number 36 and substituting his exhibit 36, so long as no information, it's not less information is my understanding of what he's representing. So in other words, I think we can resolve that one without a ruling, but rather resolve that one by agreement. Okay? Happy to have the entire document. With regard to, I'm going to try to start, you're going to see the trend here, I'm going to try to start on things that maybe we can agree to make the contested issues less or fewer. With regard to petitioners' exhibits 39 and 40, I actually think he's right that the correct way to handle them is to not put them into evidence. Those are the penal code statutes. So I'll withdraw my request to put them into evidence, which is what he's objecting to. I want to be very clear that is not me saying that I don't get to use them during the trial. The proper way to use a statute like that, I believe, is to present it to the witness at the time, and you don't actually usually place it into evidence. So I think he's right that we don't put it into evidence, but I want to be very clear that doesn't mean you're not going to hear us talk about it. You will. It doesn't mean we're not going to present it to a witness. We will. And so, at least for right now, we're agreeing not to place it into evidence on exhibits 39 and 40. So those, I'm withdrawing those so we don't have to fight about them right now. I'm withdrawing them as exhibits to be admitted. Okay?
Keep scrolling down here. 46 and 47 and 48. Again, I think those are exhibits that I get to use in cross-examination with the mayor, and I will do that at the appropriate time and reserve my right to offer them as exhibits at that time. But to get us moving along, right now I'll withdraw the offer of 46, 47, and 48. Again, making it very clear to you all, that doesn't mean we're not going to see them. I'm reserving that right. 51 and 53 and 54. Those are ones that I think we provided to him, but I'm going to double check that in May of 2026. They are voluminous. I think they're repetitive of shorter exhibits that were given to him well in advance. That are the key documents. We may or may not need to fight about what's in the larger documents. I sort of put them there to make sure the record ends up being complete. But at this time, I'll withdraw the offer of 51, 53, and 54. So we don't have to fight about it right now. Again, subject to my right to bring it up later if they become something that's contested or in dispute. That leaves us with a much fewer number of exhibits that I think we need to deal with right now that I am going to continue to offer along with my original offer of all of my exhibits subject to what I've just said or explained. And so let me go through those that I want to respond to. And what I'm about to say is actually true for several of the exhibits. Several of the exhibits, like Exhibit 32, that is put into the record not for the truth of the matter, but are put into the record for the purpose of Ajit David, any citizen, any resident, but it was Ajit David, giving written notice to the city, to Peter Zanoni, that I see a problem here. It's very clear at that time Ajit doesn't fully know the extent or the severity or the seriousness of the problem, so it's really not offered for what we call the truth of the matter. It is offered for the purpose of showing that Peter Zanoni and the city were given notice of what we thought was maybe, at that time, I think Ajit thought it was maybe been tampered with or altered. And so that is a clear exception to the hearsay rule, and 32 should be.
Tom, Mary, Paul, 32062.
That is
Tom,
true
Mary,
of
Paul,
Exhibit 34.
32062.
So I'll make
If
it
you can run it, I'm going to call you.
234, and it is
I'm going to call you
properly
because
at this time. That is also true for Exhibits 57 and 58, so those are properly admitted at this time.
124, returning traffic, warning issue.
At this time, I'll withdraw Exhibit 63, just because I don't remember what it is, but I'm going to reserve the right to offer it later.
Also, you can show the Taggart code for
it's 63, so I'll withdraw it so we don't have to address it now. And then Exhibit number 68 is admissible under Rule 1006. He referred to it. It is a summary of voluminous records. Lawyers do this all the time, and so it is ordinarily appropriate, and it is an admissible form of evidence. And just so you know, all of the underlying data, which means phone records from Devin Bacta and Philip Ramirez, those documents have been provided to them. They have the source data. And Exhibit 68 is nothing more than a summary of those documents, with the exception of, I think the only thing not summarized is the number of phone calls between Philip and Devin.
In other words, it shows the phone calls between either Devin and Philip and Mayor or Heather or Peter or Leo Lavari and Culbertson and Randy Ogmeyer. And so that is properly admissible, and 68 should be admitted. So I hope I've helped in terms of narrowing the scope of what we need to do. But for those that I am standing on and have offered a reply, we think all of the exhibits, except the ones that I've withdrawn right now, and should be admitted.
Thank you.
Brief reply.
Mr. Allison, if you could provide a response as to not providing the affidavit to supply exhibits number
Thank you.
46 through 68.
We supplemented it yesterday. We'd been trying to get everything. I think he gave me his exhibits 2 days ago, and I supplemented mine yesterday. But there's a new affidavit. If you hadn't seen it, I know that it got filed. Yeah, it's of record. So we have followed the protocol with regard to all 68 of the proposed exhibits. Is that true? Yeah.
This morning. My cell phone is off. I haven't looked at it. So I'm not aware of that.
Yeah, they were supplementing. I did too.
We're seeing traffic.
Okay, thank you. Mr. Flood, do you have any responses to that?
I'd like to get a copy of whatever that was just handed out. I don't have a copy of that.
You have an.
Oh, great, thank you. So, subject to receiving that, I can address whatever it is that's being handed out. I'm not even certain what it is. I do have some specific responses to the specific exhibits that council just referred to. I've received something called Petitioner's Amended Motion to Admit Exhibits filed. It says filed July 21, 26. My objection to the amended motion and mirror the motion for continuance filed, and so it would simply be that these are new documents. I'm reviewing them for the first time. Did I receive an email this morning?
Some were sent out yesterday, and I think one this morning. I couldn't.
It would appear that so my objection to the petitioner's amended motion and amended exhibits in the affidavit of Douglas Allison is simply based on surprise because I haven't even had a chance to look at them, and so that's my objection. I'd ask that it be rolled on specifically. I do want to get back to the exhibits, if we can. I'd like that's my response to the materials I was just handed, which are petitioner's amended motion to admit exhibits and the affidavit of Douglas Allison. Simply because I haven't had an opportunity to look at those, and so I would simply make an objection under due process grounds, lack of opportunity.
I'll be in Poker Grande.
Exhibit 32. This is the Ajit David email. Council suggested that it's not being offered for the truth, which is what the way around the hearsay. There is another objection, however, that was not addressed, and that is relevance. These are simply Mr. David's out-of-court accusations, opinions, theories about what he believed was occurring, and so it's just simply not relevant. And so that was another one of our respondents' objections. The other exhibits 34, 57, and 58 are the audio recordings of the calls with David. The not offered for the truth of the matter response to a hearsay objection does not meet the objection under Rule 805, and that is that the recording contains hearsay within hearsay. And so that objection it stands, and requests that it be sustained. I believe that, well, and Exhibit 68, subject to our motion for continuance and complaints therein, that is the spreadsheet. It just simply doesn't have any indicia in and of itself of reliability. I understand the point of a summary under 1006, but it does have to be accompanied by testimony that creates reliability. I understand that the argument may be made that it's contained within Mr. Allison's affidavit. And all it says is that it is a spreadsheet. It does not that it is a representation of the materials. So you have to file an objection. Request that all of those objections just made, Exhibits 32, 34, 57, 58. And to the summary Exhibit 68, which I believe are the ones that survive the withdrawals by petitioner, and that still have objections. I request that the objections to all those be sustained. Thank you.
Mayor Pro Tem, I'm sorry, just to clarify, so Exhibit 033, 2026, that was sent this morning at 9 a.m., but the other two, 011.1 and 034, were sent yesterday, just for the record.
Thank you, Ms. Rebecca.
And for the record, I apologize. Am I supposed to say point of order? I'm not sure. I want to make sure the record reflects that we do have objections to the depositions. Since they were marked as exhibits, I want to make sure the record's clear that, this is something that we're going to cover. Respondent filed objections to exhibits 1, 2, 4, 5, 6, and 7, which are all the depositions except for my clients. And so I just want to make sure the record reflects that at this point I'm not waiving those and specifically want to be heard. And this is something that was discussed with counsel, your counsel and opposing counsel prior to. So I just looked down and I want to make sure the record's clear in that regard. Thank you.
I was going to help on note taking too, if it helps. I was going to run through the list with you. I'm guessing that's what you're doing to make sure which numbers. You want me to call them out?
Yes.
The ones that I'm still offering and that I think should be admitted at this time is 1 through, I think it's 35. We're going to substitute 36 by agreement. And then I'm still offering 37 and 38 and withdrawing 39 and 40 at this time, subject to later use. And then I'm still offering at this time exhibits 41 through 45, which they've not objected to. And for this time, subject to being able to use it later, I'm withdrawing offers of 46, 47, and 48. So they don't need to be admitted. I'm not asking for that right now. And then 49 and 50, I think they're not objecting to. And then 51 and 53 and 54, those are the ones he complained were voluminous. So to facilitate things, I said I'll withdraw them at this time, may use them later. 52 still offered and not objected to. And then exhibit numbers 55 and 56 has subparts. All of those are still offered. And 57 and 58 are still offered, and I've offered an exception to the hearsay rule for them. And then 59 through 62 are not objected to. 63 I've withdrawn. 64 through 67 are not objected to. And 68 I still stand on the offer because a summary of voluminous records is correctly admissible. So we'd all of
From
those
62
at this
and
time.
63, could you repeat that list one more time? We're trying to take notes, go a little
I'm
bit
sorry.
fast.
Yeah, I wanted to go through it because I do know it's important to make sure the list is correct.
I
And this
appreciate
time
that.
I'm going to just say the ones I'm still offering.
Thank
Okay?
you.
And that would be 1 through 35. And then still going to offer 36 subject to it being modified by agreement. So we're still offering it. Still offering 37 and 38. Still offering 41 through 45. Still offering 49 and 50. Still offering 52. Still offering 55 and 56, and I'll say 56 has 5 subparts. Still offering 57 through 62 and 64 through 68.
Do I need to restate the numbers of my objections? It's easy.
200 block away.
Sure, thank you.
270 Victor Lincoln Henry. 5443.
The petitioner exhibits objected to,
201.
as stated previously, all of which are incorporated. Are exhibit 32, 34.
10-4, you got
Again, these are petitioner's exhibits. 32,
10-4. Time you copy our name and public service number.
58,
Stand by.
36, subject to it being substituted.
Back in the county.
68, and I specifically request of the tribunal a ruling on those objections.
124. Can you show me 10-6?
Well, 61, something out. 1261, 10-4.
And I do have one additional objection to all the exhibits, which is a global objection to the exhibits. Thank you.
Six
632.
Do you have pending calls in auto?
10-4, one pending call.
No.
Okay, I'm going to entertain a motion to accept or deny the exhibits listed through sections 1 through 49. We will discuss those first. And I have Councilmember Hernandez.
Okay, based on what's agreed upon here so far, except items 1 through 35, substitute item number 36, except number 37, 38, 41 through 45, and number 49.
May I level that objection I referred to a moment ago? Thank you. Respondent objects to the admission of all the exhibits because their relevance and significance concern disputed facts within the personal knowledge of the members of this tribunal who are acting as adjudicators despite being material witnesses. So I would object to the petitioner's documentary evidence in the form of the exhibits for that reason, in addition, and ask that that objection also be addressed. Thank you.
Well, that has to be from her.
And when I say addressed, I mean ruled upon. Thank you. May I be heard? My understanding is the motion.
I called twice, unable to leave a voicemail.
And the mayor has filed objections specifically, separately, in a motion to exclude. And so, and that has not been heard. I have not had an opportunity to have that heard.
And
Okay, we'll reserve and address that request for motion after this one that's here. There's been a motion, but before we address that motion, I would like the panel to approve or deny the request for motion on their.
This is RV Park. He says that once you enter, you'll see him right when you enter. He's outside.
Is the motion to admit?
Is
that where we are? The motion was to admit 35, substitute number 36, number 37, number 38, 41 through 45, and 49 and 50. I'm sorry, just 49. It was to admit 1 through 35, 1 through 35, substitute 36, one provided by Mr. Flood. Also admit 37, 38, 41 through 45, and number 49. 41 to 45, and then what was the last one? 49. Thank you. Apologize.
So the filed with the city secretary prior to this hearing was Respondent Mayor Guajardo's Texas Rule of Evidence 804 objection, and objection to hearsay replete within petitioner's exhibits 1, 2, 4, 5, 6, and 7, and a motion to exclude those depositions. And so because the motion would attempt to bypass that motion that's been previously filed before this hearing, I simply have to object to that motion on that. And I don't know if I have the right to object to that motion, but for purposes of my record, I definitely need to make sure that that motion is entertained and heard separate and apart from the discussion we just had about specific objections that I had to 32, et cetera. And so I just want to make sure we're not this isn't some attempt to frog leap over that motion that was filed. Thank you.
To exclude his pleadings specifically on the deposition.
Okay, since we have this motion and second, but on items 1 through 49, is there a motion to clarify on the request for items 1, 2, 4, 5, 6, and 7?
I do have a question on that. And this maybe could just be answered by Mr. Shamsi. Is sworn testimony considered hearsay?
Mr. Hernandez, if we can get the agreements in, and then we can address questions on those different motions.
Okay, so the ones that he wants to remove, the sworn testimony,
yes, sir.
Exhibits 1, 2,
4, 5, 6, and
5, 6, 7. So we want to remove those from that 1 to 35 and listen to those separately.
If that's the will of your motion for a motion clarification.
If that's a recommendation from Mr. Shamsi, then I'll amend that motion to address those separately.
Thank you. So your motion stands for 1 through 49 with special exception to 1, 2, 4, 5, 6, and 7. And we have a motion and second. I have one more discussion. We'll hear. Okay. All right. Then we'll take a voice vote. All in favor, say aye.
Aye.
All opposed, nay. Okay, the motion carries.
45.000 megahertz. Elevation 35.5 degrees.
Okay. Before.
Mayor President, just for the record, so it wasn't 1 through 49, right? It was 1 through 35, 36 by agreement, 37 through 38, 41 through 45, 49, and then excluding 1, 2, 4, 5, 6, and 7, right?
Yes.
Okay, thank you.
Thank you, Rebecca. Before we return to those items in that section, we'll move on to items 50 through 68 and discuss those. Mr. Flood, if you could explain for us again your objections to that section of exhibits. Again, 50 through 68.
Sure. Those were provided yesterday, and those are they are the topic of the motion for continuance that the tribunal has already denied, and those were contained the multiple pages. My understanding is 51, 53, and 54 have been withdrawn, as well as 63. And so the surviving objection, obviously subject to my global objection, which is that I object to admission of any of the exhibits because their relevance and significance concern disputed facts within the personal knowledge of members of this tribunal who are acting as adjudicators despite being material witnesses. That would be Exhibit 68, which is the summary exhibit, which is the objection is a lack of foundation. And those have already been addressed. We've already addressed those by argument.
Thank you, Mr. Flood. Is there a motion to admit or deny?
Make a motion to admit items number 50, 52, 55 through 56, 57 through 62, and 64 through 68.
Second. We have a motion and a second. If all in favor say aye.
Aye.
Any opposed?
Nay.
The motion carries. Returned. Okay, there's a motion to exclude
Still for veteran service. No, you have a senior neighbor picking up.
before us. Mr. Hernandez, did you have a comment?
No.
Okay. On Mr. Flood's motion to exclude items 1, 2, 4, 5, 6, and 7. Do we have a motion?
No. May I be heard?
I apologize. Thank you. Yes.
Thank you. So this is an important point, and that is that this proceeding is not the same proceeding in which depositions were taken. In fact, it was the opinion of counsel for witnesses subpoenaed for deposition in this proceeding that depositions are not part of the proceedings in this case. So there are no depositions that were taken in this proceeding. There has been no sworn testimony taken in this proceeding yet. The depositions that were taken in 2025 were taken in a lawsuit filed by a local hotel operator seeking a declaratory judgment that an ordinance, in layman's terms, was passed improperly and should not be enforceable. In that proceeding, pending in Texas State Court, there were depositions taken. The last deposition in that case was taken in September of 2025, or August of September, one of those dates, before a petition under Article 2, Section 11 of the Charter was ever filed. So there is no argument, factually or legally, that the depositions were taken in this proceeding. They are the depositions of Peter Zanoni, Exhibit 1, Heather Hurlbert, Exhibit 2, Exhibit 4, Philip Ramirez, Exhibit 5, Mike Culbertson, Exhibit 6, Alan Wilson, and Petitioner's Exhibit 7, Sonny Purnell. Respondent objects to those exhibits and the admission of the testimony contained therein prior to the receipt of any evidence in this case. This tribunal specifically adopted the Texas Rules of Evidence regarding hearsay for good reason. Hearsay is unreliable. It's not good evidence, and you shouldn't base any decision on it. Deposition testimony is addressed within the Rules of Evidence in Rule 804 regarding hearsay. And 804 applies when a declarant is unavailable. In other words, the declarant means the witness. In this case, there's been no showing that the declarants are unavailable. The witnesses are available, by all accounts. Therefore, under this tribunal's own rules, when it adopted the rules regarding hearsay, these depositions became inadmissible. So we specifically object to the admission of the depositions based on Rule 805. Also, and you can see this in my motion, there's an attachment, several attachments that address Rule 805, which is also a hearsay rule. And that's the rule about hearsay within hearsay, which is even worse from a probative standpoint. So rather than eliciting each witness's personal knowledge, the counsel in those depositions, which was Mr. David's counsel, not petitioner's counsel, repeatedly read from or played other witnesses' depositions, recordings, emails, text messages, letters. So there's just tons of what we call hearsay within hearsay embedded within Exhibits 1, 2, 4, 5, 6, and 7, the depositions I just referred to. In addition, to the extent that is testimony from witnesses that's going to be attempted to be admitted in this matter, respondent objects that that testimony is being received and evaluated by tribunal members who themselves possess firsthand knowledge of the same disputed facts and are potential witnesses regarding, are witnesses regarding those exact same matters. That objection is based on due process, fundamental fairness, and the prohibition against a witness serving as the adjudicator of disputed facts. And so, hearsay, whether in a deposition or elsewhere, is not reliable, trustworthy, and of the type commonly relied upon. And this tribunal, knowing that, issued a rule that said hearsay shall not be admissible, whether it's in a deposition or elsewhere. And hearsay is hearsay. It doesn't matter what vessel it arrives to you in. I suspect the petitioner is going to argue, well, I was in a deposition, and we said by the rules we can use depositions. Well, that doesn't fix it. It's still hearsay. And so, and by your same rules, you said depositions are permitted in this proceeding, yet no depositions were allowed to be taken. So, by your own rules, hearsay is not admissible. These depositions under 804 are hearsay, and so I respectfully ask that you enforce your own rule and sustain that objection to 1, 2, or sustain all of those objections to 1, 2, 4, 5, 6, and 7, and exclude, affirmatively by motion, exclude those exhibits as evidence in this matter. Thank you.
Thank you, Mr. Flood. Mr. Allison?
Yes. The argument that he's making is a technical argument if you were in a court of law about how you treat a deposition if you're in one court of law versus another court of law. That's what that rule was written for, and if you look at the rule he cites, it says the court can do this, and the court can do that, and the court can do this. So it's actually not written for this circumstance in any way, shape, or form, nor do your city charter rules in any way, shape, or form support his argument. And I will point out, I think it's incredibly important that you hear the starting point for agreement. We agree that the test for admissibility at the end of the day, what hearsay is all about when people are arguing about hearsay, is the testimony reliable and is it trustworthy? Okay? And the reason it would be admissible and thought of in any other court, and this one, is because it's reliable and it's trustworthy, it's under oath, and it was taken in front of the attorneys for the city who had an opportunity to cross-examine and question it if they wanted to question its reliability and trustworthiness. And at those same depositions, there was also an attorney for the mayor who had the ability to ask any questions if they wanted to call into question the trustworthiness or the reliability of it.
Mr. Allison, I'm sorry to interrupt you. Could you put the microphone where you're hearing? Yes, sir, that we're having trouble hearing you. Sorry.
And so given that and that's really the test for whether or not you want to exclude evidence, if you were in a court of law, that's the test, and that's what the hearsay rules are designed to do, is to test for trustworthiness and reliability. And I'll submit to you, if it's admissible in a court of law, it should be admissible here in this front of this city council proceeding.
Specifically, though, I also want to point out to you, because you all passed, amended, and just real candidly, I offered proposed amendments to expressly allow these exact depositions to be used in front of you for this proceeding. Those were some of the revisions I proposed. They objected. You guys ruled and made specific provisions for allowing depositions to be utilized, period. And he's trying to confuse you. Let me use his fancy word, conflate. He's trying to conflate discovery and depositions. Yes, they tried to do pre-hearing discovery, and that is not allowed by the rules. That's why we did not take the depositions of several people who were noticed to have their deposition taken. That would have been discovery. That would have opened up the can of worms where we would have been here weeks or months. Who knows? Okay? That is not the same as whether or not, that's not the same question. Just because those depositions, that has nothing to do with the fact that you guys expressly passed rules on June 2nd that said exactly and specifically that depositions can be utilized. And everybody knew what those depositions were because you remember I gave them back to them on May 20th. Okay? And so that rule, see if I can find it here, states that all testimony, live or by deposition, shall be presented under oath. It all goes on to say that the oath has to be administered by somebody who's qualified to administer an oath in the state of Texas. That's the trustworthy and reliability piece of it. That allows, that express provision in your rules was done for the purpose of using these exact depositions and was passed by you. So you've already said you can use depositions, and you can use those depositions. We've already had that fight. What he's doing then is he's going back to and it's listed in your rules as a general rule about hearsay. He's going back to your general rule and saying, well, I want to apply the general rule, not your specific rule that you passed for depositions. And legally, his argument is completely flawed, and let me tell you why. There's a Texas Government Code 311.026. Very important. All lawyers know it. Everyone lives by it. Judges live by it. If there's a general rule that says you can't do it, and if there's a specific rule, like you guys passed a specific rule expressly saying you could use depositions testimony so long as they have been sworn by somebody qualified to administer the oath, if there's a general rule and a specific rule, Texas Government Code 311.026 specifically says if a conflict, this is a rule of what we call a rule of construction. This is how we're legally supposed to construe something when you have a general rule that says, oh, don't use hearsay, and then you have a specific rule that says you can use the depositions so long as they're sworn. Okay? When you have that situation, 311.026 says if the conflict between the general provision and the special or local provision is irreconcilable, in other words, this kind of says that and that one says this, the special or local provision, not the general one, prevails as an exception to the general rule. In other words, Texas law tells us over and over again in case law, this is statutory law in the government code, we get told over and over and over again that if there's a specific rule, it takes precedence over the general rule. It's treated as, quote, an exception to the general rule. Here you all very clearly in the rules, and we
Arlene Rodriguez, 361-207-5824.
And we argued about it, and you guys modified the rules on June 2nd and expressly allowed the depositions to be used. So, I think very clearly, when you look at you all's rules that you passed, when you look at Texas law, when you look at even the rules of hearsay, because we know that rule is really designed from one court to another, which doesn't apply here, that particular rule that you're referring to. All of those things tell us that, of course, you should be able to use the depositions that have been taken under oath when counsel for the mayor, counsel for the city, and counsel for Mr. David were present. All interested parties were represented. Finally, and this is probably the most important thing, to be candid with you, one thing we always know as lawyers, and it's common sense to you, is that when we try to figure out what all these rules mean, we're supposed to consider public policy because we want to do things that are for the right reason, for the good of the public. Okay, that is essential. I've heard you several times talk about transparency, and I know you know the importance of that. This is an issue where now they're trying to, at the 11th hour, say you can't use the depositions that 2 months ago or on June 2nd, everybody voted and said you could use, okay? And so if you want to know how to reconcile sort of this conflict of how he reads the rules and how I think you clearly meant for the depositions to be used because you put it in a specific rule, to reconcile that, one of the things you should always fall back on is public policy. Public policy says be transparent. Public policy lets us know that sworn judicial proceeding is normally regarded as trustworthy and reliable. And public policy, therefore, supports the use of these depositions. Obviously, it's critical. He's trying to just throw out the whole case is what he's trying to do, and no surprise, we've seen a lot of objections, so thank you.
Thank you, Mr. Allison. If I can hear if there's a final response from Mr. Flood.
Yeah, that public policy is exactly why it's not admissible. That public policy of confrontation, and we lawyers use the word confrontation, and that is that testimony that's gleaned within a proceeding where there's a certain teed up parties and confrontation, you provide, there's a certain amount of respect for that evidence that comes from that. My client was not being removed in those proceedings. She was a defendant in a declaratory judgment action related to an ordinance. She was represented along with the city by the same lawyer in many of those depositions. So the whole idea that depositions from that proceeding can be admissible in another proceeding with different fact issues, very different legal concerns, very different sources of the allegations, very different consequences, is why it's hearsay. That's why it's hearsay. And so it's not admissible under hearsay rules because it's deposition testimony. 804 speaks to it very specifically. And nothing counsel just said changes the equation that these are not hearsay. They remain hearsay. And so they are not admissible under your own rules. And the reality is, there's nothing in the rules that say that it was these depositions. If he's right, then I can bring in depositions from divorce cases or from some other case that has nothing to do with this, if that's true. Because there is nothing in there that says that. And this is why we objected at the beginning from moving from the Mendez rules, and I'm referring to the 1987 rules, which said nothing about bringing in testimony from some other proceeding. In that proceeding, live witnesses testified, and that's what should happen. Different defenses than this one. And so, proceeding under your own rules and enforcing your own rule regarding hearsay, I would submit to you that the only discretion you have is to exclude 1, 2, 4, 5, 6, and 7. And I would specifically request that petitioner's objections, her general objection for that reason be granted, and that her motion to exclude be granted. And I do have, obviously, conditional objections that have been made within my motion in the event that they are admitted and they attempt to be
public service, 76 over 2, Crossroads RV, Payson, Kenny Lane.
But at this point, I'm asking
for this follow-up.
My client's got 4 objection.
Thank you.
Thank you, Mr. Flood.
Okay, well, I would like to make a motion to go ahead and accept these sworn test.
You can make 10, 6, and 19.
We have a motion, a second, to accept the depositions. All in favor say aye. Oh, I'm sorry.
I just wanted to remind the body that, for the record, I voted against the amendments on June 2nd. One of the reasons I voted against the amendments on June 2nd is I thought they lacked transparency. We didn't go through the list of proposed changes to our proceedings, and I thought that lacked transparency. My sense is you can remedy the depositions by having live witnesses.
649, show me that is 203
but I'm
South Bowie.
intend to support allowing these to come in, and it's consistent with my position in the second, where I voted against the changes to the process. Thank you.
Thank you.
They call back. You can point to me off the base juices.
Yeah, please.
Hello.
Okay. I know we have a motion and a second. Before we preside over that, Mr. Allison, have you provided cuts from your deposition exhibits to the...
He is on 710 returning your call.
Mr. Flood, have you received those cuts?
We provided them, and then I actually thought they were time stamps. And then he said, those aren't page in line. And then my legal assistant chimed in and said, no, Mr. Flood and I are both wrong. They are page in line. But we did those deposition cuts, which is typical. And I'm going to back up even. I'm the one who 2 months ago asked for a scheduling order, and they didn't want one. Okay? Normally you do cuts maybe a week ahead of time. There was no order or scheduling order for us, so they can be done anytime. We did them over the last 2 days, 2.5 days, and we gave them to him yesterday. And, that's as soon as I got them, I flipped them to him. Because we had to turn them over actually to a videographer who actually did the cuts. The cuts came from the videographer after we send everything into him, and he does the deposition cuts. He provides us that information, and we send it immediately to him.
How many cuts did you provide?
I'm not sure quite what you're asking. I'm going to say there's 4 depositions that we cut. 4 or 5? 4?
I don't recall, but the answer is there's hundreds of cuts, or I should say hundreds. There's many, many cuts. A cut being a deposition is edited and so you're clipping page and line excerpts. So there were many, and they were provided last evening. And I, frankly, have not had an opportunity to review them, but my staff worked late into the night trying to see what those cuts are. Yes. And we of course, object to all of that for the reasons stated.
And I will say, I also offered, because he's entitled to do his cuts, and he can put them on now or later, and that would be true in a courtroom setting too. He can do his cuts whenever he wants to.
I chose to sleep last evening.
Me too.
You had that subject we were looking for earlier to this one subject called Signite.
Christi.
The specific answer to the question was 5 deposition cuts at 5:06 p.m. Central Daylight Time.
There you go.
Thank you.
I'm sitting down here on Houston, right at Cleveland. Yeah, he'll be in a gray shirt, black shorts, black shoes, and a ball cap.
28.6 degrees.
One 14 Senate.
All right. Do
Thank you.
whoever authored that motion, was that Sylvia?
I think it's her motion.
I imagine
there she is.
I'm waiting for her to return.
Thank you.
I have a question real quick. Ms. Sylvia, with your motion that you have on the floor, I am requesting for your consideration to modify your motion.
It's a silver SUV with a handicap plate, and it's going to have a large sticker on the
subject to the defendant's right to review his objection at the time offered.
I agree.
You agree to the amendment?
I don't understand that. You mean to review the cuts and offer counter cuts?
And offer, renew his objection at the time that they're offered.
Oh, okay. To renew his objections. Okay. Offer subject to his right to further object to it.
Thank you. And you're amenable to the amendment?
Go ahead and skip up on that.
So we have a motion and second on the floor?
Without amendment.
With the amendment.
Okay, they're going to be going north on
She's made a motion to
Cleveland
accept
towards the Donut Palace.
the exhibits of depositions with the admittance being subject to allowing the defendant their right to renew their objection at the time it's being offered.
May I ask for clarification?
Yes, sir.
Hurry, traffic.
The exhibits are 1, 2, sorry, I have the wrong one in front of me, as stated.
1, 2, 4, 5, and 6.
Yes, and 7. And those have been moved for admitted in mass. In other words, they're the entire depositions. And so that's the motion, is to admit the entire depositions, not cuts. The cuts are the subject of what I anticipated would have been informed would be submitted online. And so I think we want to make sure that the record is clear that this objection is to the depositions in their entirety, and I'm asking that that objection under Rule 804 and as stated in my motion, my objections and motion, be ruled upon. The issue of what is specifically submitted during this hearing, separately from the exhibits being admitted, is a different issue. And I think that's what that may be what is attempting to be addressed. I do have in my motion a separate listing of objections that are exhibits that you saw, and those are 805 objections, which are hearsay within hearsay. And those objections I intend, having received the cuts, I intend to interrupt, unfortunately.
But I had a lot of wind.
For all the
Can you
objections,
repeat
but
that
that's,
last place for me?
my job. I will be interrupting those to object.
10 Frank Lloyd Williams. 10 Frank Lloyd Williams.
During the objection. So we have those cuts. Those objections will happen, and I don't need to dictate how the tribunal handles it, but I think a safer matter might be to simply address the objection I have to all of the exhibits. That's a global objection, which is based both on the due process grounds I stated earlier, as well as that contained within my objection and motion to exclude. And then as far as the cuts go, those will be addressed. They're contained within my motion, but those will be addressed at the time that the deposition testimony is actually offered during this proceeding.
Thank you, Mr. Flood. Yes, Mr. Allison.
Yeah, and I just want to be very clear also. And the idea that he'll be interrupting and making objections is how we do it in court, so that's not a shocker to me. Okay, lawyers stand up and object, and I understand he has that right, and you're specifically
I have
giving
no idea who
him
the female
making,
is. And is McLean going to be the male?
The motion has been clarified so that he has that right at the time of the presentation. Okay, but I still think now that that's all clarified, that he gets to do that, and he gets to interrupt, and he's already intended to do that. I think the motion and the motion as amended now takes care of that, which is the motion is to allow it subject to allowing him to make those objections at the appropriate time. And we would ask that that motion be voted on.
Did we give you that plate?
Yes, sir.
Just for clarity, I just need to make sure that my motion to exclude
Because I got the plate. Coming back expiring June 26, June 26, 2017 Chevy Traverse to and Cedar Steinhardt out of
regard to page and line cuts, that's a separate issue. That assumes they're admitted at all. And so I do need to ask the tribunal to please address my motion, which is a motion to exclude all of them under Rule 804 and this tribunal's own procedural rules. Thank you.
Except now what he's asking you to do is, I guess, not do your motions. He wants you to change your motion, and that's just not really quite how city council, I think, works. You made a motion, you have a second. It addresses his motion. It implicitly says his motion is denied as modified, and it's sufficient. So I ask that we follow the city process that you guys have already been doing.
Thank you. We have a motion and a second as amended. All in favor say aye. Aye. All opposed say nay. The motion carries. Thank you.
Go ahead.
I would specifically request then a ruling on my client's Ashmore, Tom, Exhibit 1, 2, 8, 5, 6, 7, 4, for the reasons included in the motion exclude Rule 804 and others, and also because these are exhibits and purported testimony, I object because their relevance and significance concern disputed facts within the personal knowledge of members of this tribunal who are acting as adjudicators despite being material witnesses. So I'm going to, just for the record, have to continue pressing my issue on my motion exclude under 804 because at the risk of that prior motion not addressing it. Thank you.
My response is simple. You've already addressed the 804 portion of it and given him a right to object when we're playing the clips, so that's done. And the rest of his comment there, we're going back to, federal judges already ruled and we get to continue and you guys get to be the
presiding and members of the council pursuant to city charter. Federal judges already supported your ability to do that, and so I honestly don't think there's any more. I think he's clarified his objection, and he's made it noted for the record. I think the only thing to do now probably is to note the objection, but I don't think there needs to be another motion.
Thank you, Mr. Allison. Mr. Flood, does the mayor wish to offer exhibits into evidence at this time?
We have filed a motion to admit, and I believe what I heard counsel for petitioners say is that they have no objection. Petitioners' exhibits are petitioner, my apologies. Respondents' exhibits are exhibits 1
429 to 412
through 47. I'm sorry, 1 through 47. We have filed a motion, and
we're trying to work out right now with
mayor's exhibits
email whether or not we're going to run it off.
Respondents' exhibits 1 through 47 be admitted.
Thank you, Mr. Flood. Mr. Allison, are there any objections?
There's no objection, and I'm only going to note that the site time savings, I hope, is paid back at some small point at the opening remarks.
Steiner,
Then if you have objections, then the exhibits are admitted into evidence. Would anyone like to make a motion on this panel to admit these exhibits into evidence? Motions, exhibits 1 through 47.
Respondents' exhibits 1 through 47.
Thank you. We have a motion. Do we have a second? We have a motion and a second. All in favor, say aye. Aye. Any opposed? Say nay. Okay. The motions carry. We will now have opening statements. Opening statements will be limited to 30 minutes each. First, we will have opening statements from the petitioner and then from the mayor. Mr. Allison, please proceed with your opening statement.
May I proceed?
Yes, sir.
And I am in just a minute going to need access. Not quite yet. Thank you. Give you a heads up there. Welcome a little bit, I guess, to our world. We move slow. Justice is slow, but it's a fabulous process, okay? And I do want to start by kind of highlighting something because, and I've said this a million times to judges, I don't want to do anything on the record that jeopardizes due process. I don't want to do anything that jeopardizes these proceedings. We are here in good faith, and we are here to present a case on why the mayor ought to be impeached, okay, on its absolute merit. And that process requires time. And again, it's tough because it's cumbersome. The law is cumbersome to deliver justice. And I want to kind of remind you of this, and that is we see impeachments all the time, right? We see them at the not all the time, but we see them at the federal level. We see them at the state level. We see them in other counties. We see where different people are removed from time to time. And we probably know most about it in the context of a federal or a state impeachment where the House impeaches, and then it's a two-step process, and then the Senate convicts or removes the president. We had a proceeding similar to that in our Texas legislature not too long ago, and it's usually in those cases, and I think it's important for you to realize, so I bring it up at the outset. In those cases, there's two bodies, right? There's the House and the Senate at the state level and at the federal level. We don't have two bodies here. So we actually do it a little differently. We follow your charter, and it says shall, and you have followed that. You all have already adopted the articles, which is the impeachment. She's been impeached, the mayor has. And then this part of it is the evidentiary proceeding to see what consequence that has in terms of removal or other consequence. Okay? And it's a slow process, but it's obviously an important one. And it's important to realize exactly what you should be. And the whole purpose of an opening statement is to give you all an idea of how to listen for evidence. And let me say it this way. If I give you a jigsaw puzzle and I put the pieces face up, it's easier for you to put it together. If I make you put that jigsaw puzzle together with the pieces face down, it's harder for you to put together. And so the whole purpose of opening statement is to give you an idea of what evidence you'll hear, so you'll be able to pluck the important evidence as it relates to the very issues you'll be deciding. And the very issues you're going to be deciding is put forth in your charter. And that is, should the mayor be removed because of, quote, misconduct, malfeasance, incompetence, inability, or willful neglect in the performance of her official duties. Did she do any one of those things can be a basis for removal. Simply put, mayor was the city's leadership through a corrupt process that resulted in the award of $2 million. I think we all, it is, and there was some public comment talking about character, talking about integrity, and our public processes deserve more than to hand out this kind of tax, this amount of taxpayer money, when there was a alteration, which is a corruption by definition, absolutely a corruption of a federal document, and misleading statements made that are, by express contract terms, reasons for default, which you have already found. The misleading statements made by the applicant QOF and their altering of a federal document that either from beginning to end or certainly by March of 2024, the mayor knew. All of the evidence is the mayor knew. And I'm going to detail that in just a minute in more detail. But what we need to be so careful of, and I want to say this, if I say it once, bless you, that's not what I'm going to say 1,000 times. But if I say it once, I should say it 1,000 times, because this is really where we are as a community. And I hate to say it, we're probably there nationally and at a state level, and we're wrestling with it. And all we can do is take care of it at a community level. Because what we tolerate is what I want to say over and over. What we tolerate, we become. Think about that. If we say it is okay to alter federal documents and come get taxpayer money, it is the worst signal that we are available to be corrupted. What we tolerate, we become. I want you to also, and so I want to say this, rest assured the process is a good process. The federal court denied the request for temporary restraining order. Federal court denied their request for preliminary injunction. The federal court dismissed their lawsuit, and you and I both know they're out on the radio shouting that they won. And every legal maneuver they've taken has been denied. They even went, you realize the only place left for them to go is the United States Supreme Court. The Fifth Circuit, United States Fifth Circuit,
we have a here between me and
has already denied the request for injunctive relief. The process is good. What are we not here for? And I think this is, again, something so important. We are not here to decide whether or not there was, in fact, a crime. That's Peter Zanoni's word that he used beginning back in April of 2024. Not my word, not Ajit David's word. But it's not what we're here to decide. This is an impeachment proceeding that will talk about whether or not the mayor is guilty of misconduct, malfeasance, incompetence, inability, or willful neglect of her performance of official duties. I'm quoting. So when anybody stands up and says, oh, there's no crime, so what? I think there was, but that's just my opinion. Peter Zanoni called it a crime. That was his opinion. Heather Hulbert has said it violates forgery statute, and Peter agrees. That's their opinion under oath. But we're not here to decide it. So let us not get sidetracked on that. We all know that O.J. Simpson knows, even if you don't get convicted in criminal court, it doesn't mean they won't find some responsibility, right? We are not here to decide whether or not the downtown project is a good project. I've lived here all my life. I like the project. I'm glad they're building downtown. I want it to be successful. What I'm certain of is that is a completely different question than whether or not the processes to get the $2 million were corrupt. It's not about whether or not we want the project. The project, I think it's good to develop downtown. I don't have any problem saying that. But you absolutely have to separate that from the certainty that forging, tampering with a federal writing is the correct word, screenshot. Tampering with it can never be acceptable, and the mayor's promotion of it after she knew that has to be a violation of her official duties. If she says, quite frankly, oh, how could I have known the truth is so many people told her, so if she wants to really say, I didn't understand it, she's incompetent, which is grounds for removal. But I think it's more likely that it's misconduct and malfeasance and willful neglect on her part. She willfully neglected her duties, which is a basis, according to that's the term in the charter. She willfully neglected her duties in order for her friends to get the grant. Now, we are not here, okay, to debate the issues that continually get raised by, I'll use somebody else's term now, the puppets on social media, okay? Don't get me wrong, there are some social media posts of the mayors that I think I put on the exhibit list because if she wants to say things inconsistent, I have a right to impeach her with her public statements. But we're not here, I mean, one could argue birds of a feather, but I mean, Tunches, we're not here to talk about the Chronica and what he says is true or not. I mean, his rap sheet is long, distinguished. These are the mayor's defenders, Adrian Garza, Tito, Dolcefino, Susie Luna. I mean, we need to base what we do here today not on the rhetoric you're going to hear while these proceedings are going on. We know some of those are pay for play, if not all of them. We're not here to listen to that. We're here to base a decision not on what those spokespersons for the mayor say, but based upon the evidence that brought here. We're not here to attack Ajit David or any of the petitioners. And we're not supposed to be here to attack you. So anybody that gets on the social media and starts attacking has completely missed the focus of these proceedings. And they do it to intimidate, and they do it to control, and they do it to manipulate. But we have got to stay steady and realize that the purpose of being here is to evaluate whether or not there's 4 articles of impeachment, any or all of those apply for the mayor's removal, for the willful neglect, for the malfeasance, for the misconduct, for the incompetence she's shown to allow this to go through the process, even though it was well exposed as a altered and tampered and forged document. We are here to decide, because all of those things in the charter, I think, can be summed up in one way. And again, I appreciate the public comment. Some people think she has good character and they're entitled to their opinion, and you guys get to be the judge of whether or not she is a good public service by what she did in this particular instance. Because a good public servant, I went ahead and Googled to see what it said. A good public servant is someone who serves the public with integrity. There's no integrity in what happened. Fairness, dedication, and a continuous desire to learn and improve society. It's not about self-promotion. Never was supposed to be. And I know we've drifted too far from that in terms of how we define or what we allow in public service. And so I will tell you, so I don't forget later, and I will remember later. I thank all of you for your service. I thank all of you for being here, because I know they've been attacking. And it shouldn't be, you're not supposed to attack the victims. And that's what's happened, is they've turned it into just a counterattack instead of, it's in these very chambers that she called out from the dais. My client, Ajit David in the back, said, he's the reason we're here. We're here because documents were forged and altered and tampered. And because even after the mayor found out, she insisted that the matter be approved. Turning a blind eye to that sort of corruption is misconduct. You can argue about whether or not it is felonious and requires criminal prosecution, but it's certainly, by definition, you're not supposed to lie to the type people, you're not supposed to alter a document, and when you find out, you're not supposed to say pass it anyway. That's the corruption of the process that the mayor allowed and encouraged. Now, if I could have you switch this on. Again, I know it takes a little while to go through this, but it saves us time, because what I now get to do is go through some exhibits. Again, so when they come up, you'll be familiar with them. I started with this exhibit because we all know the phrase that the buck stops here. When you are and the mayor is, as presiding, when the buck stops here, it stops with the presiding officer. And that would be true, the mayor. She would be responsible even if Peter had done it without telling her. Even if Heather had done it without telling her. Even if Type B had done everything without telling her. If there's a corruption of process, the buck stops with the mayor. Because if she didn't know about it, it's her own time and it's her own incompetence. We all know she boasts being a full-time mayor. That means she has full-time responsibility. But of course, that's not our facts. We know that she did know about the corruption of the process and still encouraged it. In terms of that corruption, I want to certainly give you detail. I think, and these are all exhibits, and I believe all have been admitted, the FEMA rules that Mayor and QOF claimed were changed and new rules, quote, newly defined. They claimed newly defined in 2023 and 2024. Those rules were published in October 9, 2020. We know that because they were published by FEMA in October of 2020. We know it again because in February of 2021, and we all know FEMA moves like at a glacial pace. In February of 2021, they said you can comment on them. And then in April of 2022, we know that they publish this website page and information in order to say that they become final and in effect on October 13 of 2022. All of this happened years before the project, the QOF project was even imagined, according to their own slides. The QOF project was imagined July of 2022. So the whole FEMA process had already come to conclusion before they even imagined their project. Nonetheless, QOF put it, and I want to be real clear here, this is not just a one-off where somebody misspoke, okay? There is a constant barrage of misinformation that the mayor supported. It started back with CCREDC, okay? And in that application, they said, quote, newly defined FEMA AE flood zone that encompasses
Senate Council on that second 59 for one block of cemetery.
Substantial unexpected infrastructure costs to the project which were not expected on the onset of the project. They had already been finally passed before the onset of the project. That is a false narrative. That is untrue. It started with the CCREDC after Mike Colbert said, don't get any money unless you add an infrastructure feature to the project. So back in mid-2023, September of 2023, applicant knew, and I think there's 120 phone calls in the key period between either applicant and Peter or mayor, or most of them are there. 50 of them are with the mayor. I mean, there was clear ongoing communication even early on, but we know for certain later the mayor nonetheless knew about the fraud and decided she was going to still support the project, knowing that it had found its origins completely in fraud. But in September of 2023, here's the certification, applicant certified. But we know that the slide that they used in the middle over here, we know that slide is where they removed the dates, because the dates, if you look over here on the left side, this is their slide with my modifications on it. Their slide said project was reimagined in July 2022 as a 126-room hotel project. And we know if you leave the April date there, it doesn't make any sense to say we're surprised, because it was sent to you before you even imagined the project. So they removed the date. How did they do that? This is the actual slide, okay? And this was sent by the applicant to CCREDC, and it was used in the presentation to the Type B board. You remember a minute ago, let me see if I can get it back up here. Here's how it should have looked. You see the April date, you see the release number, and you see the second time when the release date is printed. And again, the release date does not fit their timeline. That's clearly why they removed it. Because when you look at the actual slide, here's what they did. By the way, this was then sent as a PDF, and what you can do is then you convert it back to a PowerPoint, and when you do that, you can see the changes that Philip Ramirez says he made. And those changes are the text box right here, and behind it, you can see the release date and other information, but a text box was obviously, according to CCPD and everybody who's looked at it except for Philip, intentionally modified to conceal the date. You'll notice that the text box, before I opened it up and moved it, fits exactly over the date and the information they wanted to conceal. And you'll see down below there's a second text box that conceals the date being repeated a second time. Now, I'm no wizard. Maybe Philip Ramirez can do it in fewer strokes, but the way I know how to do this, and we did it in his deposition, you'll see that, is that
Attention. Satellite scope and reading now overhead at 2,276.500 megahertz. Elevation 17.1 degrees.
I'm only proving to you how bad I am at this. By the way, whenever I go to this slide, I always click Don't Save so that I don't mess it up in its original form. Okay? So I'm going to Don't Save. It's Exhibit 19 in the materials you have. It's the second slide. There it is. To do what they did, what the applicant did, you see where you go to the text box, or this is one way to do it. You go to text box, you click it. Look, for example, this section up here, that's one click, by the way. And then I have to define what I want to conceal. You see how I'm dragging the box over everything, that top bar? And then I create the box, or I have to position the box over what I want to conceal. Then I have to.
Entry information, Citizen Fire in 901 South Bay Street. Change it to burn alarm.
I'm going to choose white because when you make it white, everything that is supposed to be on the slide now is concealed behind the white text box, and then you click and you're out of it. What that is 5 strokes on the keyboard for one text box to be specifically dropped on the date and reference number, and then 5 more intentional strokes on the section of this slide down below where the April date is concealed a second time. These 2 text boxes that I'm showing you right now. The only person in the world who says it was a formatting error and accidental, of course, is Philip Ramirez, who said, I did it. And my suspicion is it's probably because he really told other people at his office to do it, so he can't expect them to say it was accidental. But what we know is that they intentionally dropped those text boxes on those pieces of information with a design to fulfilling what Mike Culbertson said was a must if you're ever going to get any recommendation out of CC or EDC. And he will testify to that. So then what you're going to see in the evidence is
because I'm not sure if I keyed up on the right channel. I have fire route 901 South Bay Street. Maybe it is a burglar alarm, sending a virus by smoke. Just in case, if I'm going to use it.
That is malfeasance, that is misconduct. That is neglect, willful neglect of her duties. That is not being a public servant who is protecting the taxpayer dollar. When you trace through the information, some of these I'll go through quickly, but when you trace through the information, you'll see that in October of 2023, it says the grant
back in the county
associated to newly defined 8E flood zone requirements. The lie got repeated by CC or EDC. I've already shown you that the lie was promised or certified by Philip Ramirez. The lie then was also repeated in November 8. It's not like it was a one-off, where it says the grant will be utilized for additional costs associated to newly defined FEMA flood zone requirements. Newly defined, they were 3 years old by this point in time. Additional documents show, this one is the November 9 board meeting, and they presented, and at this board meeting, it is the mayor herself who, and these are important points. This is my writing here where it says violations. The mayor weighed in at this meeting, you can see on this document, and supported a $2 million award. How is that a neglect of her duty? One, remember, you pay CCPD to tell you what the award should be, and they said at most, assuming there's an infrastructure component, which there was not, at most you can give $1,043,000. But the mayor said, no, let's violate that rule. Let's neglect my duty, and we're going to award $2 million. That's one way that she interfered with the process and got outside the process, outside her official duties. Another way is we know that any award would violate the requirement for infrastructure, but she did it anyway. She used her weight of office for that. And we also know, because we have the emails from the applicant, and they say, well, if we don't give you the award, what will we... Are you going to still come? What's it going to do to the project? And they get a response back that says, well, it's going to take us longer to do the rooftop bar and the finish out. It wasn't even, the emails, they knew it wasn't even infrastructure that it was going to really be used for. And they knew that the project was already committed, and already committed projects are not supposed to get incentive money. So the mayor led the charge through this meeting to try to get $2 million. You'll see by reading it, it failed, and then it got renewed in Type B. So it fails there, and it actually gets a recommendation for $1,040,000. That was a Brian Gully move. Okay, it's in the notes. And while she is attending the confidential meeting, think about this. While she's attending a meeting, she's sworn in her official duties. She's there as mayor. She's promised confidentiality. What is she doing? She's texting Devin. What's the assume she means economic impact of the hotel? In EDC meeting, talking about your $2 million ask, she tells Devin, this is Paulette, work phone. I have it. Devin responds, thanks for looking out for us. It's confidential. That is a breach of a neglect of her duty. So then it goes on, and we know that the slide is created in this window, and then it goes back in front of the Type B Port Corporation. And what do they say? It's a grant of $2 million to be, even though CCPD had trimmed it back to $1 million, now it goes miraculously back to $2 million to be utilized for additional costs associated with newly defined, should have said 3-year-old. We knew about them before, and they were final before we even imagined the project. But it says the grant will be in for costs associated to newly defined FEMA flood zone requirements. That's how it started. Is that my 30? Oh my gosh, how time flies. I apologize. If I may just wrap up with 1 minute. Okay. You'll see that as it progressed to City Council, we know that it was exposed by Ajit David. We know that Peter, in his recorded statement, when he admitted, says it was a scheme, and it was that way from the beginning. We know that Ajit David stood here and told the mayor face-to-face on April 16th, stood here and told the mayor face-to-face on April 23rd, and that her own legal department told her, and that Peter Zanoni told her, don't do it, and she pushed for it anyway. All neglected of her duty. Thank you.
Thank you, Mr. Allison. Mr. Yes, we'll give Mr. Flood time to set up for his opening statement while you have 5. If
Stretch.
you'd like. Yes, sir. 5-minute recess.
649.
Colin 49.
10-4, the owner of 203 South Bowie is back home if you want to make your way back over there.
10-4, thank you.
Six 32.
Okay.
One Sunrise Beach, make contact with Monica Soklo. She'll be an employee there at the office. It's going to be in reference to an 18-year being one of their fines.
For what location again?
Sunrise Beach at the office.
So. $143, be connect for TM Park.
Yes, sir. Site 10. I'll be out at Granajo Housing Authority, Unit 40 for a follow-up. So,
$645, Tuesday.
645 for the 4th.
Attention. Satellite gliding 1A now over NF2. Attention. Satellite Yagan 30 now over NF 2245.5 megahertz. Elevation 30.0 degrees.
649, 2 minutes. For Blue Year Base.
10-4.
Six 48. Get out of the office.
Attention. Satellite gliding 1A is now overhead at 2,252.500 meters. Elevation 60.2 degrees.
Hey.
So, if you ever preside and you're like, oh, no, there's somebody in there. Somebody has to.
And they're really smooth.
Six 28, 1041. Connect.
Hey, 4.
Attention. Satellite KH-12 is now overhead at 2,262.500 megahertz. Elevation 19.0 degrees.
Okay, welcome back, everyone. Mr. Flood, if you would please proceed with your opening statement.
Rebecca, yes. If I may, I'd like to make some remarks prior to my attorney making his remarks this morning, opening remarks. So I'd like to address everyone. Today is a day I never believed that the people of Corpus Christi would have to witness. Disagreement is not the issue before us today. Disagreement is essential. It's an essential part of public service. Every elected official who has served this city has disagreed with colleagues. That is healthy. It's expected. It's democracy. What should never become routine is the use of extraordinary governmental powers in a manner that causes the public to question whether political disagreement has crossed into something far more serious. I stand before you today as the duly elected mayor of Corpus Christi, chosen by the people to serve this community. This office belongs to every citizen who exercised their right to vote and placed their faith in the integrity of our democratic process. It is about the precedent that we establish for every mayor who will one day serve this city, every future city council, and ultimately every citizen who expects their government to exercise its authority with absolute fairness and integrity. History has a way of placing moments like this into their proper perspective. Years from now, people may not remember every ordinance we passed, every budget we adopted, or every disagreement that occurred on this dais. But they will remember whether this council strengthened the public's confidence in our institution or whether it diminished it. This hearing and the outcome will be indelibly imprinted in the history of the city. Throughout my service, I have made difficult decisions. I have taken positions that were not always popular because I believe that they were in the best interest of the people of Corpus Christi. Reasonable people can disagree with those decisions. That is the very foundation of representative government. Ultimately, all of our decisions are judged by the people of Corpus Christi at the ballot box. There is, however, a profound difference between political disagreement and the exercise of extraordinary governmental power. That distinction exists to protect the integrity of public office. It exists to protect the confidence and the rights of the people we serve. And it should never become blurred. It is about whether the citizens of Corpus Christi can continue to believe that their votes matter, that our institutions are guided by principle rather than politics, and that public authority can exercise with fairness, impartiality, and respect. My commitment has always been to serve this city with integrity. I worked hard and served with great honor. I respect the trust that the people have placed in me over 5 straight elections. My commitment to the city of Corpus Christi remains as strong today as it was the day I first took office. The office of the mayor belongs to the people. It does not belong to politics. It belongs to the public trust. And now my lawyer will give you his opening remarks.
Thank you.
Thank you.
Today, and through this proceeding, you all are not sitting in your political position. You're sitting as judges of the evidence. That's a big task, and it's different. You have to take off whatever hat you wear up there normally, and you got to squint those eyes and look at the evidence in a different way than you would normally, the way you would normally do your job up there. Because this is a different job that you've been signed up for here. And what you do is you rely only on the evidence. That's it. And what is evidence and what isn't? You know what isn't is speculation. Speculation's not evidence. It's none. It's zero. It deserves nothing. Assuming is not evidence. That's a nothing. Presuming, not evidence. When deciding the evidence in this case, and I'm not going to make argument about what the evidence, what you should feel about the evidence right now. I'm not going to do that. I'm not going to incorporate any assumptions. What I'm going to ask you to do is to understand that at the end, there must be evidence of the things that are alleged in these articles. It has to be, the conclusions that you're asked to draw have to be more than assumptions. They have to be more than speculation. It has to be evidence at the end that you have seen. Okay? That's what you do when you're judges of evidence. And what the evidence is going to show is this hotel, this project, my client liked it. He liked it. In fact, I think everybody likes it. She always liked it. Liked it first time she heard about it. Her goal was revitalization of downtown. That's a great goal. Nobody disagrees with that one. Her focus was the project, not the people involved in it. That's a huge distinction. Now, you've heard all kinds of stuff about FEMA and fraud and alterations and forgery and crime. What you're going to hear is my client left all of that to the experts. And that's what you should do. And I submit that's what happened. Again, she felt in 2023 that it was good. 33B, and by the time this incentive arrived at this place, actually it was over at the RTA building, on February 20th, staff came and told her that FEMA was the reason. Okay. And she and others voted in favor of it. And when I say FEMA, I'm just saying in a very general sense. I'm not getting into the details there. And then you'll learn that Leah Olivari at the Type B board saw a Channel 3 story saying that was the reason. And she reached out by email on March 1st to city staff and said, whoa, what are you doing? That's not why we approved this. How did that ever even get up here? And Ms. Campos and Mr. Hernandez remember, Everett Roy, by the time April 23rd's over here, he chastised staff for allowing that to happen. So the Type B board, the staff said February 20th, the reason was FEMA. Type B comes, Leah Olivari comes forward and says, no, that had nothing to do with it. And there's an investigation that happens, rightfully so. And it gets back to this dice on April 23rd, and the reason is revitalization, which was actually the reason why the Type B board approved it, not FEMA. And the slide issue, which we just heard a lot about, was under investigation. The EDC, like I said, supported this project. You've heard about the meeting at the EDC. The EDC RIMS analysis says that this is a $1,043,000 benefit. Bart Brazelton moves to approve the $2 million. That fails. 3 people voted in favor of it, 6 against. And then there was a motion for the full $2 million, and that passed. And so then, I'm sorry, I apologize, for the $1,043,000, I had it backwards. The $2 million was the first one, the $143,000 passed. So the EDC supported it. My client voted in favor of that. And so in December 2023, when the application reaches the Type B board, the board met in executive session and decided, came out and unanimously supported the incentive due to its, quote, catalytic nature, and that would help revitalize the town. So that was December of 2023. That's when the Type B board said, we like this project, we want it to go forward. And specifically, Leah Olivari stated, quote, not because of the additional flood or FEMA or any of that, this board felt this would be a catalyst for downtown. So that's what the Type B board said. And sitting in that Type B board was City Manager Peter Zanoni, sitting over to the right. You'll see videos that we have submitted. Those videos are admitted. That was 2.5 months before the February 20 hearing, or meeting. That was 2.5 months before that February 20th meeting. And then on January 22nd, a month before the first reading of the ordinance, the Type B board is there meeting again and talking about the incentive, and they say, the reason that the board agreed this was a worthwhile project is not because of all the FEMA floodplain zone requirements and everything, but mainly we saw this as a kind of capstone project in the downtown area to spur other development. We're not interested in fixing everybody's FEMA problem. So the reason for the Type B board approval, the problem, it didn't make it here. It never made it here on that first reading. The REDC is who then interfaced with the city, and they provided the infamous slide, which was not created by my client, that's for sure. Had nothing to do with anything like that. It provided the council with the FEMA justification that was specifically rejected by the Type B board. At the February 20 meeting, the mayor relied on staff's recommendation. She already supported the project. Staff told her it was because of FEMA stuff, which was not true, and she relied on staff and supported it. Between February 20th and April 23rd, the controversy hits. The city manager investigated. April 16th, 1 week before, Councilman Hernandez, Councilwoman Campos are in an executive session with Miles Risley, and he presents, and you're going to see this. The executive session is admitted, everything, his entire PowerPoint. And I honestly don't know how many times he uses the word alleged. And you know, we're looking at this 2 years later, but you got to go back and kind of get into their minds back then. And the idea that people were publicly saying people committed a crime doesn't make sense from a potential liability standpoint. You just don't do that. I mean, you just don't. And so that's why the executive session materials, which you probably have already seen, but you'll see again as part of this trial, specifically uses the word alleged all the time. And there was no conclusion of the city manager's investigation at that point, which is kind of why he said, well, you know what, I'm not going to recommend that they pass it. I am going to, though, I'm going to agree to put it onto the agenda, and I'm going to recommend that they discuss it. In his executive session, he says, third parties alleged. They alleged. The alleged alteration. Alleged. He says it again. explained each element of this fraud scheme that's been characterized today as a conclusion, they were all described as allegations. No conclusions. And the suggestion's been made that the mayor put this on the agenda. That's not true. Mr. Zanoni's deposition makes it clear that there were council members who wanted it on the agenda. She sure wanted it on the agenda because she liked the project. Because at that point, it had been made clear about the Type B's reasoning. But you know what? Even if she had put it on the agenda, really? Misconduct to put something on an agenda for public debate? That would be misconduct if she somehow got something for doing that, but you'll never hear that. Council here and lots of other people who met with the FBI and everyone, to a person, no quid pro quo, there's nothing there. So putting something on the agenda, if that is misconduct, we've lost our way. There's no way that putting something up for public debate, having a public debate, engaging the political process, that's alleged to be some sort of form of misconduct. The council did what the staff asked to do it. They considered it. It's a hearing, that April 23rd hearing. 2 of you were there. It's all admitted as evidence already, and I asked you to consider it. A majority of the council, including the mayor, supported it for the reasons that the Type B board originally supported it. And you know who else supported it? Peter Zanoni, sitting right over here. He said, staff supports it for the reasons that the Type B board gave. Downtown revitalization. That's exactly what he said. Mr. Hernandez, you look like you're putting on those squint eyes, which is a good idea. That's what we do with the evidence. But he did. You're going to see the video. He said, we support it for the reasons of the Type B board. He just had issues with the presentation, like Councilwoman Campos said. And I really appreciated your vote because it was, I really like this project.
As long as they're in the APO going to the jail, date of birth is...
That's a perfectly good reason to vote that way. Other people who looked at it said, you know what, that's still an investigation. I don't know, I like this project.
Nick, last name
I support it. Well, based on all these that was a perfectly legitimate way to vote, and the way you voted was a perfectly legitimate way to vote too. That's called legislative discretion, and you can't be held responsible for exercising that. You can't. Then legislative immunity breaks down, and everything, all the independence that this body has, starts to break down. The mayor supported the project because she supports economic development. Article 1 and 3 ask you to speculate that she supported it because of who was involved. That's what they want you to do. They want you to speculate. That's not evidence. It's innuendo. It was the what that she supported. Does she know the who? Sure. Does she like them? Sure. Are they friends? Are they supporters? Sure. But think about that. Everything you vote for is now suspect because you know the people involved? Come on. We got to have a higher standard than that. She supported it because staff recommended it and because she supports economic development. Now, perjury. Didn't hear much about that. For good reason. The Corpus Christi Police Department, FBI, long list, did a full investigation, and that included a review of every single deposition. The conclusion that you were provided, all of you, was that The investigation included a review of all federal and state laws. And so really, in a removal proceeding under Article 2, Section 11, this body is going to be the one that decides that a criminal code violation occurred. You would be the first ones to do that. And she didn't commit perjury. She consistently testified exactly what the evidence shows, which is there were no conclusions. Every single time she was asked, she answered honestly, and that was, I never received any sort of conclusions, which was true. Being a careful witness is good. Listening to questions carefully is good. Answering carefully and candidly is good. And I use the word carefully, and if you're working off from a position of biased assumptions, you would think, oh, he said the word carefully because she needed to be careful. No, it's because she took her oath seriously. That's what perjury is about. Does the person blow off their oath, or do they really, really take it seriously? It would be a giant leap for this board, for this tribunal, to wade into those waters when the police, district attorney, they looked at the deposition, of course, we know that, and did not wade into those waters. Okay, and I'm going to not take all my time. Article 3 relates to the breach of confidentiality of the Economic Development Corporation, and that is, I think the evidence, you've already seen it, and that is a text message from a person on the board asking an applicant what the economic impact is of their project. That's the EDC's job. So the notion that a person on the board asking an applicant what the economic impact is somehow a breach of confidentiality is not valid. It's not supported. That's not a thing. It is normal. That's healthy. That was exactly what everybody at that board was trying to figure out as well. To conclude that it's somehow a violation of something just doesn't make any sense, because she's doing exactly what it is she was supposed to be doing there. The fact that the respondent says something in the fact of, thank you for taking care of us, that's not her words. She didn't say that. Again, you can't, because you're judges, you can't let your own bias assumptions step in and say, oh, yeah, well. The minute you say, oh, yeah, well, you've lost it. You've lost your role. I'm sorry, I shouldn't say lost it. I just mean you're starting to step out, and you're starting to step into the speculation and all of that they want you to engage in. There's a lot more I could say, but I think my client said it best up front. What I want to also reflect is that I really do appreciate all of the public service that all of you do. I do. I can't imagine the time and energy that you all spend on this. No, I don't mean this. I just mean this being council members. And I look forward to meeting with you again in this manner and talking about the evidence that you've heard, and to see if you got to see the evidence, and it wasn't just based on assumptions, and that it wasn't just based on, some sort of biased assumption about how you're going to take the evidence, but is it really, really, really evidence that there was some sort of desire for my client to do something other than just see this project happen? Because that's what she wanted. She liked the project. It was not about the people involved.
during with us on that 21st.
They would have to prove that that was the reason, and they can't. And so I appreciate, again, all of you, and I'm going to sit down now, and we will move on to the evidence. And I have to, I think, once again, and here, let me address something. And I said it earlier. If we were in a court of law and a lawyer made a statement to the jury talking about the other lawyer's objections and how they're trying to hide the truth, the judge would shut them down immediately. And that makes a good judge. Here's the thing. My client seeking due process isn't just for her, it's for all of us. That's what you should do. That's what anybody should do. And so I look forward to presenting the evidence in this case and seeking another time to sit down and talk to you, not sit down, stand up and talk to you about it at the end of this. I appreciate it. Thank you.
Thank you, Mr. Flood. The next portion of this hearing process would be moving into witness testimony from the petitioners, but in order to keep that slot intact, we will recess for a 30-minute lunch break at this time and then resume. Thank you.
What do you think of? What are you taking a sense of?
Transmission to Mercury 2 has stopped. Attention. Satellite Yagan 23 is now overhead at 2245.000 megahertz. Elevation 24.1 degrees.
One 33 of Lieutenant.
Number 24548 24548.
632
10-4.
And seeking another time to sit down and talk to you, not sit down, stand up and talk to you about it at the end of this. I appreciate it. Thank you.
Thank you, Mr. Flood. The next portion of this hearing process would be moving into witness testimony from the petitioners, but in order to keep that slot intact, we will recess for a 30-minute lunch break at this time and then resume. Thank you.
Hour 59.
One sit down, I'm on that public service. Oxford Northwest Boulevard for a follow-up to that. The phone call.
10-4. Speeding, four doors, sedan, red in color, speeding and driving recklessly, northbound 181, south north. No further information available.
Copy.
Transmitting to Yagan 3 on 2245.000 megahertz.
The mower's been located. It was just misplaced. One foot push only north. See if I can find that vehicle. Or it comes up on me.
Transmission to Orion 2 has stopped.
One 124. Anyone in the area? Negative. We're going for. Careful. Yeah, we're going to dispatch. Ambulance is clear. Nothing in this wheelchair. Thank you. One fatality to public service. One 24 from UTL. Any vehicle matching that description? Today.
Attention. Satellite Orion 2 is now overhead at 2245.500 MHz. Elevation 38.2 degrees.
Careful, 120.
attention. Satellite Yagan 7 is now overhead at 2245.000 megahertz. Elevation 26.9 degrees.
One time range, 25 to go one.
Tempo 648. 648. PL 1821 Baffin Drive, Portland. Six forty eight 111, I didn't advise I'll be on at Whataburger for a follow-up. Current
646 at the jail.
Careful.
Six 45 is officer.
648 today.
Transmitting to token time on 2276.500 megahertz. Transmission to token time has stopped.
A to 2801B, can you please get the ramp down? I got passengers coming.
It's already down, waiting for you.
10-4, thank you.
Code jail 1 mail to County Court number 2.
10-4.
Attention. Satellite token time is now overhead at 2276.500 megahertz. Elevation 29.6 degrees.
Stand by, 41.
Six 46 at the court.
10-4. Taxi 2801B. Have a good day. 3435, sorry.
Likewise, be safe, be careful.
Six 48. Go ahead. Yeah, at 102, coming here.
Safe, safe.
Go ahead.
I'll be back out at 14901 Northwest Boulevard.
Attention. Satellite
individual?
for unattention. Satellite Ashmore's GO3 is now overhead at 2,236.000 megahertz. Elevation 72.4 degrees.
Why do you want to leave?
Transmitting Tonics 1 on 2,276.000 megahertz. Transmission Tonics 1 has stopped.
Hold into the Looking parking lot. 2060 X-ray Frank Victor 3031 X-ray Frank Victor 3031. Looking parking lot.
Why do you want to leave?
Not to see Mr. Special Response to that. Let's go call.
Sure. Emergency rescue, raise your arms, stand tight, Sheriff 1.
Therefore.
Attention. Satellite Cosmos times 2 is now overhead at 2,252.0000 megahertz. Elevation 40.1 degrees.
159 maintain traffic.
I'll 40 out, 0 down. Please copy that. $159.
159, go ahead.
Houston, that's 5088 Bayview Boulevard. 5088 Bayview Boulevard for a suspicious person. Caller advised.
Okay.
Stepson is on location banging on the door. The caller is not at home, but wants an officer to go
We
tell
pick up
him
where
to
we left
leave.
off at witness
He's
testimony
been
for the
told not to
petitioners.
come
Mr.
back
Allison,
prior
please call
to
your
this.
first witness.
The subject's name is Tyler Tucker. Advised he's wearing a green shirt. He's broken into the residence in the past. He is known to be on narcotics in the past as well.
Simple.
114 seconds. Send the second unit to that as well.
At this time, Your Honor, we
129, I'll be attending your help.
by video deposition, and I have asked Ms. Gonzalez to be sort of the technical person to help play that.
Thank you.
$159. That subject is clear and attached. He's just not eligible. My partner is sending a photo of him to your MDC.
Yeah, I just ran him as well. $140. Be back on the team, Mark.
Temple 146. From 159, 129, we do show history with that subject. Shows he broke into that residence in January of this year, and we show a narcotics case in July of last year.
Hence the reason I don't try to do it.
That's more direct.
29, clear.
City 182, Sweet Air is at the gate.
Receive, thank you.
Attention. Satellite KX-11 cannon 3 is now over NF 2262 at 500 meters. Elevation 13.6 degrees.
If I may, before the testimony starts, I'm going to have to restate another objection. My apologies. Before the testimony starts, I'm going to restate an objection. Respondent objects that testimony is being received and evaluated by tribunal members who themselves possess firsthand knowledge of the same disputed facts and are potential witnesses regarding those matters. The objection is based on due process, fundamental fairness, and the prohibition against a witness serving as an adjudicator of disputed facts. Thank you. I request that the objection be sustained.
I'll entertain a motion to accept or deny the request.
Airport 124, where was that to?
Motion denied. Do I hear a second? All in favor say aye. Aye. The motion carries.
Thank you. And I apologize ahead of time.
I didn't vote. But I know it passed, but I thought you might want to read my vote. So that was, so he's making a motion that we deny this deposition, the deposition's witness, or go back to the charter.
No, the objection was to the calling of a witness in this tribunal, and I'm happy to restate it. Respondent objects that testimony
back window. That's where we didn't realize that.
themselves possess firsthand knowledge of the same disputed facts and are potential witnesses regarding those matters. The objection is based on due process, fundamental fairness, and the prohibition against a witness serving as the adjudicator of disputed facts.
Got it. And then the motion was made to deny, right, his motion, and I vote nay. So the motion to deny is motion.
Noted, sir.
Thank you.
Yes, sir.
Thank you, ma'am. Sorry to bother you.
Back window's going to be open.
105, I'll be sending.
Hey, lap on court. Okay, we just got an update that the circuit man taken off into the woods. $24. He's walking down to Houston. Cut through to go towards Sunset. Okay,
No, the whole video, but I think there has to be an opportunity, if there's an objection, to pause it. You'll have to stop it. Okay, so when you go in here, just so you know, we're going to where I can go review. Okay, let's do that. Okay.
Hey, I'm gonna get out here and I'm gonna walk the area. Copy. Could be under that bridge. Hey, is that your own baby? Baby in there. 29 auto. Yeah, baby on third. Baby on third.
Copy out within a baby on third. Stand by for fire unit, please. Station 2 Allegiance EMS, Station 2 Allegiance EMS, Beacon Russell 1117 Polaris, 1117 Polaris for a 93-year-old female that has pain in back, his pelvis area, is nauseated, not feeling well. Copy 129.
Sunrise is red.
Stand by 129.
Contact our PNC, is everyone in contact with us?
We're making contact.
124 was RP. Did she advise that she was home?
The female is home, the male is not.
129, I believe she may have just left. One of the white stands on top.
animation. Satellite number 2 is now over NF 2243.000 meters. Animation 20.9 degrees.
10-4-62-11.
Will you state your name, please?
Paul Michael Culbertson.
And do you understand that we are here today to take your deposition in a pending case?
Yes, sir.
And I understand that Mr. Bell is your attorney?
Yes.
Okay. And before we get into any of the details of this, I do want to get some background on this. Where did you go to, let's say, college?
I went to University of Texas.
Okay. And did you graduate from there?
Yes, I did.
And what year?
1979.
And so, did you graduate with an engineering degree?
Yes.
Did you, when you started, did you do any postgraduate work?
I did not.
Did you go into the workforce?
I joined the Navy.
And how long did you serve in the Navy?
Till 1993, so that'd be 14 years.
Thank you for your service. And in 1993, well, let me ask you this. What did you do for the Navy?
I was a carrier pilot. I flew the A6 Intruder.
And what does that mean you're doing?
That means I was flying off of carriers in attack squadron.
And after you left the Navy, what did you go do?
I went and got my MBA at University of Houston.
Okay.
And did you graduate from that? What year?
1995.
And what was it that brought you to Corpus?
My wife wanted to move back here.
Is she from here?
Yes. Corpus Christi Regional Economic Development Corporation. I started in 2009.
CCPD, that makes sense?
Yes.
And so you have been with CCREDC from about 2009 until recently?
Correct. And I'm still there.
And you're still there right now?
Yes.
For how many years were you Vice President of Compliance and doing that job?
Until 2015, so 6 years. Actually, I kept that even though in 2015 I became Chief Operating Officer.
2015?
Correct.
But then you continued in your role as VP of Compliance and Incentives also?
Correct.
And so how long did you continue in your role as VP of Compliance and Incentives?
2021.
Tell me what you were doing as a practical matter.
So I was responsible for the execution of everything in the office. So I had so people reported to me and then on to the CEO.
How long were you the COO?
I was made interim CEO in July 22, and I was made permanent CEO in April of 23.
And how would you describe the job of the CEO?
CEO is responsible for everything to the board, for the actions and execution of everything economic development in that office and in the region. And we define the region as the MSA.
All right, thanks, Rachel. Always a fluid situation on our infrastructure. Right now it's 12:15, and we're about 45 minutes away from our next intermediate advisory. But as of 10 a.m., the winds for Corpus still at 50 miles an hour, gusting.
Type B projects that come to the city. And Type B is a type of sales tax incentive, and so if somebody would like an incentive, they would come here, submit an application, and the application goes through CCREDC. We take it through our board, per guidelines, through the Type B board, and present it to the city council.
And I know that we're here to talk eventually about the downtown hotel project, whatever we want to call it. What do you refer to that as?
Homewood Suites. Homewood Suites.
And did Homewood Suites run through this type of B process? Is there some sort of a written document that lays out that process?
Yes, the Type B guidelines. They're done by Type B and approved by the City Council.
And do those Type B guidelines lay out the very, probably with more specificity, this procedure you're telling me about?
Yes.
I think the first thing you said is you all are responsible for, by you, I mean the RADC, that the RADC is responsible for receiving applications.
That's correct. After that, we run through the application complete, and we start working economic impact models using a RIMS-2 model, RIMS, and then 2 I's, RIMS-2. There are 2 different ways to do economic impact. One is RIMS and one is IMPLAN, IMPLAN. And these are accepted, used by the Bureau of Labor Statistics, and we go through that.
And I'm going to slow you down for a minute because you're ahead of me just on something that I don't understand there. Okay, you being the expert on it.
No, that's fine.
Okay, so in order to evaluate the economic impact, it sounds like you run it through 2 models?
No, just one, the RIMS-2.
And how do you,
RIMS, all caps, and in space, and in capital I, capital I.
And we call it, that looks like RIMS-2 to me, but you call it?
No, RIMS-2.
Okay, RIMS-2. Okay, got it. Okay, and RIMS-2, tell me specifically, you say you run it through that. I guess you're doing that because it is a model that probably based on whatever type of business or industry and probably a multitude of factors. This computer software is designed to help you understand the economic impact of that coming to our community.
That is correct. It gives us how much taxes, various taxes will be collected from the project. So those taxes can, obvious ones, property tax, sales tax, but also by creating jobs, those people buy things, and so we collect those sales tax. If it's a hotel, if it's a destination hotel, then we would look at HOT, which is hotel occupancy tax. And also the building permits, whatever, but those are pretty much a wash.
And all those are revenue sources?
To the city. We do it by payback and investment return. And return on investment, ROI. So payback means that, say you give $50,000 in incentives, how long will it take for the taxes generated to equal 50,000? And so that's the payback period.
And is it in RIMS-2 or somewhere else that maybe there's some guidelines for an EDC such as yours to rank what are more attractive types of businesses to bring to a community?
We have by the Type A, now Type B, we've always used a 5-year payback.
5-year payback and greater than 12% ROI?
Correct. At least 12%.
But on the private projects, your criteria for supporting it and recommending it is this 5-year payback and greater than 12% ROI.
Correct.
You're really feeding data into a computer and looking for a result.
Correct.
Okay. And that's how it's supposed to work at EDC.
Correct.
Okay, and so what I'd like to do is understand what the different data is that is inputted into RIMS. Mm-hmm. And it sounds like type of job is one.
Correct.
Is the pay scale for that job inputted?
Yes.
Is the number of jobs inputted?
Yes.
Is the type of industry inputted?
Yes.
So so far I'm just guessing good. It's not that I know. I'm just trying to think about what things would give influence economic output. Go ahead.
So capital investment, but not only capital investment, when. So when. For example, if it was a $20 million or say a $100 million project, if you had all the spending in the first year, it would be much better than have the spending over a 3-year construction period.
Makes perfect sense to me. Is CCREDC's decision to recommend or not recommend a project directed solely by its economic impact?
Yes. Now, it goes before the board, and the board can decide. But so far, it has been the impact. So far, it has just been determined by the impact.
Does that impact the room score?
So, if you were say Margaritaville, which is a destination, then we would include hotel occupancy tax because it would go up because of this. If you were just another hotel, in fact, this was the discussion we had with this one. If you're just another hotel and you realize that occupancy is even in good months, 72%, then we would not include hot.
You would not include the hot tax.
Right. And hot can be huge. I mean, it's what, 9%? You know, for whatever. So 9% of the hotel bill has 9% added on. That is Corpus Christi.
Okay. And so you're saying that you would factor in, for example, if it's a type of hotel that is a destination, will draw new people here, then that's another positive thing in the equation.
Right.
Is that considered by REMS 2, or is that something?
Yes.
Okay, so that is another data point.
Right.
1520
Briar Drive. For this one.
Okay. Homewood Suites is not a.
Yeah. It's not a destination.
It doesn't draw people. Oh, I want to go stay at a home. I want to go stay at a Homewood suite.
Yeah.
Fair enough. So then you're going to get all the data points, put them into REMS 2. You're going to get a report.
Correct.
What do we call that report?
Really, it's just the economic impact report.
When the application is in progress or completed, who does it get distributed to?
It goes to Randy, myself, and then once we have it, we have to the city manager, the assistant city manager of economic development, which is now Heather, and the mayor. And we just send them the application and said, we have received this.
So that, I would assume, means you present all applications to your board and to the Type B board.
Yes.
But is there a written guideline for Type B?
Yes.
What do we call that?
The Corpus Christi Type B Corporation Guidelines.
Okay, but there's no ranking of the type of industries that are historically better known for helping with economic development.
REMS 2 would take care of that because, for example, if you had like I said, a refinery could create 8 jobs, while a restaurant actually will create 0.6 jobs. So it takes care of that in its, when it comes back and spits out the payback and the return on investment. But no, we do not. While we have a preference, there is no preference. In REMS 2 does not see that. It just takes the investment, jobs, salary, and...
REMS is running a program.
Correct.
Okay, but you said we have a preference. Who's we?
We, the EDC.
And what is the EDC's preference?
EDC is manufacturing.
What are the parameters that you think of in terms of hotel?
Well, we would like more of a destination one, if we can. Slitterbahn comes to mind, a Margaritaville, something like that. A 4 or 5 star would be preferable to a 2-star or no star. Obviously, number of jobs has that impact. But if you had a 2-star but had a lot of jobs, it's probably worth it. So.
Okay, so kind of with the hotel, in your mind, you start thinking we'd rather have a destination hotel, we'd rather have a 4 or 5 star, right so far?
Yeah, we'd rather have that, but we just put it into rims and see that it hits those numbers.
Right, but you've been doing this a long time, so I'm already getting a sense that that you know what it has the smell test.
Right, it does.
Okay, when it walks in the door and you hear what they're doing, you go, oh, this is what I like about it, this is what I don't like about it.
All right.
Okay, what does a hotel do?
I think it's 1.3.
So it's pretty low.
Yes.
You said the preference is manufacturing. Why? What are the things that manufacturing does?
Because manufacturing actually increases the wealth of the region by exporting goods and/or services and bringing money from the outside in.
So manufacturing, for example, creates more jobs, creates higher paying jobs.
Right. And brings money from the outside.
Brings wealth to the community.
Right.
Okay. And do you look at hotels as creating higher paying jobs or not?
No.
Do you look at hotels as bringing wealth to the area?
No, not really.
Yeah, because most of the staff there are lower paying jobs.
Right.
I think I've heard a number that at a hotel like Home Suites that there is a specific number assigned or dollar amount assigned to the average wage that it's going to bring.
That's correct.
And do you remember what it is for Home Suites?
I do not.
That's around $13 sound right per hour?
It seems low.
Okay. But historically, hotels bring low-paying jobs.
Yes. Which is taken into account by RIMS too.
Right. And all we're doing here is kind of cannibalizing.
Right.
So I am sure there's a RIMS 2 report, I guess we ought to call it the Economic Development Report for the home suite projects.
That's correct.
And do you remember how it scored?
It was within the 5-year payback and at least 12% for what we recommended.
In other words, for a specific dollar amount.
Correct.
And what was that dollar amount?
For our recommendation was, and I don't know the entire one, but it was $1,043,000.
$1,043,000?
Yes.
And so did you take that to, I guess, first, when you say the recommendation, that's staff's recommendation?
Correct.
And that's after the application and after it gets put through the RIMS 2?
That's correct.
The ask was $1 million?
It was $2 million. From the project, it was $2 million.
Fair enough. Who asked?
The project, it was Philip Ramirez.
Do you remember roughly the date of the application?
It was the end of September of 23.
I want to say the Type B meeting was December of 2023. Does that sound right?
Yeah, that sounds right.
I think just before the break, we were sort of getting our timeline in terms of when it went in front of the REDC board.
Correct.
And it sounds like that would have been after September, but certainly before December of 2023.
Correct.
And during the presentation, the ask was $2 million.
Correct.
To the REDC.
Yes.
And the staff's recommendation was $1 million.
Not on that one. Not on the presentation. On the second one where we voted, it was $1 million.
Okay. And that's because the staff had completed their analysis of where it what benefit, cost benefit there was to it.
Right.
Is that a public meeting? The first meeting with REDC, is that a public meeting?
No. We're a 501c6, so we're private.
Then the Type B board presentation, when that was made to the Type B board, that was in an open meeting. I have a videotape of it.
Yes, it was.
On the application, did they identify what the money that would be given to them, if any, what it would be used for?
Yes.
And what was Randy telling you he had been told by Philip and Devin?
That due to increase in construction costs plus the FEMA requirements, that's what the ask was for.
And by plus the FEMA requirements, you mean the changes they were saying had occurred at FEMA with regard to the floodplain.
Correct.
The amount matters?
Yes.
And reasons matter?
Correct.
Did you ever have conversations with Philip Ramirez about the $2 million asked for the changes in FEMA floodplain?
Besides that was one of the reasons. No, we didn't have anything else besides that. Or we had because of that.
I'm not sure I understand your answer.
We did not have a specific conversation about the FEMA change. Just that due to the FEMA change.
It's just what?
Due to the FEMA change.
Okay. Due to the FEMA floodplain change.
Right. In downtown. That's why the ask was where it was.
But I mean, you heard those words from Philip Ramirez.
Yes.
You know I know a little about that. When you heard the words from Philip that the reason for the $2 million ask was for the change in FEMA floodplain, do you think that was before or after the executive session meeting that likely occurred with the Type B board?
It was probably before.
Okay. So it would have probably been November 2023?
Yeah, or December.
Did you have a hand in developing the presentation?
No.
The 5-slide presentation I showed you a moment ago was developed by, from your perspective, Philip Ramirez?
From their side. I don't know exactly, but you know, we did touch it. I mean, you'll see our logo on there.
Okay. Who added your logo?
Randy would have.
Okay. Did Randy make any other modifications to it?
Not to my knowledge.
I think you and I both know. Later in time, it was pointed out that one of the slides in that 5-slide presentation had been falsified or altered, right?
Altered, yes.
Okay. Well, altered in a way that it was no longer conveying the full information that was on the published federal website, right?
I know that a date was missing.
And also the reference number, I think.
Okay. I do not know that. I just know the date was missing.
Okay.
The date of publication was missing.
And you and I know that became a subject of great criticism. And so I'm just putting a bookend on that for you now because at some point in time, I'm sure you realized, hey, this presentation we're using has been, whether you want to call it altered or changed or falsified, whatever word you want to use, it created a commotion.
Yes, it did.
Okay. And then I'm sure naturally you sort of did say to yourself, hey, what's the deal here? What's going on? How did this happen? How did we get into this uncomfortable spot? Fair enough?
Yes.
Okay. Did you have conversations to learn about why it had been altered or falsified?
I did not.
You never talked to anybody about it?
I talked to Randy about it, but that was it. Just said it had happened.
Who what?
Just said it had happened. Because once it came out of Type B, it was a different animal.
Your conversation with Randy relating to the altered or false slide, what were those conversations?
Just what are they talking about? Because I was not making presentations, Randy was, and so when it came up in City Council, that's when I asked him what it was.
And what did he tell you?
He said that a date was missing.
Did you say anything else?
No. On the presentation, but that was it.
Did you ask him, Randy, did you do it?
Yes, I did. And he said no.
It's a pretty natural question.
Yeah, no, I understand.
The next natural one is, do you know who did it?
I do not.
Did you ask him who did it?
No, I did not. I mean, I asked him if he did it, and he said no.
Okay.
He said, I received it like that.
And I think you have had a conversation that tells me if I ask you who did it, then your deductive reasoning was it came from the applicant.
Correct.
Yeah. And I think you told Ajit David that it came from the applicant.
Correct.
Okay. And that's still your belief?
Yes.
I'm going to show you the online version of the FEMA federal document. Do you understand what I'm going to show you?
Yes, I do.
And do you see, I think you're familiar with this for sure, do you see the release date of April 13, 2022?
I do.
And do you see the reference number of R6-009?
I do.
And do you see the release date of April 13, 2022?
I do.
And then if I go to the slide that was used, do you see that all three pieces of information are missing?
I do see that they are missing.
Okay. And so, and I wanted to show you that because you've told me that, I just knew about the one date.
Mm-hmm.
Correct?
Correct.
Did you, until right now, know that there were three separate alterations or falsifications of the document?
No.
This is the first time you've heard that?
Correct. I just thought it was the date.
You told us that you were at the open meeting for the Type B board when the project was presented, right?
Yes, I believe so.
Okay. And during that presentation, we have it on video, but the applicants, I believe it was Ramirez.
Video? Thank you.
Thank you. Thank you. My apologies. We are, I think, what was that? Were we at page? Well, I need to state an objection just for the record. Pages 75, line 6 to page 76, line 11 is an objection to all of that testimony under hearsay 801 and 802, even if the video is independently admitted, each speaker's statement still requires a hearsay basis, so I need to make it, just for the record, an objection on that testimony, 75-6 to 76-11.
Noted. Do we have a motion to accept or deny this objection?
Yeah.
I'm sorry, Mr.
That's
Olson.
okay.
Yes, go ahead.
You're objecting to, just give me a page and line, 75-6?
75-6 to 76-11. It's him recounting the Type B presentation. That's all, and it's a hearsay objection.
And the actual video says the same thing, which is the proper evidence, and it's already in the record. So I'll make this suggestion. I'll withdraw it from the presentation, but let's not spend too much time technically trying to make sure it doesn't play, since I know, you see what I mean? I mean, because we don't have our operator here, but I don't know how they get to skip around or not. So with us withdrawing it, you don't really need to do anything. Pardon?
So there's an agreement to exclude that?
Yes, I'll agree to his request, so it's done by agreement, and because we know that the Type B presentation is already in evidence. It's done by agreement, and however they take care of that, the Type B presentation is already in evidence.
He being the respondent, thank you.
By agreement. You're welcome. My worry was starting and stopping it will be more trouble than it's worth sometimes, but I'm not
Are we able to proceed this time? Yes.
Philip Ramirez talked about how they'd reimagine that project in July of 2022. Do you remember that?
Something like that. I do not remember.
You remember that they asked for $2 million?
Yes.
Do you remember that they told the Type B board that the change in FEMA rules is what they were representing, that was one of the reasons for the ask?
Yes.
And that they needed the $2 million, or at least a portion of it, in order to comply with these new, what they call new FEMA requirements.
Yes.
And specifically, they told the Type B board that they had to elevate the first floor of the building 4 feet.
Yes.
Is there a deputy you have? I believe you have it out in the county.
And that they were kind of caught by surprise by, the way they expressed it, by these new FEMA rules, and did not anticipate it, and therefore were making this monetary ask. Do you remember that?
I remember the gist of that, yes.
But I'm talking about, it's always been in the 100-year floodplain, right?
I assume so, yes, sir.
Yeah. I mean, Corpus didn't get lower or higher.
Yeah, correct. Yes.
So in terms of it being in a floodplain, at the time they bought the property, at the time they reimagined the project, and for decades before that, that piece of property has been in the floodplain, 100-year floodplain for decades, right?
I assume so.
But I mean, you know that the elevation hadn't changed and the floodplains are basically the same for decades.
That's correct.
Yeah. And that's anything down the hill. We're up on the hill right now.
Right.
Anything down the hill is considered in the floodplain.
Correct.
Okay. And that's been true for a long, long, long time.
Yes.
Okay. So you would expect them to make sure the property's insurable?
Correct.
You would expect them, before they come ask for $2 million, to make sure what the floodplain was for the project?
That's correct.
You would expect them to be keeping up with FEMA rules to make sure that they know they can succeed with the project?
I would assume that.
Well, you would expect them to.
Right. Yes.
That's their job as the developer?
Mm-hmm.
Yes?
Yes.
And their job in Philip's case is being the architect?
Yes.
Okay. And I'm sure you're familiar enough to know that architects deal with floodplain on every project.
Yes, here. Yes.
Some places you maybe don't have to deal with it, but here you know it's something you've got to check on every project before you put a penny in.
Correct.
Okay. Did you ever have any conversations with Peter Zanoni about the hullabaloo?
We spoke briefly about it. I think the time we spoke about it was actually, he asked about the presentation, and we told him where we got it from, and that we hadn't altered it except for put our logo on it, and that they were delaying the February meeting, and that was it.
So you let Peter Zanoni know that the REDC was not responsible for the change in its content?
That's correct.
In the slide presentation?
Correct.
In the FEMA slide specifically?
Correct.
Okay. And that is specifically what he was asking you about is, hey, who changed the slide, basically?
Yes.
If the mayor is saying that the floodplain, that the FEMA rules had, suddenly changed or recently changed, do you know where she would have gotten that information?
No.
But you now know that's false information.
That they've recently changed? I mean...
Well, the changes were announced back in April and finalized in October, and then it's a year plus later. That's not a recent change. Agreed?
Yeah, I agree to the dates.
Okay.
Right?
If they didn't imagine it until July of 2022, then we know that they should have known it. The architect should have known.
Yes, I will say that, yes, they should have known.
Okay, the architect should have known before they even announced the changes.
Yes.
And the architect should have known when the changes were going to come into effect before he even imagined the project, apparently, right?
I would assume so, yes.
Okay. And so if you're going around acting like it's this change that we didn't anticipate, that's, whether you want to call it untruthful, disingenuous or untruthful, it's really not, it's not being square.
I would agree with that.
Okay. And whether you want to call it disingenuous or untruthful or not squared up, not honest, that's the reason that city council changes in FEMA is the reason the city council was given for the $2 million ask, right? At first reading.
Yes.
And the reason that the developer, Devin, Bacta, Philip Ramirez were given to the city council for the $2 million ask was for, quote, costs associated with FEMA flood zone requirements. Does that sound right? Yes. And the other reasons were that the grant request, it said, would be utilized for additional costs associated with newly defined Federal Emergency Management Agency, FEMA, AE flood zone requirements that has added unexpected additional costs, $1,510,000 and change towards the project. Remember that being essentially on the agenda?
That's correct.
And that's really a false reason. Agreed?
It's not entirely, covers everything, yeah.
It's not entirely true?
Just something like that, yeah.
Okay. Remember in school when they said if it's not entirely true, then you're supposed to check false?
Yes.
Okay, so on that one, we're going to have to check false. Agreed?
Agreed.
Okay. And I assume you would agree that everything that is being put in front of the city council when you're asking for $2 million in tax money needs to be 100% true.
That's correct. So what goes in is what we do compliance on.
Okay, but I mean, you're agreeing with me.
Yes.
Okay, you're agreeing with me.
I am.
Okay. And what we're reading on this agenda clearly is not 100% true, right?
Correct.
And that's why a minute ago you agreed we have to check the false box on it.
Yes.
Okay. Do you think that it is, by the way, and what we're talking about here, these were the reasons that Philip Ramirez and Devin Bacta were telling the city council for providing a incentive of $2 million in taxpayer money to their project, right?
Correct.
And like you said earlier, reasons matter.
All right.
Okay. It's important that the reason be correctly stated before anyone ever considers a incentive of $2 million like this.
Correct.
Okay. Reasons are a critical part of the evaluation to either support something or not support something.
Correct.
And if you don't have a good reason, then you probably shouldn't get the money.
All right.
Okay.
On the feeder road or on the highway?
So I assume you would agree with me that it is 100% in the wrong to have asked for $2 million with reasons that are not correct.
So you'll need to get on before go outside.
Well, it doesn't pass the smell test, do you agree?
Correct.
But I think we can agree that going to them, knowing the timeline that we know now about FEMA, that going to the city council and asking for the $2 million for the reasons set forth in the agenda item is wrong.
In the first reading, yes.
Okay, and you agree it's wrong to have done that?
Yes.
And I assume you agree it is wrong to have altered a federal document as part of a presentation. But we can agree that forging or falsifying or altering a document in order to play a narrative that it's a recent change when it's not really that recent is a misrepresentation, at least, about the need for the project.
I'll agree.
And you shouldn't get $2 million. I'm trusting in your character here. You should not be asking for or receiving $2 million if you're misrepresenting material information like this on a project.
I would agree.
But we know that out of those two narratives, you understand those are two different narratives.
Correct.
Out of those two narratives, the narrative related to the city council agenda item that got voted on at first reading was the narrative, the false narrative about it being a change in FEMA.
That's correct.
And Leah was calling saying we need to get rid of the false narrative, and I'm not saying she used that word, but we need to get rid of that false narrative and get a different narrative in there.
That's correct.
Okay. But the numbers you were working on was that it met your criteria if the investment was $1,043,000.
If the if the incentive were $1,043,000, correct.
And that was no longer the incentive, so you're no longer living in your world of numbers.
Correct.
Okay.
Yes.
So now we're living in a different world of politics by the time it gets to the city. right?
Correct.
Okay, it wasn't going forward or not going forward because of the numbers at that point in time, because the numbers it was going forward with at the city
$2 million.
were not, and which is the number that was not recommended.
Correct.
Okay.
Our board had not recommended.
Right.
Indian boy.
Yes.
Do you need to correct any dates?
So we did Type B in closed session in October 16th, closed session on November 23rd, and then we did an open session on December 11th, and they directed staff to prepare a $2 million grant, and then it was passed on January 22nd of 24. City Council first reading was February 20th, and then the second reading was not until April. So we were delaying it off of the March, between the first reading and second reading. So.
And do you have the dates for the REDC meetings?
We had REDC was introduced September 27th of 23. And, oh no, that's when we received the application. The initial meeting was October 12th of 23, and that was just introduced, and it was voted on November 9th of 23, and we recommended $1,043,433 to the Type B board.
And that once it became a $2 million animal, then it's no longer within your realm of the numbers.
Right. So in December, Type B board directed staff, which is us, to prepare a grant for $2 million.
Right. And what I was asking you, because when we said a moment ago, it kind of goes from a numbers to a political issue.
Yes.
And I'm going to read you the agenda item at the second meeting.
Okay.
But it reads as follows, the agenda item. Ordinance authorizing an agreement between Type B Corporation and Elevate QOF LLC for a total incentive amount not to exceed $2 million
I could hear it
for Homewood Suites by Hilton at the corner of Street and Lomax Street. You understand so far?
Yes.
So far, no change, right?
Okay.
Then it continues, for costs associated with the street level retail public space and outdoor dining area activation, including gray box and finish out, including necessary flood wall and dry flood proofing to allow a consistent street level access. Authorizing expenditure up to $2 million from the Type B unreserved fund balance and amending the fiscal year 2023-2024 budget to increase expenditures by $2 million. First of all, do you understand?
Okay,
does that sound like what the second?
Yes, sir. Yes.
Okay. And you realize they were referring to this, they being the city, was treating this like it's a second reading on Ordinance 240256, right?
Yes.
But like we discussed earlier, the narrative has completely changed, right?
That's correct.
And so the reason that we're now seeing, and let's just recap, the reason that was put in the first reading for the $2 million was because of these changes in FEMA rules. And now it doesn't even mention that.
Correct.
Okay. Now it's making it sound like it's cost associated with street level retail, public space, outdoor dining, things that are very, very different, right?
Yes.
And like we said earlier, reasons matter.
Yes.
And here, because of how they've changed the reason behind it, we're not getting really two votes on the same thing.
Correct.
Okay. And again, you can't predict if it would get more or less votes because of how it was changed. That's up to each individual council member.
Correct.
Okay. And so if the second reading on Ordinance 240256 had the same wording as the first reading, where it's relying upon an altered federal document, you can't tell us if it would have passed or not.
I could not tell you.
Before this Homewood Suites project that we've been talking about received this $2 million in taxpayer money, before that, has there ever been any hotel that received a favorable recommendation from REDC for a grant of $1 million or more?
Schlitterbahn, because it had a hotel attached to it. But besides that, I cannot think of one for type B or A.
Okay. So this would be the only one that was a hotel only.
For type B or A.
And let me rephrase it because I kind of generalized there too. The Homewood Suites, the one that we're talking about in this lawsuit, it would have been the first hotel that's just a hotel. Schlitterbahn's a lot more than that.
I understand. Yes, sir.
It would have been the first hotel that you know of that ever got any type A or type B money.
That's correct.
And
29063467.
Was this Homewood Suites one, and I understand the recommendation coming out of our EDC was $1 million plus a little. Was it the first one to ever get our EDC money? First hotel?
In type A or B. We have had tax abatements on, but in type A or B is the very first one.
Yes. And you understand the difference between tax abatement and giving them your money?
Right.
Okay. Yeah. Do you know of any studies that would indicate that bringing the Homewood Suites Hotel here, the one we're talking about in this case, that bringing it here would in any way increase tourism or serve the purpose of a destination hotel?
No, there has been none. In fact, we specifically took hot out of the calculation.
For the reasons you explained earlier.
Yes,
explain that to me one more time.
We did not believe that a hotel of this nature would increase tourism, be a destination in and of itself. It would just take rooms from other businesses, so we did not add hot as in the calculation for the incentive.
Okay, this is a scenario, since it's not a destination hotel, Homewood Suites is not a destination hotel. This is a scenario where, since it's not bringing new people to town, it may take away from other hotels.
Correct.
Yeah. And it was, that taken alone would really mean it should not qualify for any incentive like this $2 million. Agreed?
Our recommendation based on REMS 2 was $1,043,000. That was based on numbers. Anything above that, and that is what we held throughout the entire process.
And anything above that you would not be recommending?
Correct, and we did not.
So the politics of it were for you to get behind it?
Yes. Yes, it was.
But the phenomenon you described earlier, where if one new restaurant opens, one closes, because this is not a destination hotel, it runs the risk of doing that here in Corpus, right?
That's correct.
And that's another reason that there should not be public money spent on it.
It does not help the economics. It doesn't.
Right. Which the whole reason you're supposed to be giving public money is to help the economics.
That's correct.
And so the fact that it doesn't help Homewood Suites did not help the economics, that would be a reason to not give them anything.
Nothing. We still have the investment, which adds to the tax base, the sales tax during maintenance and during construction, and the jobs. Now, if it reduces in jobs, but you still have the investment.
I'm going to say this: the phenomenon that you talked about earlier, with one restaurant opens, another one closes, is sort of, for lack of a better term, it
cannibalizes.
I thought you said that maybe.
Yeah, we do. We say that word.
Okay. And so this is a scenario with this Homewood Suites because of the factors we've talked about, that it may cannibalize other hotels.
That's correct.
Okay. And that factor taken alone, sir, is not a reason to give money to it.
That is certainly something not in its favor.
Yeah. And because it is supposed to be, the money is supposed to be for the purpose of giving an incentive to increase economic development.
That is correct.
And what we're talking about, this cannibalizing effect, is not increasing economic development.
Yes, barring the new investment. Correct.
Okay. Because you can understand that it doesn't make sense to give money that's incentive money
Right.
to a project that's already committed.
Correct.
Okay, and so that would be another reason that would cut against giving money to this project if they were already committed.
I agree.
Yeah, they should not qualify for an incentive.
Right.
They're already here.
Yes.
I'm going to read you a transcript of a recorded statement of Peter Zanoni.
Okay.
When you read the entire PowerPoint, it was so obvious that the writer
Could we
wanted
pause
one
the
to
video?
believe.
Thank you. Yes, sir, Mr. Flood.
Thank you. Thank you. I have an objection to this section. It's 119.14 to 120.13. And I earlier, in response to, and the objection is, this is counsel in the deposition reads Zanoni's recorded statement that the presentation had been altered and was designed anyway. It's hearsay within hearsay under Rule 805. Earlier, when I made an objection like this, there was a representation that it was going to be taken out, but it wasn't. It was played anyway. And so I just need, for the record, to not waive this hearsay within hearsay objection 119.14 to 120.13. And if I'm looking at your cuts correctly, I think it's all in there. I think it's included. So I would make that objection.
Mr. Allison, could someone turn on his mic?
On this one?
Excuse me 1 second. We're turning your mic. Thank you, Rebecca. Yes, sir.
Ready?
Yes, sir.
On this one, the audio is already been admitted into evidence, so it is proper to present that to another witness and let him testify about it. So I think on this one that I should just say that his objection, I think he's really just making sure he doesn't waive it. In other words, he's objected to it once, it's coming at him again, he's objecting to it again, so he can't be accused of waiving it. I agree he's not waiving it, but I think you've already ruled on it.
Control to get on to 181 from 77. Continue on Basin 77. His cells of 181. Children light pickup. There's a white ram with them, and they have several pieces of heavy equipment, 17 traffic control.
I just need the objection system overruled. That's all. Thank you. So I'm reassert my objection.
I think y'all previously voted to admit the particular item, so I don't know that you need
correct,
to vote.
That's not going to be business 77, it'll be bypass 77.
That's exactly correct. Council's
between 188 and 181.
Trying to obstruct or try to get in the way. I'm just trying to make sure my objection is.
Okay, thank you. Then shall we resume?
Pardon?
Then shall we resume?
Yes.
Resume. You want a motion? Motion, do I hear a second? Second. All in favor say aye. Aye. Any opposed? Thank you.
Thank you.
Resume the video, please.
That the FEMA change was just recently released and this and that. Do you agree with that?
I would agree.
Continuing to quote, part of it goes back to the narrative. Mike Culberson said this has to be tied to infrastructure, and then they hatch a scheme. FEMA floodplain. That's infrastructure, fixing the bottom floors. Then they developed a narrative to fit it that they just found out because people would say that they should have known of this a long time ago, like Commissioner Hunter, Councilman Hunter. Sorry.
Councilman, yeah.
Did that happen? I'll go. It's a long sentence, and I hate taking things out of context, so I read you the whole thing.
Yes.
Now I'm going to center in on the portion of it that I want to ask you about. Mm-hmm. Fair enough?
Fair enough.
Yeah. Part of it goes back to the narrative. Mike Culberson said this has to be tied to the infrastructure, and then they hatch a scheme, FEMA floodplain. Do you agree with that part of it?
I agree that I said it had to be tied to infrastructure. I'm not sure about hatching the scheme, but...
And who did you say it had to be tied to infrastructure?
I told both my board, the project, and Type B it had to be tied to infrastructure.
And what is the reason that it had to be tied to infrastructure?
Because in the Type B guidelines, there is a clause that allows for the reimbursement of infrastructure, and in fact, that's all we've ever done when we looked at projects like this, that it's tied to infrastructure.
And so, when would you have made that statement that it had to be tied to infrastructure?
I'm sure I would have said it prior to the project, even before it went to our board.
Before the first presentation? Or?
Yes.
Pardon?
Yes.
So before the first presentation to the REDC?
Correct.
Channel 9 radio check. Over, Mike.
Peter goes on to say, then they developed a narrative to fit it that they just found out because people would say that they should have known of this a long time ago, like Councilman Hunter. My question is this. Do you agree that they developed a narrative to fit the infrastructure requirement?
I'll agree that they came to us with the infrastructure.
By they, you're talking about
the project.
Philip and
Devin. You're correct.
Okay. And was that after you told them it had to fit infrastructure?
I'm sure I probably told them when we first started talking about it. So
you think the sequence of events is you had some conversation where they want $2 million,
right?
And you're telling them it has to fit infrastructure,
correct?
And then do you think the sequence is, and then they came up with this FEMA plan concept?
I do not know the actual thing, but that sounds like it would fall into place. Yes.
That seems like the likely sequence of events.
Yes.
So apparently this discussion you're telling me about started a discussion between REDC and Philip and Devin where you're trying to say what infrastructure can we pin it to.
Correct.
And part of that discussion was a discussion about FEMA.
Correct.
And the result of that is it ended up that FEMA was really the poster child, the face for why you needed the $2 million.
That's correct.
Okay. And then that obviously led to the falsification of a slide that we've seen in the 5-slide presentation.
I can't say that it directly led to it, but it was after that.
The falsified slide came up after the idea of we need infrastructure came up.
Correct.
Okay. And you were looking for an infrastructure tie-in in order to try to support this $2 million award or million award, whatever amount it was going to end up being.
Correct.
Because you knew you couldn't get behind it without there being some infrastructure tie-in.
Correct.
And you couldn't get Type B money in your mind unless there was a infrastructure tie-in.
That's correct.
When you were having those conversations, well, it sounds like these conversations were directly between you and Philip?
They were probably between Philip and Randy, and I was kept apprised.
Okay.
Or it may have happened the very first time we met about it. You know, they came to the office and we talked about it, and I said it has to be tied to infrastructure.
You told that directly to Philip?
That's correct.
Okay. And did you in any way, shape, or form mean or suggest that the need for an infrastructure tie-in justified altering a federal document?
No.
Would you have ever tolerated that?
No.
I mean, you would have screamed bloody murder, I think, at him.
That's correct. Okay. I would not have let it go forward.
Pardon?
I would not have let it go forward.
Right. And therefore, they would have never gotten it. Agreed?
Yes.
But now apparently what it morphed into was prettier sidewalks in a dining area, right?
Yes.
Okay. Which did not meet your infrastructure requirement, right?
Correct.
Let me put it this way. Earlier, I think you agreed that the way it was presented misrepresented the project and also was false because it's not really truthful?
Correct.
Okay, in that sense, do you agree with him that
it provided a different timeline, right? Because it's recent, but it had actually been out since April of 22. Yeah.
Doesn't pass the smell test.
I'll agree with that.
Okay. Because, I mean, there's conversations that you're aware of with it needing to fit an infrastructure issue. Help us understand perhaps what someone was thinking when they altered the document.
Okay.
Agreed?
Agreed.
Okay. And of course, that's not. That concludes our offer of portions of the deposition of Mike Culberson. Your discretion if we take a stretch, or we're ready to probably play the deposition of Alan Wilson. Want me to get that one done? I think it's fairly short.
It's short. Yeah, we can move forward.
Okay.
Thank you.
Will you state your name, please?
Alan Wilson.
Mr. Wilson, I think you know that we are here today in relation to a matter that was before what we call Type B board. Is that
Correct.
right?
That's correct.
And how long have you been with Charter Bank?
This past April was 9 years.
And how long have you been vice president?
I've been an executive vice president or a market president for 20 years.
How long have you been in the banking industry?
I was telling Rosie, this month is 43 years in Corpus Christi.
And what part of the business of banking have you been involved with over your career?
Commercial lending and then management.
Tell me just very
What
generally.
are you telling me here, everybody?
Just generally, what's that process for commercial lending?
Well, if you're talking about when you start your career, you learn to analyze credit. And usually a year or two into that, if there's an opportunity, you become a commercial loan officer. What's involved with that is being able to appraise people's character, being able to read and analyze financial statements, and then being able to structure loans that doesn't put your bank at risk, but provides service to the community.
You mentioned in there appraising people's character. Is that important to the loan process?
We talk about in the lending process the 4 C's of credit. The first C is character.
And character, does that run hand in hand with the integrity of the person?
Yeah.
The honesty of the person?
Sure.
Okay. The truthfulness of the person?
Yeah, those are...
I just got back from the rear.
How long have you served on the Type B
mulching machine over there? It's called.
By the city?
I'm in my 6th year, and in September I will term out.
And I think at the time of the application and funds that we're going to be talking about here, that all relates to a Homewood Suites project.
Right.
I think at that time you were a member of the board.
Yes, I was vice president.
Okay, and I think now what is your current position?
President.
Since we know this was one of the projects, or that this project for Homewood Suites and the funding request came through EDC, right? Said yes?
Yes, I'm sorry.
Okay. Let's stick to that framework.
Okay.
And they would have done that analysis, and one prerequisite to it even getting out of CCREDC is that it meets the CCREDC criteria.
Okay.
Correct?
Yes.
Okay. And you don't, the Type B board doesn't get a project unless, other than the exception, which we know doesn't apply here.
Right.
The Type B board doesn't get a project unless it gets the check marks as meeting the criteria for the CCREDC.
That's correct.
And then it came in front of the Type B board.
It did.
And then it got voted on and therefore approved and passed on for city council consideration.
That's the process.
Have you heard the discussion with Peter Zanoni?
I don't think I have.
Okay.
I'm going to have to stop just for a second to make a...
Please pause it.
And I think I figured out a way to make this even a little easier. We're learning as we go along. I'm going to make an objection, and what I'm going to do is read the pages, and this will be multiple objections because it's all in sequence rather than stopping. It's going to be from page 15, line 18, all the way to page 19, line 15. And all those objections are all hearsay and hearsay within hearsay, so that's 801 and 805. And so that entire stretch, I can try to make this one objection if possible.
Thank you, Mr. Flood. Mr. Allison?
Through 19 what?
Through
line 15.
15. Page 19, line 15.
Thank you. Can I have one moment just to look at it?
Yes.
Animation 50.0 degrees.
Actually, I'm going to withdraw. I meant to, it's not all the way to 1915, but to 1810. So my apologies. To 1810.
I should guys the staff high school.
Oh, I thought I had you here doing all that. Oh, okay.
Just so you know.
Well, my mistake. I'm looking at what was provided last night. 18. Okay, well then it's to 18.4.
Yeah, I think he's just discussing his understanding of the issue, which is not hearsay, and so I believe that we should stand with the earlier rulings and allow it to play. So I would request that you as presiding deny the objection, and if you want to vote on it, I understand how you do that.
And just for the record, I want to make sure it's clear. It's 16, I'm sorry, to 1810. And
1518 to 1810.
Well, you
1804.
Okay, that's fine. 18.4. That's
18.4?
fine.
Okay, thank you. All right, do we have a motion or?
I think the simple motion would be the motion to deny the objection.
Yes. He's offering if we would like to take action similar to what we did at the last objection. So do we have a motion?
To deny his request, yes.
And a second? All in favor say yes. Yes. Any opposed, nay? Carries, thank you. Resume the video.
Thank you.
Context for it. You know that later in time, this project was in front of the Corpus Christi City Council.
Yes.
And between first and second reading, you probably remember there being some hullabaloo.
Yes.
About the altering of a federal document.
Yes.
Okay. And there was an investigation by the city to look into that, correct?
I don't know that.
Okay. One of the conversations in that time frame was this conversation.
I don't have that, but they haven't given it to me. And so until then, I'm not giving any recommendation. I'm putting it on the agenda. I was asked to. You can consider it. You have to come up with your own recommendation.
But you did let the city council know that there were some some improper information, some tampering and all that involved. Also, you let them know.
I let them know. We're going to let them know again tomorrow in executive session. I already have an executive session posted.
Okay. Peter, when does executive session happen? Does it happen towards the end or?
No, when we break for lunch, most likely. I can't remember how many items are on there, but probably on the first break, the lunch break, so like
is it
2:30? Yeah.
Okay, is it after public comment or before?
Oh yeah, no, it's after public comment.
Okay, no problem.
Yeah, after public comment.
Yeah, I was just a little surprised that council is still willing to consider this after they know what was done. And on that website, on the FEMA website, it even says this is a United States government portal.
Yeah.
On the very top.
Yeah, definitely. Right, it was Alton. And then when you read the entire PowerPoint, it's so obvious that the reader or the writer wanted one to be led to believe that the FEMA was just recent, even words like recently released and this and that. And part of it goes back to the narrative. Mike Culbertson said, hey, we can't, this has to be tied to infrastructure. And so then they catch the scheme that, okay, FEMA floodplain, that's infrastructure. The fixing the bottom floor so it meets the floodplain, and they stuck with it.
Got it.
And then they develop a narrative to fit it that they just found out, because people would say like, shit, they should have known about this a long time ago.
Yes.
Like Councilman Hunter. So, I think, Ajit, I think people right now, the council right now, seem like they're strong and are going to vote, but we've seen it time and again that once one or two or more start talking at the council citizens, they change their mind real quick. But it's on them. I know I'm not recommending it because I don't have the information I need. Mm-hmm. I'm going to have to cover it. Even if they said something, I'll believe it. I'll put it on. But they haven't even sent me shit, and instead they want my lawyer to send them, ask for them over an hour, and I'm not doing that. So if council asks me between now and next Tuesday, my answer is this, which is that I can't recommend anything because I'm still waiting on information to develop a recommendation. However, because the council wanted this on the agenda for them to consider, it's on, and you all consider what you want to do. And the applicants are supposed to be in the room. You can ask them.
That's right. And how difficult would this be? If you ask somebody, hey, we're going to give you $2 million, just give an explanation for this. And if they're not in a position to give that to you, the council still wants to give them $2 million. When you ask for $2 million, the least you can do is, hey, just give us an explanation and the money is yours. Even that is not happening.
Right, exactly. As of right now, that's not happening.
On the eastern apartment 2344.
Okay. No problem. But anyways, I think, if you think...
86.
It doesn't go much longer. I actually did not mean to. You understand from listening to that, a very specific reference was that the infrastructure was the FEMA floodplain, right?
Yeah.
First thing I think we've agreed to is in the context of this Smart Suites project that the infrastructure component that was part of this package to get money for the applicant, the infrastructure component was the allegation or suggestion that there had been a FEMA floodplain change.
Recently was the idea, but it wasn't recent.
Right. But we're agreeing on what we're referring to when we talk about infrastructure.
Yes.
At the presentation, he says, Mr. Philip Ramirez said, the one thing that came up is that we were not anticipating the FEMA maps were preliminary, but they became finalized and adopted the process of the city. We needed to comply with the new FEMA requirements that came into effect on October. You know that they're not really new. They've been around for a long time.
I do know that they were preliminary.
Well, they were preliminary from 2020, like 3 years earlier. But then Mr. Ramirez says it kind of hit us midstream. It threw us for a little bit of a loop for some aspects of the project we're not planning on. Okay, that certainly indicates that they were surprised by it, right? Mm-hmm. Correct?
Yes.
But you and I both know, and I know it goes back to 2020, they do the preliminary and the proposed changes, and it's several years before they become final, right?
Yeah.
It's about a 3 or 4 year period, right?
Okay. I'll take your word for it. I don't know the timing, but
generally that would be consistent with how FEMA operates.
Sure.
Okay. You know that much.
Yeah.
And I think the website, the initial presentation of it was October of 2020, so that's years before this project was even imagined, right?
Right.
Okay. So it's not like they're new changes.
Right.
It's not like they're a surprise.
So should...
Agreed?
Yes.
Okay.
Should somebody in the real estate business have known that they were coming? The answer is yes.
Yeah. And it should catch them by surprise on a multi-million-dollar project.
Yeah,
We agree?
I was surprised by that, yeah.
You're surprised that they're claiming they're surprised.
I guess that's one way of putting it.
They should. It should be anticipated. It should not be, oh, we didn't anticipate.
Yeah.
They shouldn't be surprised by regulation.
The possibility of that becoming the law.
Right, because it had been proposed for years.
Yeah.
Okay.
I agree.
And and again, Mr. Ramirez goes on to say the applicant in front of the Type B board quotes, so there were some FEMA requirements. He says requirements, but we know he's referring to FEMA. Quote, so there were some requirements and parameters that we certainly did not anticipate. Again, they should have anticipated them, right?
In my opinion, yes.
Yeah. FEMA doesn't move fast. Right?
Right, government.
From the information we have in the presentation, is it very clear that the applicant is sort of pitching it like these were not anticipated and that it was some kind of recent change?
To the best of my recollection, I think that's true.
Yeah. Okay. And we are agreeing that that should not be true. It should be that the architect and the developer did their homework ahead of time and anticipated everything because the information was available.
Okay.
Agreed?
Agreed.
And you understand the audio tape I played a moment ago, pretty distinct voices, but that's Peter's own OD?
And I think.
Yes. Okay. I think we're now at the point then where it's clear, is it not, that the infrastructure component we're talking about relating to the application for receiving money is the FEMA flood plan changes, at least the suggestion of that by the applicant, right?
I think I agree with that.
Okay. And that in that context, then Culbertson was asked about infrastructure. Remember, that's where we were talking a moment ago? Mm-hmm. That's where we diverted?
Yeah.
Okay. Mr. Culbertson says on page 121 of his deposition, quote, I agree that I said it had to be tied to infrastructure. Did I read that correctly?
Mm-hmm.
Do you agree with that?
Yeah, I guess.
I mean, he knows his business.
Yeah.
And so he's saying he agrees that it had to be tied to infrastructure, and he further says, quote, I told both my board and the project in Type B it had to be tied to infrastructure first. Did I read that correctly?
Yes.
And do you agree with that?
Yes.
And then Mr. Culbertson goes on to testify, quote, and in fact, that's all we've ever done when we looked at projects like this, that it had to be tied to infrastructure. Did I read that correctly?
Mm-hmm. Yes.
And do you agree with that?
Yes. Well, as far as I know, I don't know his history.
Right, but this is his expertise.
Yeah.
So he would also,
I would expect he knew what he was talking about.
Right. And then he went on to say, he was asked, quote, because you knew you couldn't get behind it without there being some infrastructure tie-in, and his answer was correct. And then the next question, and you couldn't get Type B money in your mind unless, that's a typo, unless there was an infrastructure tie-in, and he says that correct.
That's what he said.
Supervisor.
Did I read that correctly? And so what he's very clearly saying, and again, you said he's kind of the expert in the field, he's very clearly saying that if there's no infrastructure component to it, this FEMA floodplain deal, then there can't be any money.
The implication is it would not qualify for Type B.
In which case there should be no money given.
Right.
When the applicant, Devin Bacta and Philip Ramirez came and made the presentation, you know that they made a presentation using a FEMA slide, correct?
Yes.
And I think you probably now know it was falsified.
I know that, was it the date that was removed?
Actually, it was a date in 2 places. I'll go ahead and show you the...
I think Ajit has shown me.
Let me help you there so you have exact information.
Okay.
Here's the original that's online still. And I'm going to point out 3 things for you.
All right.
There's a date here, and a date here, and a reference number there, or release number.
Right.
You see those 3 items?
I do.
And then, here's the actual slide they use in front of your Type B board. And do you see that the date has, the one date I pointed out a moment ago has been removed. It's not there. Agreed?
Yeah, no, I don't see it.
And then the second date I showed you is also not there.
Right.
And then the release date is also, or the release number is also not there.
36009.
Correct?
Correct.
So that's 3 alterations where they
36 to road
changed,
supervisor.
modified, forged, whatever word you want to use the document.
Yeah.
The suggestion by Mr. Ramirez that somehow this change in FEMA floodplain rules was not anticipated, and we've agreed that's what he's suggesting, right?
Yes.
That suggestion sort of is time sensitive. The word recent or not anticipated are time sensitive words.
Yeah, right.
Okay. And so removing the dates deprives the person on the Type B board or who's ever looking at the falsified slide. Removing the dates removes the reference to a time period.
Okay.
True?
Yeah.
Okay. You live in a world where you do lending with private money, right?
Yes.
And you understand that, quite frankly, you've been given a awesome responsibility by serving on a board that can advance or loan or invest, whatever word you want to use, public money.
Right.
And that's, in my view, and I don't mean to say less of the private sector, when you're dealing with public funds, there probably needs to be even higher scrutiny. Do we agree?
High standards.
Yes. The highest of standards.
Yes.
And back to what the most important thing is when you're advancing money, the highest standards for one's character, correct?
Yes.
The highest standards should apply for one's integrity, right?
Right.
The highest standards should apply to one's honesty in making the request for the money.
Well,
the
yes.
highest standards should apply for one's truthfulness in making the request for the money.
Correct.
For public money. Right?
Correct.
Okay. And so if you're altering you understand the FEMA document that they have offline from being online.
Right.
That's a federal document.
Yeah.
Okay.
So, yeah,
And altering the federal document to request public money, I'm sure you will agree, lacks integrity.
Yeah, if it's material, yes.
Well, and we've already proven its materiality because time and this not anticipated argument is out there, right?
Okay.
Okay, so let's not digress.
Okay.
Altering a federal document is, you would never expect someone of good character to alter a federal document.
Not to mislead.
Do you agree?
I agree.
Yeah. Okay, well, if they altered the very document that was the infrastructure component that would prohibit it from being approved by CCPD like Culbertson testified to,
well,
that's material, isn't
that
it?
is material if the EDC would not have approved this because of the alteration.
When you saw Mr. Culbertson's deposition, he would not have. Correct?
I think that's correct.
Yeah, and if CCPD knew then what it knows now, that the infrastructure component was based upon a false document, it should never have then come out of CCPD.
Yes, that's correct.
Well, yeah. And there's no ifs, ands, or buts about that one.
I didn't say if. I said yes, that's correct.
Yeah. And quite frankly, and I'm going to make the assumption that you think the Type Board B responsibility to administer public funds is a serious and awesome responsibility.
It is.
and that it requires the highest standards for the words you used: character, integrity, honesty.
Going to be out of Missouri.
Yes.
But if you have a falsified federal document, are you going to approve a loan?
352.
No, if it's material, no.
Well, this is material. If it's,
Yeah,
okay.
yeah.
So it should never have gotten approved.
Yeah. Well, it should never come to us.
Right. Okay. And if you'd have known back then what you now know to be true about...
We would have tabled it and investigated it and tried to understand why, and we would have gone several steps further.
Yeah.
But at
In other
the
words,
time,
you would not have approved it as is with that falsification.
not on that day.
We agree.
We agree.
And then it never came back because that never happened because you were lied to and you relied upon the applicant.
Yeah. And so I became aware of the allegations after we'd already voted.
I understand. So if it's true that they falsified the document, you would have voted no.
I would have voted no.
Against it?
Yes.
Okay. That's all I have.
Thank you.
That concludes our offer from Mr. Alan Wilson. The next offer is going to be Heather Holbert. It's a 58-minute. It's longer than that. So your pleasure, break now or not, or your call.
Well, let's go ahead.
Started?
Yes, sir.
Okay.
Thank you.
Come on, can you turn on that 27 out of Missouri?
15 George 180352.
And would you state your name for the record, please?
Heather.
And Ms. Hilbert, go ahead and tell us where you are working today. And what is your job today for the city of Corpus? And very generally, do you understand today that we're here in connection with a lawsuit that is complaining about a specific ordinance that was a award of $2 million to a particular company?
Yes.
Before we get into the details of that, we understand that you're in Europe.
Yes. I went to Berkeley High School.
And what year did you graduate?
1988.
Did you go to college after that?
Yes.
And where did you go to college?
I graduated from UTSA.
And what year was that?
1994.
And what was your area of focus or major?
Business administration with an accounting, focus in accounting.
312 County.
Are you a CPA?
I am.
312 Troy. Those individuals that needed assistance to make that U-turn moving north or south. I believe they're going to be northbound and they need to go south. You're looking for heavy equipment and light forces with a white Dodge Ram. 10-4. I'm on a 188. I'm about to report on it. 74. 10-4.
647 to Dr. Kyle. Copy beginning. Copy ending.
Was there for Grand Office and worked for Arthur Anderson as an auditor. I left Arthur Anderson and worked for
64.0. 64.0.
left Grand Office as their financial reporting and budgeting manager. Left Taco Bodega and worked for a private CPA firm. And then from there, I left there, went to work for the city of San Marcos. And then left San Marcos to come here to Corpus.
I think you said you went to Arthur Anderson?
Yes, I was an auditor for Arthur Anderson.
When you say auditor, I think probably I know what that means, but tell me what that job was.
I was a financial auditor, so we went to various companies that contracted with Arthur Anderson to do their audits or financial audits, and so I was one of the staff auditors.
Would that include some, what I'm going to call compliance auditing?
Yes.
And when you're auditing for compliance, are you making sure, I guess, first of all, that they're probably following generally accepted accounting procedures?
Accounting principles, yes.
And then you went to the city of San Marcos?
Yes.
Go ahead and give me, I've got some background on you, but I'm going to start putting some time on it now. What year do you think that was?
That I went to San Marcos was 2009.
And how long were you with them?
11 years.
So 2020?
Yeah, 2020 is when I started with the city of Corpus Christi.
And what did you do?
I was hired in as their assistant director of finance and then
Love
was to the director of finance.
Copy your name and public service number.
So that has a lot of either directly for you or you're overseeing compliance.
Yes.
Is City of San Marcos, is that a home rule city?
Yes.
For example, I'm generally familiar with there being statutes that require strict compliance for procurement. Do you know what I'm referring to?
Yes.
For cities, right?
Yes, all cities fall under the state statutes.
Second contact with Casita Castillo, 361 534 5133 at 361 534 5133.
San Marcos to make sure that there was compliance insofar as its interaction with the financial part of the city, compliance with the charter?
Yes.
City of San Marcos, is that where you sort of made the jump from going from the private sector to the public sector?
Correct.
And I'm sure you understand the need for heightened scrutiny. Don't get me wrong, it may be your view that you should always have
McDonald's, 2475 West Wheeler, going to be for a holdable one. Only could advise you to the
Did the
zone
city of San
4.
Marcos, it's not an uncommon feature, did they have some sort of a two-reading rule?
Yes, their charter did require 2 readings of ordinances.
2 readings?
Of ordinances.
When you began then with the city of Corpus Christi, that was in 2020.
That's correct.
What position did you first take here?
The director of finance.
And how long were you director of finance?
I was director of finance for 3 years. About 3 years.
And then what did you become?
And I was promoted up to assistant manager.
Do you remember the date and year that transition, that change to assistant city manager occurred?
It was in May of 23.
Let's go back to your period of time, 2020 through May of 2023, where you were working for City of Corpus Christi as Director of Finance. Do you remember that so far?
Yeah.
Tell me what your job responsibilities were.
So to oversee the finance department, which included all of the financial reporting, all the cash management, accounts payable, accounts receivable, payroll, procurement, and economic development.
As Director of Finance, would it be your responsibility to make sure that you're complying with procurement laws?
Yes.
What's the game with it?
Both know that the state passes promulgates laws, statutes that define exactly that procurement
Everybody
process.
should know that 4, number 4.
Aspects of that procurement process, yes.
Pretty tough to turn on the country.
During the period of time you were Director of Finance, you had the interaction with the legal department for the city. All this sort of matters.
Multitude of matters.
Anything that came up that probably involved money and law.
Yes,
issue.
or agenda items for contracts, or procurement, or a multitude of things.
What was the practice there as far as
There is a false one.
what would be the trigger for you as Director of Finance to maybe reach out to legal?
And we work with legal on a daily basis. I mean, we work with legal on all of our agenda items, because of all of our contracts, all of our agreements, multitude of things, yeah.
There's a huge interaction between how the money flows and making sure it complies with the law.
Yes.
Would there be a question, I'm sure there would be, while you're Director of Finance, where you would say, hey, can we do this action or do something, and is that allowed under the laws of the state of Texas, whether it's procurement or otherwise?
All
I imagine it's pretty hugely important to you to make sure that you provide important information to your boss.
That's correct.
Yeah. I mean, is it your practice in any way, shape, or form to withhold information from Peter Zanoni when it is relevant to an issue?
No.
Are you the type of employee that if there's an issue and you have some information about it, you're going to make sure you communicate it to your boss?
That's correct.
And is that something that Peter Zanoni insists on?
There's an insist that you want to make sure that you always want to make sure your boss is informed.
And I didn't mean at that time insist in a bad way. Okay. You think he expects of you that you're going to make sure you communicate all important information.
Yes.
And keep it informed.
Yes.
That's the way he does business.
Yes.
And you feel like, not that it's a bad thing, but that he requires that of you as an assistant city manager.
Yes.
Because I've always been your experience with Peter Zanoni.
Yes.
When you were assistant city manager, would you still have, for the period of time we're talking about, would you still have frequent contact with legal?
Yeah. Yeah.
And would you still have the responsibility of participating in
agenda
items?
Yes.
And still have the responsibility of drafting memos for agenda items?
Yes.
Please, that's funny. Thanks,
And still have the responsibility of making sure there's compliance with the laws of the state of Texas?
That's correct.
Go ahead and tell me while you were director of finance for the city of Corpus Christi, what was your job with regard to economic development?
So when I first started as the director, economic development was a function under finance. I believe it was in October of 22. I can't remember. There was a separate department of economic development created, but we did not have a director in place for a long period of time. And so while it was a separate department, I was still overseeing that in my role as finance director. And then when I moved into the assistant city manager role, I was still overseeing economic development until we placed a director in June of 24.
And I understand from what you just said that there were still some position changes, but since it didn't get filled until July or June of 2024, sounds like we were doing the same job for that period.
Exactly, yes.
But as a practical matter, it sounds like from when you began 2020 until June of 2024, you had the same role with economic development.
In essence, yes.
And tell me what that role was.
Just overseeing the economic development functions. So we have tax increment financing zones, we have the Type A, Type B sales tax, along with 380 agreements, working 380 agreements. So all those things that fall under the purview of economic development. I was basically the liaison with the economic development, with regional economic development.
And the first reading for the city of Corpus Christi had all that language of infrastructure and FEMA in it, right?
Mm-hmm. Yes.
And then the second reading had none of it.
Yes.
I'm going to put some kind of timeline to your discussions and we're kind of getting there.
Sure.
And it's in the deposition, so you may have read it.
You're going on traffic.
Do you agree that it looks like the
application
was received September 27th, 2023? Does that come forward with your memory?
That is about that memory. I can't speak to that exact date, but yes.
Then he also testified that the project was presented to the REDC on October 12, 2023. Does that sound correct?
That sounds correct, yeah.
Mr. Corson testified to it. That's sort of his specialty, so you don't disagree.
Yeah, it was his board meeting, so yes, I would defer it on the date.
I use that word too, defer. And then he testified that the REDC voted to recommend $1,043,000 on November 9, 2023. That was also his board meeting, and do you accept that name is true from him?
Yes, that sounds appropriate, yes.
And then it went to closed session with the Type B board on November 23, 2023. And is that something he might call someone know about?
Yeah, I'm sure exactly, yes.
And you would accept what he said is true there?
Yeah.
And then the open meeting for the Type B board, does it comport with your memory? His testimony was it occurred on December 11, 2023?
Yes.
Did you attend that meeting?
Yes.
Did you attend any of the REDC meetings? In the October one? see if you recognize this, because I know you said you went to the
36 ID.
See if you recognize this as their agenda and in the slide presentation that was used at the county board meeting.
$38.87, $41.77, $38.87 dollars.
Yes, this does look like the type B board agenda.
Confirm the date. I know you said it earlier in the record.
December the 11th, 2023.
And you were there for the presentation.
Yes.
And do you remember during the presentation, for example, that really I think that Mr. Ramirez, Philip Ramirez was doing most of the talking in terms of the applicant?
Good.
I believe so.
Do you remember him talking about that one thing that came up that was not anticipated? It was FEMA.
Your vehicle is reconfirmed. It started February 26th on 09 Chrysler. Your vehicle was eligible on ID card expired in 29. Showing to have one out of Nueces County, which vehicle caused bodily injury. With $20,000 bond.
And then he said something along the lines Mr. Ramirez did about it. It did throw a wrinkle and an aspect of the project from a constructability perspective, but also just an added cost that we were not anticipating when we first started moving the project forward.
Yeah.
And he's talking about FEMA there. He's talking about, he's saying we need the money because FEMA threw us a curveball.
To accomplish what they wanted to accomplish that.
Well, to comply with what he said were the new FEMA regulations.
Yeah.
Okay. Well, he's actually talking about raising the floor lines, right? Is that correct?
I believe so.
In response to FEMA, what he's calling new FEMA rules, right? Correct?
I believe so.
And if you look at exhibit number 1, if you'll go to the slide presentation.
Yes.
And then the second page, do you remember them using that slide?
Yes.
And you and I both know that became a slide that has generated a lot of controversy in this lawsuit, fair enough?
Yes.
Mr. Ramirez relied upon that slide when he was making the presentation to the Type B board and requesting $2 million of public money, right?
Yes.
And that slide is a screenshot of the FEMA federal website, right?
Yes.
I have the screenshot here, at least, of the actual slide I'm going to show to you now and draw your attention to.
Last name Gonzalez with an S, first name Gabriel, 82597, 825-1997.
Yes, this is a press release.
You advised the hard day was Gabriel, you came in on verbal.
On slide that was used during the Type B presentation, except for the one used at Type B.
Gabriel Gonzalez with an S, 825-1997, 825-97.
It has a release date of April 13, 2022, right?
That's correct.
And then below that, it again states below that voice of the CDC. Below that release date, it again says at a second location that the release date is April 13, 2022, right?
That's correct.
And then on the one that FEMA published, it also has
We got in the rock truck?
009.
Are we on Amanda?
Yes.
And someone has removed all of that information from.
Hey, Cruz, come over here on the left-hand side on the very, very edge. We don't want to get all that other torn up. Like over here where I'm at. On the very, very edge. And we're going to go out the same way. On the very, very edge. The traffic will go around us.
Actually, another publication I'm going to show to you.
Okay, so
document that was published online. She has the release date of October 20.
Indefinite 9999. Also showing 2 for 2,000 positions from the staff.
R6 20-012. And you see that this is information that was released to the public by FEMA in October of 2020, right? And that's
let's have the intersection, and we'll start there.
2 years earlier than
3946,
the release date
Victor
on the
Lincoln
previous
Frank, 3946, RTA Corpus.
Okay. And do you see that that was a release by FEMA of the revised preliminary flood maps for Nueces County? And that they're, you see that?
Yes.
And that they're ready for public view back in October of 2020, right?
Yes.
If we look at these federal documents, and
Transport 24563, 24563.
Governor Barris was characterizing the changes in the flood maps, I'm using that word, in the flood maps as being a recent change that makes the presentation in December of 2023, right?
I believe so, yes.
We know just from looking at the FEMA documents that those flood maps have been released for review back in October of 2020, right?
Yes.
You see where you can click on the flood map change viewer and it gives you the website?
Okay.
You see that?
Yes.
Okay. And if you click on that, I'll show you exhibit number 2 to your destination. And it gives you, do you see that?
Yes.
You recognize that? You see the L heads and the T heads for Christi, right?
Mm-hmm.
Say yes?
Yes.
Okay, so back in October of 2020, when you click on that, you see the new FEMA flood maps back in October of 2020, right?
Yes.
You've been talking about it, that they reimagined the project like July of 2022.
Straight up?
2022.
325 Transport.
Presentation that you did.
I think it was 23, wasn't it?
That's
There we go. We didn't hit the federal or 15 or Highway 44.
Years after the FEMA.
We can do that word for more.
Imagine this very project, the Homeland Suites, years after FEMA flood maps had already changed, correct?
Like I said, I'm not sure what, I don't know when they imagined it. If it wasn't 22, it would be about the time it was adopted, right?
Well, no. Please answer my question.
Sure.
And I said 2022, you said 2023. In either event, that is years after the FEMA flood maps were published for review in 2020.
Yes.
Okay, so they didn't even think about this project until after the FEMA flood maps were already available for them.
Yes, it appears so.
Yeah, and that's not a recent change, right?
Okay.
And I think if you read Clovis's deposition, of course, we said there among other things is that the word he used, actually, he volunteered, was that
Possible theft of copper.
At a minimum to the title to say it was a recent change when it had been a change in the making for years. Fair enough?
Fair, yes.
Okay. And some people might think it's, well, if you went and removed the release dates from the slide you're looking at, I'm going to pull that up to the camera and be clear on which one we're talking about. And pull it up to the camera. That's the slide they used during the presentation to the people, right?
Yes.
And that's the one that has, it's altered, it's had dates removed from it, right? Correct?
We contact with Matthew Walker, 210-531-8049, 210-531-8049.
And can you include adult mirrors?
Yeah, it was and staff is coming for the slides.
Yeah. And that was part of an investigation that was launched by
605.
Christi and the city manager, right?
Mm-hmm. Right.
Yes.
We copy your name and policy service number to
His fingers on the keyboard, but he or his staff are the ones that had altered the slide.
In contact with Rochelle Williams, 361-424-0270, 361-424-0270.
He said he wasn't sure how the date was removed or how the change was captured.
Okay, so that's sort of, he kind of admitted it, but didn't really come clean. That's kind of what it sounds like.
Like I said, he said that he was, staff prepared it. He said that his staff had prepared the presentation.
Was it at his direction?
Yes.
You see how removing the date fits into the false
31 8049 20531 8049.
Which, I mean, if your narrative is something false and you remove the data so you can sell the false narrative, that doesn't pass the smell test at least, right?
1262.
In fact, it was a false narrative.
Well, the narrative that you needed it for new
1262.
was false, right?
We're going to be 109.
Yes.
Okay. And do you think it's okay to get $2 million in public money that is even in part based upon
Warrant is confirmed. Active warrant is going to be for assault covered body injury on 20,000.
To this same ordinance
That is
about
Yes.
first reading.
Okay. The first reading of the notice drafted by the PC.
And did you sign off on it?
Yes, in essence. Yes.
And in that
12 circuit miles are going to be 780.
memorandum, is it very called a memo?
Yes.
52 digits, right?
2024, right?
Yes.
So it's after the presentation to the type B board where we just looked at the altered slide, right?
Yes.
And in this presentation, though, Philip Ramirez again used the same altered slide, correct?
Yes.
Okay. And this is the memo that you prepared, by the way. This second time that I'm referring to where Mr. Ramirez used the same altered slide, that occurred at a meeting on February 20, 2024. Does that sound right to you?
511.
Yeah, the Texas plate, Tom Lincoln King, 7216, Tom Lincoln King, 7216, via northbound 35 frontage, 1850.
January 30 to February 2024. We're seeing a continuation of this.
30203, can I get the next available court date?
Have you heard the audio tape where Peterson only refers to
September 21st, September 21.
I'll say there till we get there. Then it also
12,480 miles,
of the presentation being using altered federal documents.
Again, I don't agree with a federal altered document. This is a screenshot of our website.
Okay. An altered website.
A screenshot.
Okay, a screenshot. Yeah. Well, you basically did a screenshot of the website. That's a federal website, right?
Mm-hmm. It's
a federal website, correct?
Okay.
648.
Downloaded as a PDF federal document, right?
Which it was not.
648.
That was not what was done.
Yeah, 936 West Island.
Okay, and you already said that's not okay.
Yeah, no, exactly.
I mean, it's wrong no matter how you cut it.
Yeah.
You're not trying to say because it's a website, it's okay to mislead, but a document you can't alter. You're not saying that.
Well, no, what I'm saying is you keep referring to it as a federal document. It was a screenshot of the website. Okay.
He's altering federal information.
Yeah.
Okay. I mean, that's bad.
Yeah.
It's horrible, right? I mean, it's horrible. Can we agree?
If you were to alter a federal document, yeah.
Well, if you're altering federal information in order to deceive somebody to thinking it's recent, that's horrible. Agreed?
Yes.
Especially if you're asking for public money with it.
Yes.
You didn't do it. You would never in your life do that, would you? Alter a federal screenshot and go present it to solicit federal or public money. You would never do that in your life, would you?
No.
Anyway, in your memo, at least so
639.
In December of 2023, we see this federal alter, whatever you want to call it.
311 South, Down Street, 311 South, Down Street, 92 to 911 call. Caller advisor was accidental, but I could hear arguing before she hung up.
311.
Yes.
For 31 South Road is where it's being.
On February 20, 2024, right?
Yes.
Okay. And specifically, if you look at the caption, first of all, on your agenda memo that you published on January 30, 2024, it says there's going to be a first reading on February 20th, which there was, right?
Yes.
It says the second reading is scheduled for February 27th, right?
Mm-hmm. Yes.
And that second reading did not occur on February 27th because all heck was broke loose.
That's correct.
Okay. And the heck that broke loose was the accusation that there'd been an alteration of federal data.
That is correct.
Does it say in your memo that the $2 million is, quote, for costs associated with FEMA AE flood zone requirements?
Which is true.
Does it say that?
Yes.
Okay, and that sentence was removed in your second memo, wasn't it?
I believe so, yes.
Okay, I have it here if you want.
Okay.
We'll get to it in a minute.
Yeah.
And does it say on the background that under background, does it say, quote, on this January 30th one, on January 22, 2024, the Type B Corporation unanimously approved an agreement with Elevate QOF LLC for costs associated with FEMA AE flood zone requirements. You see that?
Yes.
And the reference to costs associated with FEMA AE flood zone requirements was removed from your subsequent memo, right?
Yes.
And so, and then on your January 30th memo, does it say that, find the paragraph if you will, the grant request will be utilized? Do you see that? It's on the top of the second page.
Okay. Okay.
Where it says, quote, the grant request will be utilized for additional costs associated with newly defined Federal Emergency Management Agency, open parent FEMA, close parent, AE flood zone requirements that has added additional unexpected costs of $1,510,000 and change towards the project. Do you see where I read that?
Yes.
That sentence was completely removed from your subsequent memo, right?
Yes.
Anyway, and then on the list of supporting documents, it says the things that were relied upon to make this recommendation. That's what you're listing there, right?
Yes.
And so the things that you were relying on is, one, the proposed agreement between Type B board and the applicant.
Yes, because that was being forward for consent. That's what was being approved, was the agreement.
Right. And the other thing that's here as far as the listed item you relied upon is FEMA cost estimates, right?
Yes.
And who provided those FEMA cost estimates?
The developer, the applicant.
And then the other thing that you were relying upon in order to make this recommendation for $2 million to be given was a FEMA flood map. Do you see that?
Yes.
And the other thing you were relying upon was the PowerPoint presentation, which had the altered federal website, slide, whatever you want to call it.
I would not agree that we're using the PowerPoint presentation to make the decision. It was based off the application and the information given.
What's listed as the supporting document?
To the agenda item.
Yeah, so you had false information because it's altered being part of what was supporting the award. I'm using the word supporting because it says supporting documents.
Yeah, supporting the agenda item, yes.
Yeah, which is approval for $2 million. Correct?
Yes.
Okay, so there's a direct link, even according to your memo, of that PowerPoint presentation that has the false or misleading information in it and the award of the $2 million.
Yes.
And that's, again, that is a horrible thing to have in terms of a record for use of public money. Agreed?
Yes.
I'm going to hand you what I'm going to mark as Exhibit 4, and I think you'll agree with this. After there's a memorandum, then it usually ends up on an agenda.
Yes.
And I think it's on page 4 of the agenda. This specific agenda item, right?
Yes.
And the ordinance, it's called Ordinance 24-0256. That's the one we've been talking about, right?
Yes.
The ordinance reads, or the agenda item, I'm going to read it into the record so we can talk about it and make sure I read it right, okay?
Sure.
Ordinance authorizing an agreement between the city, I already messed up. I'm going to start over. Ordinance authorizing an agreement between the Corpus Christi B Corporation and Elevate QOF LLC for costs associated with FEMA AE flood zone requirements and exterior upgrades for homeowners suites by Hilton at the corner of Chaparral Street and Lomax Street, appropriating $2 million for a non-reimbursable grant from the Title D Economic Development Fund and amending the budget. Did I read that correctly?
You did read that correctly.
Okay. And it's during this meeting where Philip Ramirez had been used the altered slide, website slide, whatever you want to call it, that he had also used in front of the Type B board.
Yes, it was included in the presentation.
I'm going to hand you exhibit number 5 to your deposition. And do you recognize this as the February 27, 2024 agenda?
Yes.
And that is what was originally, back when this false narrative was going on, that was going to be the second reading to approve the ordinance.
That is correct. That was when it was originally scheduled, yes.
So, at least at this point, we see very clearly that the
Was that the stopping place, or is this an error? A technical issue? Okay. What was the... Hey guys. Probably like 30 minutes left. IT to the rescue.
Yeah, I see it.
Are we amenable to a 5 to 10 recess? Okay, it's 3:29. We'll come back at 3:39. Thank you. Recess for 10 minutes. Thank you.
Attention. Satellite SRGO1 is now overhead at 2,236.000 megahertz. Elevation 17.8 degrees.
Go gun brush. Five 87787.
And can you verify that 28 driving a 92 Dodge van, James Tucker out of Seymour, expired August of 2006? Ten for that's coming back to a title only.
Good.
Take it en route to the 1900 US 181 juvenile concern for safety.
Simple enough.
We'll be looking for a dark blue Toyota Corolla. In front of this door, the vehicle is not running. There's a 6-month-old child locked inside. The keys are inside the vehicle.
10-4. I don't believe I have a lockout kit. I'm gonna have to break the window. The RV I'm calling.
Eligible star 32 negative 29.
10-4, thank you.
Import, it is the mother calling in.
10-4.
Attention. Satellite intruder 2 is now overhead at 2261.500 megahertz. Elevation 32.9 degrees.
Just running up 39.
Do we have any negative? The mother did not advise. I can't attempt to call her back. 10-4. Unit 3069, can I get an individual? Yeah. We copy. One 59, I did not copy you traffic. It was mobile.
23. Do we have a lockout kit?
159, can you advise how long the child's been in the vehicle?
I got 4 down, 3 around, room for 3 behind brush.
Is the vehicle not on?
Alright, we're okay.
I need a rolling left.
10-4, so going to be red on flooding.
10-4, Portland, rolling left. 10-4, we're getting a moving route. Same high for our new message, for our new message. Station 2, Allegiance EMS, Station 2, Allegiance EMS, median route to 1900 US 181, 1900 US 181 Academy. We have officers on location for a 6-month-old that was locked in a vehicle, 6-month-old locked in a vehicle that was not running. The child is hot and sweaty. They want the child checked out. 1900 US 181 Academy. 210 route.
Recording.
10-4, 6-10. You recovered that one.
Set to go.
Good.
4 young John Frank. John. 4 young John Frank.
Power Peter. 59. Toyota Corolla 4-door gray 2.
Okay, so 5, 10-4, go ahead. 64.7, 64.7.
And that is what was originally, back when this false narrative was going on, that was going to be the second reading to approve the ordinance.
That was correct. That was when it was originally scheduled.
So, at least first reading has occurred on February 20th, right?
Yes.
And it's, as we see, it reads on the agenda. We see exactly what the words are there, right?
Yes.
And then those exact same words for the second reading appear on the February 27, 2024 agenda. Okay. And that February 27 was supposed to be the second reading of those same words describing the ordinance. It identifies that it's quote costs associated with FEMA AE flood zone requirements. Right? And that's how it's worded on February 20th and February 27. It's very clear that we have the same ordinance when we compare those two.
Yes.
Okay. Because it's the identical wording.
Yes.
Okay. And you said number 6.
Sure,
On May 7, there's a very clear articulation by my client to Mr. Zanoni saying, hey, basically you got to alter the item here.
March 7th. You said May 7th. Thank you.
And I think you'll remember on February 27th, it came off, it got, it's in the writing somewhere, to be honest with you, I think. Mm-hmm. It was basically postponed or tabled or taken off the agenda.
It was pulled off the agenda, yes.
Were you given information more detailed, like, hey, we got a problem because they've been showing everybody an altered federal website, screenshot, whatever?
I believe so. I don't remember exactly when I was told that, yes.
So somewhere in there, either that day or immediately afterwards, you heard it got pulled off because there was problems with it.
There were some questions, yes.
Yeah. And the question was, hey, have they been lying to us about this FEMA deadline, about this FEMA timeline?
Yes, that was being brought into question, yes.
About recent changes, right?
Yes.
Okay. And so that was because of this concern about it being some trickery, some misleading information, whatever word you want to use. That's your understanding that they decided to pull it off the agenda and look into it or investigate it.
Yes.
And you were involved in that investigation?
Yes.
Okay. And do you know if that investigation started, because we have this March 7 letter that is exhibit number 6. Do you know if the investigation started immediately after February 27, or did it wait until after March 7?
I don't recall.
Do you see that, first of all, Mr. David identifies that there are, in the first paragraph, his words, lots of questions.
Yes.
That he identifies that the project is well under construction and a fully committed project. You see that?
Yes.
And then his complaint or his concern goes on to say that then there's 1,510,000 identified basically in the memos that the city had done, right?
Yes. Yes.
That I know that number probably came from EDC, right?
Yes.
Okay. So there's this $1,510,000 and change, and he's complaining is for new FEMA flood zone requirements. You see that?
I do.
And he's saying, hey, you need to look at the presentation because the FEMA screenshot, he calls it what you call it, a screenshot.
Mm-hmm.
This FEMA screenshot in the presentation, he says it's remove the release date and remove the release number. Do you see that?
Yes.
Okay. And so at least by this point in time, March 7, do you think you had been made aware specifically that the release date and the release number had been altered?
Most likely.
And he says, he's honestly think he's just trying to be a little polite. Strangely, I'm going to quote, strangely, these are missing or hidden from the screenshot in the application. How did they disappear? Question mark. Did I read that correctly?
Yes.
Okay. And then he says, I'm attaching a screenshot of the actual FEMA portal where you can see the release date and see the release number, basically.
Okay.
So very clearly here,
saying,
hey, let the city know this slide, I'm going to use his word, screenshot, this screenshot of this federal information has been altered.
Okay.
He's saying that very clearly to you. Do you agree?
Yes.
Okay. And
Well, did not CDS be saying EMS was taking care of the problem
is, hey, this, you've said it's not good, horrible, whatever word you want to use from earlier. You were investigating why this bad thing had happened that was a document part of a package to give $2 million to the project.
Yes.
Okay. And Mr. David made that very clear that was the nature of his complaint, is that there's money being given for a project under these false pretenses.
Yes.
Okay. Then he goes on to say it's questionable about a developer using this excuse, meaning, hey, all these new FEMA things, because he's an architect and he's supposed to be looking at flooding, flood zones, right?
Yes.
And I assume you would agree, if you're going to do a $30 million building, you better do your homework way in advance on what the flood zone requirements are.
Yes.
And the FEMA requirements are, right? And that means he should have, and maybe did, I'm not going to ask you to speculate, he certainly should have known back as early, remember I showed it to you in October of 2020, that they were publishing the new FEMA flood maps.
Yes.
Okay. And you would certainly expect a project developer, architect, somebody who's doing a $30 million project to do their homework and be aware of that, not at the 11th hour, which is what they were pretending in front of Type B, but you would expect them to have done it early in the development of the project. And by it, I mean...
Yes.
You'll know that to represent the flood maps as being a recent development in 2024 is not really true, because we showed it to you where they were being published in 2020.
Yes.
Okay. Is it fair to say that you, let's ask you, that you agreed with Mr. David's criticisms that he's articulated that we just went over in this letter?
On face value, yes.
Correct. Well, and you did an investigation. You and who else were involved in the investigation?
The city manager, I think we had the Miles Risley, I believe was Miles Risley was involved in it. I don't know who else to tell you the truth. I don't remember.
Okay. I'm going to show you exhibit number 7 to your deposition. And leaving room for human error by my staff, they have transcribed a audio tape of Peter Zanoni and my client speaking. Do you understand what I've just told you?
Yes.
You understand we took a break and we're back on the record?
Yes.
And during that break, really just before the break, I think I handed you a transcript that's marked as Exhibit 7,
yes,
which is a transcription of a phone conversation between Ajit David and Peter Zanoni.
Yes.
And I think during the break we talked with your lawyer here, and,
yes,
and I extended the courtesy of actually playing the audio tape so you could see it or hear it while you're also reading the transcript?
Yes.
Okay.
Yes.
And was that helpful to you getting an understanding how the conversation went?
Yes, it was very helpful. Thank you.
But it's clear from the context of the discussion between Mr. David and Mr. Zanoni that they're talking about the same issue I've been asking you questions about, is this darn altered, and the word he uses is a United States federal porthole.
Exactly.
Okay? And the word that goes unscathed in the discussion between Peter and Ajit.
He has one power on Ocean Drive, but it's on the opposite side.
With a United States federal porthole.
Yes.
Anybody to dispatch? I need a private feed again.
I'm using now their words, and without me making them up or you making them up, and without them being your words, you don't have any reason to disagree with that characterization.
Okay.
No.
That's
in the conversation. It was clearly talking about it in the discussion.
Yes.
Okay. And so, is it okay then if we refer to it, at least while we're talking about this recording, as being the concern here was the tampering with a United States federal porthole?
Yes.
But by this point in time, we're between the first reading and the second reading.
Yes.
So we know we're between February 20 and April 23rd.
That is correct.
And during that time frame, it's very clear that Peter has full knowledge that this tampering with the United States federal porthole has occurred.
Yes.
And it's very clear he is the one that characterizes it or uses the word scheme.
Yes.
And he actually goes into an explanation about how, there was a need for an infrastructure component, so they made up this FEMA thing, and it was a scheme to basically get the money. That's all in there, right?
Yes.
And it was a scheme to get the money that was and my scheme is the tampering with the United States federal porthole, right?
Yes.
To get $2 million, and correct?
Yes.
And is that consistent with what your investigation is?
Yes.
Yeah. And repeatedly, because of the realization that it was a tampering of a United States federal porthole scheme to get $2 million, Peter repeatedly said that he was not going to recommend it to council, right?
Yes, in this conversation, yes.
But let's at least kind of set the table for the shift that's occurred in advance of this April 23 meeting. Is
William Mary John 7324, William Mary John 7324,
costs associated with a street level retail, public space, and outdoor dining area, right?
Yes.
And those are new words.
Yes.
Compared to the first memo.
Yes and no, because in the first memo it does talk about which I pointed out earlier, it says the exterior upgrades, the exterior upgrades, and I think it goes into the exterior upgrades and leased spaces.
Well, you did more than that. You took FEMA out.
Yes.
Okay. FEMA's now not the headliner.
Exactly.
And the reason you took the headliner out is because it was a big realization, and you can hear it, and I saw it on your face when you listened to it during the break. It's a terrible thing that was being discussed between Peter Zanoni and Najib David, correct?
Yes.
Okay, and y'all didn't want to touch that with a 10-foot pole again in the second reading.
No, we provide clarification because the Type B board...
Well, you threw FEMA out.
Because that wasn't what the Type B board...
For whatever reason you want to say now, you changed it.
Yes.
Okay.
Yeah.
And now we have the words we just read into it, and on the summary it says it's for, quote, for costs associated with the development of street-level retail, public space, and outdoor dining activation, again, emphasizing those things and removing FEMA the way it had been expressed in the first memo. Correct? Yes?
Say that again?
It's putting those words in and removing the FEMA words that were in the first memo.
Yes.
Okay. And then on background, it says again, for costs associated with the development of street-level retail, restaurant, and public spaces to be built along with the Homewood Suites project.
Yes.
Did I read that correctly? And again, those are words that were not in the first memo, and you've removed the words about FEMA that were in the first memo.
Exactly.
Okay, so you're saying that the $2 million was awarded based upon FEMA flood map changes? And so the fraud? I mean, we've already said that's a fraud to have represented it or misrepresented it the way they did, right? You sure you want to? We've already said that. Agreed?
Yes.
The first time it had the fraudulent representation in it as the banner reason for getting the $2 million, right? That was the headline.
Yes.
Because you've told me the results of your investigation is you concluded it was in fact tampered with.
It was, it did not reflect what was on the screen, yes.
Right, which the way the way Peter is talking about it and everybody without objection is they're using the word tamper, and so we don't have to.
Sure.
It's a pretty important conclusion when you conclude that a federal document used to get $2 million was tampered with. Agreed?
Yes.
You pointed out a few different times that the slide that we've talked so much about was a screenshot of a United States federal FEMA portal.
Yes.
Okay. And you recognize, though, that taking a screenshot, is a form of recording information?
Yes.
And so for purposes of what I'm looking at right now, if it says a writing includes a printing or any other method of recording information, then the screenshot would fall in that definition of a writing.
Yeah.
Okay.
What is it the exact report?
And removing information from it, from that writing, specifically removing the release date and at another location removing the release date and at another location removing the reference date, that would be a form of altering that writing, correct?
Yes.
But leaving the FEMA logo on it certainly makes it appear as though it is a authentic screenshot of a FEMA writing.
Yes.
Because when you just look at it, you think, hey, that's FEMA, this is what I'm looking at is FEMA, right?
Yes.
Did anything in your investigation in any way, shape, or form suggest that FEMA had approved altering their document by removing the release date and by removing the reference number?
No.
And you understand it was someone other than FEMA who altered the document, right?
Yes.
Correct?
Yes.
And that someone else, whether it was Philip or his staff or whoever, did so in such a way that it gave it the look that another, i.e. FEMA, had published the document in the way they showed it to you, the city council?
Yes.
The way it was presented, in other words, to the Type B board and at the first reading to the city council, this altered writing made it appear as though it was a screenshot of the original, right?
Yes.
Even though there is no such original, because the original actually has the other information that they removed.
Yes.
$47.95 from Dr. Carl back in jail. After beginning.
So if I give you this definition that forge,
64.0, 64.0.
that forge means to alter, make, complete, execute, or authenticate any writing that happened, right, so far?
Yes.
So that it purports to be the act of another, like FEMA, that happened, correct?
Yes.
In this case. Who did not authorize it, and we talked about FEMA didn't authorize it, right? That happened in this case.
Yes.
I'll be at 138 Catalina, just for a minute.
Definition of forge, then the facts of this case meet that definition.
Yes. Yes.
I'm going to give you another definition of forge. That forge means to be a copy, to say, hey, this is a copy of an original, when in fact no such original, like we see in the slide, exists. Do you understand?
Say that again?
Yeah, if I purport to, hey, this is what it looks like, and no such original exists that looks like that, then that's a forgery according to what I just read, I think, but I want to say it to you again. You understand where I'm going?
Yes.
I'm giving you a second definition of forge. Forge means to be a copy of an original when no such original existed. Do you understand the definition?
Yes.
And we have that in this case.
Yes.
Okay. Those are two different definitions, and both of which you have agreed those facts are in this case to meet that definition of forge.
Yes.
Okay. Alternatively, I want to give you another definition of forge. That would be to utter a writing, in other words, to say the words.
Okay.
And I'll read you the whole thing. Forge is also to issue, transfer, register the transfer of, pass, publish, or otherwise utter a writing that was forged within the meaning of the things we've agreed or you've now agreed were forged within the definition.
Okay.
And in fact, making the presentation and representing thereby that this forged document was authentic, the utterance of it becomes forgery. Do you understand?
Yes.
And that happened in this case, right?
Yes.
It is also alternatively a separate definition of forgery or forge if you possess a writing. You know, we've defined writing earlier.
Yes.
That is forged within the meaning of the first two definitions with an intent to utter it in a manner.
Am I renewing? Am I going to renew
That's
or am I
within the preceding definitions I just gave you. Okay?
Yes. Yes.
That happened in this case too, right?
Yes.
That's all subsection A of what I'm looking at. In subsection B, then, you're going to figure out what I'm reading from in a hurry here. I'll just tell you. It's Texas Penal Code 32.21. And I know from your background, it's not just that I'm interested. I wanted to know your background in terms of looking at things, and this is the sort of thing your background has led you to be educated about.
Yes.
Okay? Because when you're doing compliance auditing, when you're working with Arthur Anderson, when you're working with the city of course, but also the city of San Marcos, you're supposed to make sure you keep things. It's your job and the jobs you've had to keep things in compliance with the law.
Yes.
And so You probably even knew at the very beginning I was reading from a statute. Did you? Probably,
yeah. Either that or a very sophisticated dictionary, one or the other.
Yeah. And that it is according to this Texas Penal Code statute 32.21, subsection B, a person commits an offense. You're used to seeing that language and interpreting it, right?
Mm-hmm.
Say yes?
Yes.
A person commits an offense if he forges a writing with intent to defraud or harm another. Do you understand what I read to you?
Yes.
We've already talked about this being a fraud, right?
Yes.
And next section talks about are you familiar that in Texas statutes that the degree of the offense sometimes has to do with how much money's involved? Now, the steal a candy bar, it's a worse offense if I go steal an automobile?
Yes.
Okay. You understand what that in Texas law? You've probably seen that many times.
Yes.
Okay. And so I'm going to skip down to, I think it's E1. It says if it's shown at the trial, basically, that an actor engaged in the conduct to obtain or attempt to obtain a property or service, an offense under this section is, I'm going to skip down to part 7, a felony of the first degree if the value of the property or service is $300,000 or more. Do you understand what I just read you?
Yes.
And we can agree that $2 million is more than $300,000.
Yes.
Okay. And I know, look, you don't get to be judge and jury. I'm going to relieve you of that responsibility.
Yes.
Okay? And you're not here to do that. Fair enough?
Yes.
But do you know, as you sit here, given your background, of a reason, and I'm going to grant you, you don't know what's the intent of whoever exactly altered it. Fair enough?
Fair.
And it rarely happens that somebody comes to the courthouse who's accused of a crime and says, I intended to do it. Fair enough?
Yes.
But understanding that, do you know of any factual reason that came up in your investigation that would preclude the application of this penal statute?
Factual. Say that again.
Yeah, I'm trying to give you permission to not try and be in the mind of the people who actually altered it, because I'm not asking you to do that.
Okay.
That would be unfair, I think.
Yeah.
Okay, true?
Yes.
Okay. But in the course of your investigation, did you find any facts that you can tell me now that would preclude application of this penal statute?
No.
Offer from the deposition of Heather Holbert, and we have Peters in on next. We can get most of it done if you want to roll it.
I'm sorry?
I think we can get most of it done. Maybe all of it. We'll see.
It's at 1:14.
Okay.
All right, that's fine. Thank you.
State your name, please.
Peter Zanoni.
Do you understand, of course, that you've been given an oath today?
Yes.
You understand there's a written record being done and a video record being done?
Yes.
What did you do to prepare for your deposition? Did you review any videos?
No video.
Okay.
Yeah. Excuse me, one video.
So the video that you looked at yesterday in preparation for your deposition, your recollection is you were viewing that and it was reminding you or showing that you had talked about the document and that it looked like it had been tampered.
Correct.
And that the document that had been tampered with, I think you and I probably both know, was a screenshot off of the FEMA website.
Correct.
Okay. And did you look at any other videos?
No other videos.
And on the ordinance we're going to talk about today, it didn't have that magic language, correct?
I wouldn't call it magic language, but it did not have that. Did not have that by my direction.
And usually that language would be there saying staff recommends, but on this one proposed ordinance we're here to talk about today, it did not have that language.
That is correct. It did not have it.
Okay. And is this the only ordinance that has gone in front of the city that has ever lacked that language that says staff recommends?
I'd like to answer it, which is that, to my knowledge, about in the 6 years, if you count how many ordinances and resolutions and motions, has been a lot. I don't even want to guess at a number. But I would think it's fair to say that this one is probably about the only one that did not have a recommendation. There may be others, but to my knowledge, this is to my recollection, I'm not looking back at years of ordinances, but just intuitively, I would think this is the only one.
I want to get a few definitions with you since we're going to be talking about some things that I think are coming up.
Okay.
I'm going to start with a real easy one, and I jumped online and literally found I went to Webster's.
Okay.
And found the definition of same, and I'm going to read each one real slowly, just the word same.
S-A-M-E, same, you say?
Yes.
Okay. Okay.
Resembling in every relevant respect. Second definition is conforming in every respect. Third definition is being one without addition, change, or discontinuance. Then it says identical. Next definition is being the one under discussion or already referred to. And the next definition here is corresponding so closely as to be indistinguishable. Do you agree with those definitions?
I do.
Do you have any different anything in those definitions that you think is missing that we need to add a different definition of same?
I would just add it would be exactly alike, you know?
Okay.
Yeah, exactly alike.
What I want to do is give you an opportunity to look at the penal code.
Okay.
And that forge means to alter, make, complete, execute, or authenticate any writing so that it purports to be the act of another who did not authorize it. You understand that?
I do.
And forge also means to be a copy of an original, that you present it as a copy of an original when no such original exists. Can you understand that one?
I do.
And I'm going to scroll down because, like any statute that defines forgery, of course it says forgery is an offense. It's not going to surprise you, right?
Right.
And then, like any offense, you know, if you go steal a candy bar, it's not as big a deal as if you go steal an expensive automobile, right? Okay, so the portion I scroll down to is the portion that is a felony of the first degree if the value of property or service is $300,000 or more. Do you see that?
I do see that.
Do you understand that definition?
I'm not sure what a felony of the first degree is, but yeah.
Okay.
Yeah, but I understand the definition.
They classify them, and so you understand a felony is very bad, I'm sure.
Yes.
Okay. And a first degree, I'll tell you, that's worse than a third degree, okay?
Okay.
Then Exhibit 2, I'm going to show you the definition of criminal responsibility for conduct of another. It's Section 7.02. And it says that a person is criminally responsible for an offense committed by the conduct of another if with that intent he causes or aids an innocent or non-responsible person to engage in conduct prohibited by the definition of the offense, in this case forgery. Do you follow me?
Understood, yes, I do follow you.
And I'll show that to you just as Exhibit 2. I just want to make sure you understand that.
Yeah, I see it.
We mentioned earlier that we're here to talk about a specific ordinance, and that was one where the City Council was considering, there was a first reading and a second reading about $2 million and some issues we're going to discuss about that. You know that, right?
I do know that.
Okay. And I believe, though, that process actually starts at the CCREDC.
That is correct.
And you know that based upon the CCREDC process, they could not recommend $2 million.
Correct.
And I have in front of me, I'm going to mark it as Exhibit 3, the slides that were used at the Type B board presentation.
Okay.
It's my highlighting.
Okay.
I don't want to confuse you.
Okay, yeah.
And the applicant was there, having gone through the CCREDC process, now in front of the Type B board, and made the presentation with the slides that we are looking at right now, or something like it.
Yeah, I'm not for certain if it was the applicant or Mike Coplison, but
if the video shows Philip Ramirez doing all the talking, that's not going to surprise you, right?
Right.
Okay. It's recorded. It's recorded, right?
Okay, good, yeah. It is recorded, yes.
Yeah. And one of the slides, I believe it's the second slide, and let's go ahead and just for some context.
Okay.
I'm going to show it on the camera real quick.
Sure, no problem.
That's the first slide.
I actually performance demo
And then
video.
the second slide's the one we're going to be talking mostly about. And that's the second slide.
Is it all right if Peter gets up where he can see?
I'm going to show him right now again.
Well, I want to make sure that what's on there is what he's seeing.
Yeah.
Okay.
The second slide is the slide that has what I think we all know now was a tampered or altered document, right?
Yeah, correct.
And the portion I highlighted is that in the presentation, and it's on the slide, it says on the slide specifically, project was reimagined in July 2022 as a 126-room hotel project. Did I read that correctly?
That's what it says there. You read it correctly.
Okay. And so at least we know that the sort of the beginning time, the moment in time that they imagined doing a hotel project, the applicant was apparently, at least according to them, July of 2022, right?
Correct.
I'm going to just read you some of the quotes, and I'm not going to ask if you remember, did they say it that exact way, but I'm just going to ask if you remember hearing the gist of what I'm quoting, okay?
Okay. This is at the Type B board meeting?
Yes.
Okay.
That at the Type B board meeting, the applicant, or Mr. Ramirez, at the Type B board meeting, Mr. Ramirez said things like, one thing that came up that we weren't anticipating, the FEMA maps were preliminary, but they became finalized. Things like it kind of hit us midstream, it threw us for a little bit of a loop. Quote, it did certainly throw a wrinkle and an aspect to the project from a constructability perspective, but also just added costs that we were not anticipating. So we had to mitigate these new requirements. You remember things along those lines being said?
I do, yes.
And do you remember the upshot of that? The gist of it was that Philip was representing at the Type B board that the FEMA floodplain rules had recently changed.
Correct.
I'm going to show you exhibit number 4 to your deposition. And this is a screenshot of the same FEMA website that you looked at a moment ago. But it's not been altered like the one used during the Type B presentation. Do you understand what I'm saying?
I do, except the one we saw a moment ago was not the website, but it was a PowerPoint presentation.
Right, it was a screenshot of a FEMA web page.
429 B FRO receipt third-party information. Citizen stopped by her residence after seeing the unit work there.
Okay, if you can let our dispatch know that we're going on concerns as well, our bridge is not working. Good, Ted.
Yep. 44 is probably best for that. Okay, 10, so I'll start heading back in a minute.
And if you compare that to the one that was given to the Type B board,
Just drive on the very edge, guys, on the very edge. Just watch the driveways.
I did not.
so in other words, you believe that the Type B board voted to approve the award of the $2 million, not knowing that there had been this altered federal document.
Correct.
I'm going to also show you Exhibit 5, which is another FEMA, me capturing a website and making it a slide or an exhibit to your deposition.
Okay.
And me show that to the camera just real quickly for you too.
Yeah.
Can you tilt it up a little bit? There's a glare from the studio like that.
9502, the city of Christi 7.
Got it.
If you look at that this exhibit, then you can see. And by the way, let me back up. We know government doesn't move at a lightning pace. Fair enough.
Fair enough. Yes,
Okay.
sir.
And things like FEMA rule changes typically take years. Correct?
I'm not for certain, but I think they would take time.
Okay. And usually whenever there's federal regulation changes, it's real common in the public sector to publish drafts or preliminary proposed rules or whatever it is that you're changing and to give an opportunity for comments, right?
Correct.
Okay. And from the exhibit that I just showed you, can you tell that in fact, at least back as far as 2020, years in advance of the December 2023 Type B board meeting, that these new or proposed, revised, whatever you want to call them, FEMA rules had been out there in the public domain for years, correct?
I was not aware of that, but if the evidence shows that, it sounds plausible.
Yeah, I mean, and that would be kind of typical of how government moves.
Correct.
And that certainly flies in the face of the suggestion by Mr. Philip Ramirez that these had been unanticipated or, somehow caught them by surprise. Fair?
Fair. It's one of our points we had when we talked with them.
Yeah.
When I talked with them personally.
And we talked about that apparently the Type B board voting at a time when they did not know there was a altered or forged slide, and voting on an amount that had not been recommended by the CCREDC, they nonetheless gave a vote yes to have the award of $2 million considered by the city council, right?
Correct. Correct.
And that leads into an agenda memo being created by your staff to have that matter put in front of the city council and on the city council agenda.
Correct.
I'm going to show you what I'm going to mark as Exhibit 6, and this is the first agenda memo. Excuse me, this is the memo for the first reading. Fair enough? That's fair enough. Does that appear to be the memo for the first reading of the ordinance we're talking about?
It appears to be based on what I read, yeah.
Yeah. And so this agenda memo, I think, would have been prepared, it says, from Heather Holbert, okay?
Correct.
And it has the first reading scheduled for February 20th, and the second reading, it says, is going to happen on February 27th, right?
That's what it says, yes.
And it identifies a possible award, Type B money, for $2 million. It says, quote, for costs associated with FEMA AE flood zone requirements, right?
Correct.
Further down it says the grant request will be utilized for additional costs associated with newly defined FEMA AE floodplain flood zone requirements.
Correct.
And that PowerPoint presentation that is then supporting this first reading had that altered slide in it again.
I haven't seen it, but I believe it did.
I don't think that's in dispute. It's recorded.
Yeah.
I want to make sure I understand what when you say, I don't think I was aware, you mean you don't think you were aware there was an altered slide at the time you put on the first reading?
Correct.
I'm filling in the pronouns.
Okay, thank you. Otherwise, I probably would not have put it on for the first reading.
Yeah.
So, yeah.
And if you don't put it on for first reading, obviously it never passes.
That's true, yes.
Now I'm going to show you exhibit number 8, which is labeled Video 1. And they're going to put it on that screen.
Dispatcher on 34, going to get a private on 3049.
What I wanted to confirm is then just this progression from the agenda memo talks about costs associated with FEMA, and then the agenda item talks with costs associated with FEMA, and when the mayor reads it in the public, she says for costs associated with FEMA. Okay. And again, at that point in time, when you're in that meeting at the first reading on February 20th of 2024, at that time, is it true to say that you don't think you knew I think, because otherwise you said you would never put it on, that you were still in the dark about there having been an altered federal document.
Correct.
Okay. Go to video 2. This is marked as exhibit number 9, and it's from that same meeting.
Okay.
129, I'll be assisting this man with a ride to the area of Athena Street.
Yes.
Starting mileage 1918.
So as a banker, when you invest in a new project or go into a new project with someone, you're not going to check the flood zone first when you're building? Yeah. That's the big concern I have. As an insurance agent, that's the first thing we check. You can't even start building the building until it's insured. So when you're building in a flood zone, it has to be already checked. So why are we doing this?
Because it changed.
6 months after.
It changed.
It changed. It was, the rules had come out later.
We've
been working on the rules for 2 years. You can expect those changes 2 years ago.
They did change that.
Do you hear both the mayor's voice and also Councilman Hunter's voice on there?
I do, yes.
And is it clear that Councilman Hunter, whatever background he has, and he's describing a little bit on his speaking or during his speaking, that he is questioning, hey, how is it that you can say that should have been the first thing you looked at, basically?
I heard that and I agree, right.
And you were there at that council meeting?
I was, yes, sir.
And so he sort of, and I know later in time you said the same thing, I assume you remember that, but at the meeting, Councilman Hunter is clearly saying, hey, how can this be true, basically, because...
649, 1042.
Yes, if I'm hearing it, but I'm asking you, do you hear it that Councilman Hunter is sort of questioning the truthfulness or accuracy of some of the information, right?
Correct.
And the mayor's trying to correct Councilman Hunter and say, no, like, aren't you listening? It changed, right?
Right, I don't know about correct, but speaking alongside him, saying those words, yes, it changed.
Yeah. He's talking, she kind of bumps in. He talks, she bumps in. Right. He talks, she bumps in, right?
Correct.
That meeting, I think we had it at February 20th, and I know then at least by March 7, my client had sent you an email. Let me show that to you, and we'll mark that as Exhibit 10. Let me give you an opportunity to refresh your recollection about that.
Okay, good.
Mr. Zanoni, during the break, I think I gave you an opportunity to review what I marked as Exhibit 10, which is an email dated March 7, 2024 from my client to you, right?
Correct.
And overall, it's an email that is relating to the altered slide, correct?
Correct.
And in the email, first he points out that it was a project that's already under construction, and he says fully committed. That's in his email to you, right?
Correct.
And you probably understand the reason that he's doing that, my client's doing that, is because the rule really is that you don't get money for a project because it's incentive money if you're coming already to town, right?
Correct.
Okay. And then the email goes on to explain and really refer to the attached presentation, which is the same slides we've been talking about, right?
Correct.
And it says, quote, they talk about pandemic-related cost escalations, $489,000, I'm rounding, for exterior upgrades and $1.5 million for new FEMA flood zone requirements. Did I read that correctly?
That's what it says, yes, you know.
And he says, take a closer look at the FEMA screenshot in the attached presentation. This is my client to you saying that, right?
Correct.
And then it goes on to say, quote, every FEMA notice clearly has the release date and release number. Strangely, these are missing or hidden from the screenshot in the application, right?
Correct.
So my client is telling you, kind of letting you know, hey, this slide has definitely been altered.
Correct.
Okay. Then he goes on to say it's rather questionable that the developer is using this as an excuse to seek incentives, meaning the money, right?
Correct.
And that the development team on this project includes a local architect, referring to Philip Ramirez, right?
Correct.
Who should in fact be very well versed with flood maps, FEMA requirements, etc., right?
That's what it says, yeah.
And then if you scroll down, what he attached for you, or one of the things he included in this email, was a screenshot of the unaltered federal FEMA information.
Correct.
Which highlighting, he puts a circle around it, the release date, and then the second time it tells you the release date and also the release number.
Correct.
And the reason he's doing that, obviously, I think you probably understood at the time and now, the reason he's doing that is to draw the contrast. He's saying, here's what the real document is, that if you go look at the slide used during the first presentation, the first reading of the ordinance, it's very clear that it's been altered by somebody, right?
Correct.
But at least by March 7, you had a very clear piece of information that somebody had used a altered, forged federal piece of information, got it from online and forged it, and they were using it to ask for $2 million of public money.
Yes, that's what it is.
And like you said earlier, that would have essentially never made it onto an agenda item. It would have been disqualified. And so that's important news, even though it's after the first reading.
That's correct.
Okay. And that actually led them to a phone call, and I think you know it's a recorded phone call at this point in time, right?
Yes.
Yeah. And I want you to hear that so it's fresh in your mind, and I'm also going to show you the transcription of it.
Okay.
If you're like me again, I like to hear it and see it at the same time. It helps me make sure I catch it all.
Okay. Yeah.
And that transcription is going to be marked as Exhibit 12 and the audio recording as Exhibit 11. Okay?
Okay. What was the date on it, Don?
It refers to, I just know this from the top of my head, I think it refers to the next meeting, not this Tuesday, but a week from tomorrow, which to me, if that's a second reading, the second reading was on April 24th, 23rd, and so 22nd, a week before that, I'm going to say around the 15th. Of April?
Of April, okay.
That's my best understanding.
Okay.
Okay, it's clearly between the first reading and the second reading.
Okay.
Okay.
The requested information I asked from the applicant. I don't have that. They haven't given it to me. And so until then, I'm not giving any recommendation. I'm putting it on the agenda. I was asked to. And I say you can consider it. You have to come up with your own recommendation.
Got it. But you did let the city council know that there were some some improper information, some tampering and all that involved also. You let them know?
I don't know. We'll let them know again tomorrow in executive session. I already have an executive session posted.
Okay. Because when does the executive session happen? Does it happen towards the end or?
No, when we break for lunch, most likely. I can't remember how many items are on there, but probably on the first break, the lunch break, so like 2:30. Yeah.
Okay, is it after public comment or before?
Oh yeah.
Public comment or before?
Oh yeah. No, it's after public comment.
Okay, no problem.
Yeah. Yeah, after public comment.
Yeah, I was just surprised that council is still willing to consider this after they know what was done. And on that website, on the FEMA website, it even says this is a United States government portal.
Yeah.
On the very top.
Yeah, definitely. Right. It was all done. And then when you read the entire PowerPoint, it's so obvious that the reader or the writer wanted one to be led to believe that the FEMA was just recent, even words like recently released and this. And part of it goes back to the narrative. Mike Culbertson said, hey, we can't, this has to be tied to infrastructure. And so then they catch the scheme that, okay, FEMA floodplain, that's infrastructure. The fixing the bottom floor so it meets the floodplain, and they stuck with it.
Got it.
And then they develop a narrative to fit it that they just found out, because people would say like, shit, they should have known about this a long time ago.
Yes.
Like Councilman Hunter. So I think, I think people right now, the council right now, seem like they're strong and they're going to vote, but we've seen it time and again that once one or two or more start talking at the council citizens, they change their mind real quick.
Yeah.
They could ram it through, but it's on them. I know I'm not recommending it because I don't have the information I need.
Mm-hmm.
I'm going to have to cover it. Even if they send something that said this is what happened, okay, I'll believe you. I'll put it on. But they haven't even sent me shit, and instead they want my lawyer to send them, ask for them over an hour, and I'm not doing that. So, so if council asks me between now and next Tuesday, my answer is this, which is that I can't recommend anything because I'm still waiting on information to develop a recommendation. However, because the council wanted this on the agenda for them to consider, it's on, and you all consider what you want to do. And the applicants are supposed to be in the room. You can ask them.
That's right. And how difficult would this be? If you ask somebody, hey, we're going to give you $2 million, just give an explanation for this. And if they're not in a position to give that to you, the council still wants to give them $2 million. When you ask for $2 million, the least you can do is, hey, just give us an explanation, the money is yours. But even that is not happening.
Right, exactly. As of right now, that's not happening.
No.
But the vote will be not tomorrow, but the next Tuesday. This will be the vote.
No problem. Anyways, I think if you think it's okay, at least in that way you're clear in your stance. It's going back to council, so no one can blame you for that because you did the right thing. You did not really recommend council to approve it.
Right. I changed the recommendation of that because that's what it had initially. I'm not approving this. I'm not recommending to approve this.
Got it.
I'm recommending they can consider it. That means they consider what they want to do. Look at any other agenda memo on the council meeting. It always says that they should always say staff recommend blank. Yes, no. That's our job. Otherwise, you don't need us. But in this case, and very few exceptions, if we don't agree with the council, I'm not going to fall on my sword for that shit. I asked those guys to give me information, they didn't give it, so I can't make a recommendation. But because our form of government, there's 3 ways you can get something on the agenda. Sure. In this case, the majority of the council, or at least 3 council members, want it on the agenda. Okay, I'll put it on the agenda. You guys figure it out.
No, that's fair. That's fair. I bet you it's more than likely it's Roland and the mayor and maybe Dan Suckley also will be in support. But that's okay. That's
They told me 7. Somebody told me today there's 7 yeses and only 2 no's.
No problem.
Yeah.
Over to this. Okay, Peter, I get an idea. Okay. So I'll just stop by tomorrow.
Make sure you do what my position was, because I'm not recommending it, but I'm putting it on for them to consider.
No problem, Peter.
Yes, sir. Okay.
Okay.
Thank you.
Take care, Peter. Thank you. Bye-bye.
Okay, yes, sir. Okay, bye-bye.
Does that recording sound like a true and correct recording of a conversation you had with my client?
It does.
But We have the March 7 email where by that point in time clearly my client had told you that this has been forged, and then now we're more mid-April and you're speaking obviously with some knowledge of what is an ongoing investigation, I think.
Correct.
But one of the common themes, back to what I was saying just a moment ago, is you were clearly in this still fact-gathering time frame where you had asked for an explanation about how there was this altered federal document, and you're waiting for the applicant to get you that information.
Correct.
And you're very clearly saying in this recording, because you're not going to give a recommendation unless you get closure on that issue or some reasonable explanation.
Correct.
Yeah. And I think at the very beginning of recording you said, quote, until then, I'm not giving my recommendation, meaning exactly what I just said and you agreed to, right?
I agreed to then and now, yes.
Yeah. Outside of executive session, did you let some of the council members know?
Yeah, and I'm glad you said it that way, because I didn't sit down with all council members, all of them, either individually or collectively, to let them know, but the council members who had interest in this item would often call or come visit me. So when I was engaging with council members individually along this continuum of time, I let them know that brought to my attention has been what appears to be a forgery of a federal document tied to this award of money.
Who did you let know, let's say, in this March, I guess from sometime probably after March 7 and before the second reading? Fair enough?
That's fair enough, and I don't know, from memory I'm going to tell you who I believe I told. I may have told others, but I'm not for sure. But I know I told the mayor. I know I told Councilman Roy, Councilman Pusley, and maybe Councilman Suckley. But for sure, Pusley and the mayor in one phone call. It was right after I had met with the architect, and then Councilman Roy was meeting with me and talking with me frequently, so him as well.
Okay, who did you tell shortly after you met with the architect?
The mayor and Councilman Pusley, I believe, called me around 5. I was picking up my son at the.
Okay.
It was around the 5 o'clock time frame. I believe it was that same day.
Okay, and you made a reference, and so I'm going to go back to it because it's a little bit, we're taking it out of sequence, my fault. You referred to a meeting that you had with Philip Ramirez, right?
Right.
I think that, and I have this dated by another information with Sony, okay? I think that happened probably on or just before April 8, about a week before this recording. Does that sound about right?
Probably, because I'm referencing it in that recording.
Yeah.
Yeah.
Okay, and the way that Sony had described it, and I understand we took his deposition yesterday.
Yes, I understand.
Okay. He described it as, one of the words he agreed and recalled saying to my client shortly after the meeting was that Philip was stuttering. Do you remember that?
I remember, yes.
And also just his description couldn't complete a sentence. Do you agree with that?
I agree with that.
Fair, very fair. I appreciate that.
Yeah. After I interviewed Philip, I did that same evening, I believe, have a conversation with the mayor on the phone, and Councilman Pusley was there either.
I'm sorry, I need to make an objection.
There was a three-way call. I'm not 100% sure.
Sorry, can you pause the video?
Yeah. There was a leap over a portion that was not played. And so just for purposes of optional completeness, I'd like to just read
Can you raise your mic? I'm sorry.
I apologize. I'm sorry. For purposes of optional completeness, I'd just like to read one question and answer that's found at the bottom of page 67. And it is just simply this. And that was in reference to after the phone call, after the meeting with Philip Ramirez. Okay. And so it sounds like after you had this meeting with Philip, is also when you talked to the mayor and told her that it was a forged federal document. The answer was, I don't know if I told her that exactly, but I did tell her that the meeting I had with Philip did not produce information we were looking to get from Philip, which was simple. which was that this document was changed. How did it get changed? You're the author of it. Thank you. That was page 67, line 20 to 68, line 3. Sorry for the interruption. Sure. Page 67, line 20 to page 68, line 3.
Thank you.
Yeah.
01179916. That was after the meeting with Philip, and so I explained to the mayor that Philip, who would be the only one that could explain what happened to this document, could not explain it. And so there was an obvious change in the document from the website to the PowerPoint. And the only person, well, there were probably two people that could have explained it. One was Mike Culbertson and his team, and then the second one would be Philip Ramirez and his team. And I believe we had a conversation with Mike Culbertson to rule him out and actually ask for a copy of his PowerPoint presentation. And who created it? Did he create it, or did Philip Ramirez create it? And Culbertson said that the PowerPoint was created by Philip Ramirez, sent to Mike Culbertson, who did nothing to change it, and just placed it into a template that had EDC heading on it. And that's why we ruled out Culbertson as somebody that may be aware of or may have changed the document, and then started working with Philip Ramirez as the sole person that should know what happened to the document.
And what you just told me is what you told the mayor.
Correct.
In the phone call soon after the meeting with Philip.
Correct.
So at that point in time, then you are still communicating to both of them that this is something you cannot recommend.
That, yes, and that they should be concerned about it.
Yeah. And did you speak to the mayor about it on any other occasion?
I'm not for certain, but I probably did.
I'm going to jump ahead a little bit just because I think it'll help you in what we're talking about here in terms of time frame, and show you what I am going to mark as Exhibit 20, and it is the second agenda memo. In other words, the one that comes out in advance of the second reading. Agree with me?
Yes.
And it has a date on it of March 11, 2024, and down at the bottom it says recommendation, staff recommends City Council consider this agreement on second reading, and so forth.
Okay.
Did you hear me?
Yes, it is.
And you know there's a big distinction here, right? In other words, this document, which is Exhibit 20, you've gone from staff recommends to staff is saying consider it.
Right, for the City Council to consider it.
Right, you've withdrawn your recommendation, staff has.
Correct.
Okay. And go ahead and satisfy yourself, Exhibit 20, that is that second memo.
Okay. Yeah.
Correct?
That's correct.
Yeah. And so here you are, you have the March 7 information that Ajit sent you, my client sent you in the email, right?
Correct.
You have the March 11 memo that I just showed you, Exhibit 20, where by March 11th you've already changed your recommendation because at least by then you clearly had not been given a satisfactory explanation on why it was okay to alter a federal document, right?
Right.
And then on about April 15, mid-April, about a week or so, a little more than a week ahead of the second reading, you're clearly still of a mind that I'm not going to recommend it, right?
Yeah.
But at least by March 7, you've gotten the information clearly that there's been this federal document altered that is forming a basis of the request, right?
Yeah, what was the date of Ajit's email?
March 7.
Okay, that's correct.
And then on about about April 8th, approximately is when we know the meeting was with Sony and Philip there, where there was not a satisfactory explanation given.
Okay.
You with me?
I am.
And I'm just trying to get the timeline with you.
Yes, sir.
And then on about April 15 or so is when you have the conversation with my client that's recorded.
Okay.
And then the second reading was on April 23rd, Okay?
Okay.
But at least somewhere in there, it looks like for quite a period of time,
Right.
you were very clear, I'm not recommending it.
I don't know about that whole duration, but as I tried to conduct my investigation with Philip and others, it became clearer that nobody would explain what happened to this document. And so as I got closer to that council agenda time frame, it made sense to me to not recommend anything because I had no answers.
And, of course, I'm a lawyer, but I'm going to say this anyway. It's not a good sign when you're requesting $2 million of public money and you can't come up with an explanation, and instead I give the city attorney my lawyer. Agreed?
I would agree. We weren't happy with that.
Yeah. And I'm going back to the recorded statement. I'm actually looking at the transcript. I had you read along with it.
Okay.
In that recorded statement, you do say, I let them know about the tampering, and those are the conversations we've already talked about, I take it?
Right, yeah, like the mayor and Pusley, for instance, yes.
And are there any others that you can tell me about that you haven't already told me about, or you think we've covered that?
When we talk about the tampering, there was an executive session where this item was presented. I don't know to what extent I can just talk about what happened in there, but generally this type of topic was discussed in that that was the purpose of the executive session.
I understand that you talked to the council in executive session about this subject matter. Do you think you would have told them anything different than what you had told the mayor and Pusley?
No, I don't. Okay. I wouldn't have told them different.
In that conversation with my client is when you said, when you read the entire PowerPoint, you're referring to the altered slide, right?
Correct.
You said it's so, I'm quoting now, I think, if it's a correct transcription.
Yes.
It's so obvious that the reader or the writer wanted one to be led to believe that the FEMA was just recent, even the words like recently released and this and that. And part of it goes back to the narrative. Mike Culberson said, hey, this has to be tied to infrastructure. And so then they hatched the scheme that, okay, FEMA, floodplain, that's infrastructure. Does that sound like what you said?
Yes, it does.
And so it was very clear to you at this point in time that what had happened is not just that there was a federal document that had been forged, but also that there had really been kind of a plan to do it, or your word, a scheme, right?
It appeared to me that the PowerPoint seemed to have seemed to portray a story or scheme that led a listener or a reader down a particular path. And that path being that the FEMA floodplain maps were recently changed, and therefore we had to redesign the building, and therefore we're looking for money to help in this construction costs that now have elevated due to the new maps.
Yeah. And that was the narrative they were promoting, the applicant.
That was a narrative that was in the PowerPoint. It was one that was expressed in the Type B meeting, and it was one that was expressed at the, I don't know for sure, but I assume it was expressed in the first read of the item.
Yes.
Yes.
And the reason I'm asking you that, it may be the same reason you pointed out in your discussion with my client, but I want to make sure. Mm-hmm. The reason I'm asking you about it is one has to always consider, hey, did just some weird, was it just accidentally left off, or does it appear that it's connected with this false narrative that they were telling, and there's a connection that you're observing, and that is the document information removed is in concert with the false narrative, right?
Correct.
Yeah. And that all of a sudden starts making it look like the removal of the information was for a purpose, right?
Correct.
Yeah. And then you go on to say that they developed a narrative. They, I think, is the applicant, right?
Yes.
That they developed a narrative to fit it, that they just found out, because people would say, like, shit, they should have known about this a long time ago. Again, that's the same, you're alluding to the same thing, and that is this false narrative to pretend like it was recent changes in FEMA when in fact it was not.
And that they were recent, you said? Yes.
And then you said at least a second time, I'm going to try to keep count for you, quote, I'm not recommending it because I don't have the information I need. Does that sound like something you said that day?
That's it, yes.
And again, that goes back to you were requesting an explanation from Philip Ramirez or Devin Bachtor or that group, and they came in and you still did not have a satisfactory explanation on why they had altered the federal document.
Correct.
Yeah. And then you said again, I can't recommend anything because I'm still waiting on information. That's the same thing, right?
Correct.
And then you go on, you said that, however, because the council wanted this on the agenda for them to consider, it's on. And so my question to you is, when you are saying in that conversation with the cheat that the council wanted it on the agenda, who are you referring to?
Yeah, I'm not for certain, but I know the mayor and I think possibly were okay with the issue at hand of not having an explanation and wanted to proceed with having it on.
Both of them, you had informed them that there had been this altering or tampering or forging of a federal document, but they were still willing to support it, right?
Correct.
And that's true for the mayor and true for, I don't want to throw them together, so I'm going to ask individual questions. So
X-ray Robert 7248.
what you're telling me then is that the mayor had definitely been made aware that the altered federal document used at the time of the first reading to support the request for $2 million, that even though it had been a federally altered document, she was still, had indicated she's still okay with moving forward and approving it.
Correct.
And that's consistent with her,
I'm sorry.
the mayor's desire to put it on.
I'm sorry, can we pause the video?
Thank you. And we have to, for purposes of optional completeness, after he said correct regards the mayor, the question was, and same thing for Mike Pusley, correct. And if I heard you right earlier, it sounds like same thing for Roland Barrera because of what you explained.
Mr. Flood, can you give us a reference page and line?
I apologize.
Thank
you. I apologize. It ended, the proffer ended at 89, page 89, line 17, and where it didn't go was line 18, which the question starts, and same thing for Mike Pusley.
Testimony.
Answer correct question, and if I heard you right earlier, it sounds like same thing for Roland Barrera because of what you explained earlier. Answer correct. That ends at line 23. Thank you.
Okay, thank you. Resume.
She was still, had indicated she's still okay with moving forward and approving it.
Correct.
And that's consistent with her,
were okay with the issue at hand of not having an explanation and wanted to proceed with having it on.
Both of them, you had informed them that there had been this altering or tampering or forging of a federal document, but they were still willing to support it, right?
Correct.
And that's true for the mayor and true for, I don't want to throw them together, so I'm going to ask individual questions. So what you're telling me then is that the mayor had definitely been made aware that the altered federal document used at the time of the first reading to support the request for $2 million, that even though it had been a federally altered document, she was still, had indicated she's still okay with moving forward and approving it.
Correct.
And that's consistent
I'm sorry,
with
I have to stop. I have to request that it
the
end
mayor's.
again. Please, again, it was heard again, so the harm is just being compounded at this point. So I have to, again, read, picking up again, page 89, line 18, and same thing for Mike Pusley, answer correct, question, and if I heard you right earlier, it sounds like same thing for Roland Barrera because of what you explained earlier, answer correct, at end of line 23. Thank you.
Thank you, Mr.
646, 1042.
Desire to put it on, and your testimony that she still wanted to approve it is certainly consistent with what we saw when we played the video clip of Councilman Hunter talking, and that is she's clearly advocating for this ordinance.
That's what it appeared like, yes.
And then later you say, quote, I just want to make sure that you knew what my position was. You're talking to my client.
Right.
Because I'm not recommending it, but I'm putting it on for them to consider. Again, same thing, right?
Correct.
So it looks like during the course of a few minutes, whatever that conversation is, I mean, you were repeatedly saying, because you had not found a satisfactory or been given a satisfactory explanation, you're very clear that you don't think it should go on the agenda, you're not putting it on the agenda, and that the councilmen, some of them want it, and so you're going to put it on the agenda. Am I right so far?
Correct, you are.
And that it's also going to have a statement in there with your agenda memorandum that says staff is not recommending it, y'all can consider it.
Correct.
As far as you can recall, only time ever where you, as staff, didn't want to put your stamp of approval.
That's correct.
I think I mentioned earlier that we had deposed Heather Holbert.
Yes.
And I'm going to play a portion of her deposition and ask you to comment or agree or disagree just to get your comment on it. Go ahead and roll that. It's marked as Exhibit 13 to the deposition.
Can you pause the video?
Thank you.
You to comment.
Thank you. This portion, where a portion of Heather Herbert's deposition is being played, is a violation of 805. It's a hearsay within hearsay, and it's simply asked for and make an objection and request a ruling that this portion that goes from page 94, line 14 to page 95. I believe that's the portion that her deposition is being played. It's hearsay within hearsay, violates 801, 802, and 805, which are hearsay rules within this proceeding, and ask for a ruling on that objection. Thank you.
Mr. Ellison.
9414 through 9523.
Is 1042.
Go ahead, over.
159 or 129, are either one of you available for code 12?
Well, and you know what, as we're looking at this, for efficiency purposes, there's the exact same problem, and we can make this all one objection. There's the same problem, page 96.
Hey, Don, grab that one, please.
Page 96, line 1, all the way to page 100, line 11. All multiple hearsay embedded within hearsay. And would object to same and ask for a ruling. Striking that.
What's the end point on that one?
Sure. Page 100, line 11. It's when Hurlbert's prior testimony is being shown to another witness.
It relates to playing her testimony?
Yes. Yes.
I don't think there's anything wrong under the rules at all, even the rules that we abide by. I don't think there's anything wrong under the rules. In fact, I think it complies with the rules in order to, you can present testimony to another witness and ask if they agree or disagree and comment, and that's all that is. So I don't think that's a problem at all to present that testimony, and would ask that the motion be to overrule that objection.
Panel, do I have a motion and a second? All in favor say yes. All opposed say nay. Motion approves. If you can.
Thank you.
Thank you, Mr. Flood. If you'll proceed.
And agree or disagree just to get your comment on it. Go ahead and roll that. It's marked as Exhibit 13 to the deposition.
Okay.
So you had false information because it's altered being part of what was supporting the award. I'm using the word supporting because it says supporting documents.
Yeah, supporting the agenda item, yeah.
Yeah, which is approval for $2 million. Correct?
Yes.
Okay, so there's a direct link, even according to your memo, of that PowerPoint presentation that has the false or misleading information in it and the award of the $2 million.
Yes.
And that's, again, that is a horrible thing to have in terms of a record for use of public money. Agreed?
Yes.
Did you hear that okay?
I did, yes.
Do you agree with that testimony?
I agree with what she said, yes.
Yeah. And what she's doing is connecting, she's observing the relationship between the falsified forged document and how it was used directly to make the request and receive a favorable vote from the city council during the first reading, right?
Correct.
Okay. And you agree with her? That's I think the word we use there is that's very misleading of the applicant to do that, correct?
Correct.
And the word we used there I think was horrible or terrible. It's certainly something that should be disqualifying for that application, right?
I'm not sure about disqualifying, but it shouldn't have been brought forward.
It should not go forward.
Right.
Okay.
Yeah, it shouldn't have been considered.
Yeah. I'm going to now also play another clip from her deposition, and this is exhibit number 14. I'm using now their words, and without me making them up or you making them up, and without them being your words, you don't have any reason to disagree with that characterization.
Yeah.
That's in the conversation. It was clearly nobody was fighting about it in the discussion.
Yes.
Okay. And so, is it okay then if we refer to it, at least while we're talking about this recording, as being the concern here was the tampering with a United States federal portal?
Yes.
Okay. And so, it's very clear, I think, that by this point in time, and again, we don't know the exact date, but by this point in time, we're between the first reading and the second reading.
Yes.
So we know we're between February 20 and April 23rd.
That is correct.
And during that time frame, it's very clear that Peter has full knowledge that this tampering with the United States federal porthole has occurred.
Yes.
And it's very clear he is the one that characterizes it or uses the word scheme.
Yes.
And he actually goes into an explanation about how, there was a need for an infrastructure component, so they made up this FEMA thing, and it was a scheme to basically get the money. That's all in there, right?
Yes.
And it was a scheme to get the money that was the scheme is the tampering with the United States federal porthole, right?
Yes.
To get $2 million, and correct?
Yes.
And is that consistent with what your investigation found?
Yes.
Yeah. Did you hear that testimony? Yes. And I hope you could tell from context it is talking about it's her having listened to the recorded statement between you and my client and her trying to understand what was being said in that discussion, right?
Correct.
And then at the end, her testifying that what you said in that conversation was consistent with what she found in the investigation.
Correct.
Okay. And I think that really the point of it was that she listened to the description that is in the recording about it being a scheme, that it was basically cooked up in order to have a basis for getting the $2 million, and that her investigation confirmed that, right?
Correct.
And you agree with all that? That's what happened here.
I do, except that I'm not sure what her investigation was, Heather. I kind of told the council I am doing an investigation because this item rose to the council level. It was high profile. Heather probably, I don't know I can't speak to what her investigation was per se, but I know she probably had to have similar conversations.
And her, whether you call it an investigation or her path to figuring out what had happened, what she's letting us know led us to the same conclusions that are articulated in your recording with my client.
Correct.
And that
And you don't dispute any of that?
I don't dispute any of that. Just I wanted to point out that her investigation was may not have been the same as mine.
I understand.
In terms of when things took place, whom she spoke with, that type of thing.
Yeah, and I guess that even is really my point, is that two different approaches came to the same conclusion.
Okay.
Right?
Yes. Yeah.
Okay. Then I'm going to play exhibit number 15, and it's still part of her testimony.
So if I give you this definition that forge, like forging a document or writing, that forge means to alter, make, complete, execute, or authenticate any writing that happened, right? So that it purports to be the act of another, like FEMA. That happened, right? In this case. Who did not authorize it. We talked about FEMA didn't authorize it, right? That happened in this case.
We're going to play that clip for you now?
Yes.
Okay. We're going to restart the one that was there?
Yes.
Okay.
Start from the beginning.
So if I give you this definition that forge, like forging a document or writing, that forge means to alter, make, complete, execute, or authenticate any writing that happened, right, so far? So that it purports to be the act of another, like FEMA. That happened, correct? In this case. Who did not authorize it. We talked about FEMA didn't authorize it, right? That happened in this case. If that's a definition of forge, then the facts of this case meet that definition. Yes. I'm going to give you another definition of forge. That forge means to be a copy, to say, hey, this is a copy of an original, when in fact no such original, like we see in the slide, exists. You understand? Yeah, if I purport to, hey, this is what it looks like, and no such original exists that looks like that, yes, then that's a forgery according to what I just read, I think, but I want to say it to you again. Do you understand where I'm going? Yes. I'm giving you a second definition of forge. Forge means to be a copy of an original when no such original existed. Do you understand the definition? Yes. And we have that in this case. Yes. Okay. Those are two different definitions, and both of which you have agreed those facts are in this case to meet that definition of forge. Yes. Okay.
Did you hear and understand her testimony?
Yes, I did. I don't know if I completely understand it, but I heard, yeah. The two different definitions?
Yes, sir.
Yeah.
And then I also showed you my screen, which had the actual statute language as I was reading along, so you got to see it too?
Yes.
And she obviously testified that what occurred in her view here met the definition, the penal code definition of forgery, right?
Correct.
Do you agree with her?
I agree with her.
Yeah. I'm going to go to, well, and let me back up for a minute. You told us earlier, and I understand you are not an attorney, right?
Correct.
And at the same time, of course, what we're looking at is a legal statute, right?
Correct.
But you've also told us earlier that one of the requirements for you as city manager is to make sure that your processes are complying with the law, right?
Correct.
And although you're not an attorney, you certainly have, I know, years of experience, all city government, and reading rules, regulations, laws, statutes. You have a legal department. You are somebody who has a lot of experience in looking at issues and looking at law, looking at statutes, and trying to make your processes comply with those legal requirements, right?
That's correct.
And so even though you're not a lawyer, you're somebody who is in a position of authority, certainly, that you have to be able to read statutes, whether it's a forgery statute or some other procurement statute or whatever, and look at the facts to make sure that you're not getting off track.
That's correct.
Yeah. And would this forgery statute be a precise reason that you would completely be of the mind, after learning of the forged document, to say very clearly, as you did on the tape, I think, or audio?
Thank you. Yes, sir.
Well, we might have actually been a little too quick to the gun on that one. It's coming up. And I apologize. It's going to be the next answer where that's the sole reason why at line 20 I'm going to need to object starting at line 21 in the references to Sony Parnell on this question. So
it's page which line?
Sure. It's page 101, line 21 to 102, line 16. And the objection is hearsay. Counsel states that Parnell told David that Zanoni warned council members not to touch the item. That is hearsay. And so I'm objecting to that testimony as hearsay. It's patent hearsay.
Thank you, Mr. Flood. Mr. Allison.
Which page line?
Page 101, line 21 to 102, line 16. It's Parnell's account of what Zanoni allegedly told council members. It's a report statement. Is that a question?
Okay.
And actually, to the question about what did he said, he says, I don't know if I said that or not, and then he makes a different comment, so I'd stand on the offer.
I'm sorry?
I'd stand on the offer because he actually, the question is, did he say this to you? And he says, I don't really know if I said it, but here's what I think. And his testimony about here what I think is admissible, and so he would ask that the objection be overruled.
Okay. Microphone, Mr. Flood.
Apologies. The question specifically asks for the hearsay. And he says, I can't recall if I said that exactly, but I would. Let me think how I can say this. And so he characterizes the invited hearsay in other words. So it's not hearsay. It's just he changed the hearsay. It's still hearsay. That's my objection.
Thank you.
Yeah, I think it's cumulative, and I don't think it's hearsay.
Do I have a motion from the panel?
Yeah. You haven't heard it yet?
Okay, so I think we'll probably need to play it further and then go.
I don't think anyone knows who's asking what.
Appeared, he's talking about what he thinks now, which is admissible, I think, given the fact that it appeared of a law, federal law had been broken, I wouldn't have considered it.
And I amend my motion, my objection now, and move to strike.
Do we have a preference of this panel? Do we understand now? Okay. So there's a request to deny and a request to retain. Do we have a preference?
So my objection was hearsay. It was then read into the record over objection without a ruling, and so now I've moved to strike what was read into the record because it's all hearsay. Page 101, line 21, question starting at 21 to 102, line 7.
Okay, so we would need a motion to strike or not. We have a motion to strike. Do we have a second?
Who's made a motion?
I made a motion.
Okay, got it. Thank you. I was just getting it clear.
Okay, is there a second for the motion to strike? I'm sorry? There's a second? Can you clarify, are you seconding the motion? No. Okay, then we have no second on the motion to strike. Do we have a motion? Do we have a second? All in favor on the motion to deny the objection, say aye. Aye. Any opposed? Thank you.
Recording 5 different times, and I'm not going to recommend it.
That's the sole reason why, yes.
One of the comments from Sony even was to my client was even that you had told some members of council, hey, don't touch this, something along those lines. Did you do that?
I can't recall if I said that exactly, but I would let me think how I can say this here. Given what we knew at the time, given the fact that it appeared a federal law had been broken, I wouldn't consider it yet. I wouldn't have put it on the agenda. I wouldn't have voted on it if I was a council member.
I'm going to play exhibit number 16. This is a clip or portion of the deposition of Mike Culbertson. It's number 12. But we can agree that forging or falsifying or altering a document in order to play into a narrative that it's a recent change when it's not really that recent is a misrepresentation, at least, about the need for the project. I would agree. And you shouldn't give them $2 million. I'm trusting in your character here. You should not be asking for or receiving $2 million if you're misrepresenting material information like this on a project. I would agree. Yeah. Do you agree with Mr. Culbertson's testimony?
I do agree with it, yes.
Let me show you exhibit number 17, and this is an article that was attached to a text message to you and Sony, and it had to do with charges brought in a Westlaco scam. Do you remember that at all?
Vaguely, yes, sir.
Okay. I'm going to let you review the attachment, and it may refresh your memory.
Okay.
It's exhibit 17.
Okay. Yeah.
It's information sent by my client to you that it sounds like you vaguely remember that happening.
I do remember it, yeah. I don't remember the content, but I do clearly remember it happening.
Okay.
Yeah.
And it was the content, though, of it is you just had an opportunity to review, right?
Correct.
And what happened here essentially in Westlaco was that they created some sort of fictitious, is the word they use here, consulting agreement that had to do with then delivering a $300,000 incentive for a project, right?
Correct.
And obviously the creation of a fictitious document is sort of like a forged document, right?
Correct.
And was it clear to you that and it sounds like you already understood the seriousness of it, to be honest with you.
Correct.
But was this my client also letting you know, hey, this is serious?
I would agree with that.
Is that the way you kind of took it? Hey, he knows it's serious, and you're probably saying to yourself, I know it's serious too.
Correct.
In this Westlaco article sent by my client to you in the time frame we discussed, the specifics of it also include that it led to the arrest and charge for conspiracy to commit wire fraud, right?
Correct.
Okay. That means sounds like somebody was indicted, right?
Yes, sir.
And that indictment extended to people on they call them city commissioners, not councilmen, right?
Correct.
And so a vote that was in relation, in this Westlaco matter, a vote that was allowing for an incentive payment for $300,000 led to, because of the fictitious nature of the underlying documents, led to criminal charges against the councilman or commissioner for the city at that location.
Correct.
That would be like in the equivalent of somebody on our city council putting themselves at risk for a criminal charge by voting to approve something supported by a fraudulent document, right?
Yeah, correct.
Yeah.
I would agree with that.
And that's why I'm sure a moment ago you said you wouldn't vote on it.
Correct.
Knowing what
if
you
I could vote, yes.
Pardon?
If I could vote, yes, I wouldn't vote on it.
If you could have voted, you would have said either no to it or you would have just not voted on it.
Right. I probably would have voted no rather than abstaining.
And that's because you recognize that an affirmative vote in this case to allow the $2 million award creates risk or jeopardy to the councilmen and women who approved it.
Correct.
Including the mayor.
Correct.
And that jeopardy is a jeopardy that goes so far as to be a criminal offense they could be charged with.
Correct.
Yeah. Instead of the second reading being the same as the first reading, the second reading is now going to be this new and different thing.
That's what it seems. Yes.
That's what happened, in fact, right?
Yes.
Yeah, it says the money's for costs associated with the street level retail, public space, and outdoor dining area. Did I read that correctly?
Yes, you did.
And I think they say it once, and then again twice, and then again a third time, and then again one more time down here, correct?
Correct, yeah.
Okay, so they're making extra sure to run 180 degrees the opposite direction of reading number one.
Correct.
Okay. And no secret, that's because everybody's now figured out there's a forged document, right?
Probably so, yeah.
But even though this effort was going on and you kind of have a lipstick on a pig now?
Correct.
You understand the reference?
Yes.
I mean, you can't undo what has already been tainted. Do we agree on that?
I agree, yeah.
I mean, even though you're putting a pretty new face on it for the second reading,
right,
that still does not undermine, or that does not change the reality that the first reading was completely tainted.
Correct.
Okay.
Yeah.
And what we're seeing here is a first reading then that was for one reason, and that was the banner for the money for the first reading at the time of the first reading was for money to meet what they falsely called new floodplain, new FEMA requirements, right?
Right.
And now FEMA's not even being mentioned anymore in this second reading, right?
Correct, yeah.
Okay, and so the second reading obviously then is not the same, we went over those definitions, not the same as the first reading.
Correct.
Okay.
Yeah.
And you understand that means then the ordinance was not passed in accordance with the city charter?
Yeah, but if the city charter says the first and the second should be substantially the same, then, right? Is that what you're referring to?
Which even worse for the city than that, okay? I'll go ahead and read it to you. So let me go ahead and mark it as Exhibit 25, the city charter. and it says, quote, "No ordinance shall be passed finally on the date it is introduced, but the same shall be considered and voted upon at 2 regular meetings." Understand what I just read you?
Yes.
And so what it's saying, shall be considered and voted upon, is the, quote, "same shall be considered." Do you understand what I just said?
I do, yes.
If you want to read it, it's right there.
Shall be passed finally on the date it is introduced, but the same shall be considered and voted on. Yeah, upon 2 regular meetings. Yeah.
Okay, and the definition we used earlier for the word "same" obviously says being one without addition, change, or discontinuance, identical. Obviously, the first reading version and the second reading version are not the same, right? Correct. And there were multiple definitions, but the answer is always the same. Mm-hmm. One of the definitions was being the one under discussion or already referred to. With that definition of "same," obviously the first reading as it was worded and the second reading of the ordinance as it was worded are not the same. Agreed?
Well, at least the memo is not the same. I don't know about the motion or whatever, the ordinance.
Right, and that's where we got into a discussion with some of the witnesses. I think everybody agrees, though, reasons matter to why you vote.
Right.
It's a completely different thing to say I'm going to give you $2 million for FEMA requirements and to say I'm going to give you $2 million for your dining.
Correct.
Okay.
Yeah.
And so if the definition of "same" is, quote, "resembling in every relevant respect," we can agree it was not the same because it was not resembling in every relevant respect.
Correct.
And if the definition is conforming in every respect, you know I'm quoting from the definitions. Mm-hmm. If the definition of "same" is conforming in every respect, then we can say that the first reading ordinance and the second reading of the ordinance were not conforming in every respect, correct?
Correct.
And therefore not the same, right?
Correct, yeah.
And if I'm going through every definition. If we consider the definition of "same" to be being the one under discussion or already referred to, we can agree that the way it was being done at the first reading is not the same as it was being under discussion and referred to in the second meeting, right?
Correct, yeah.
And therefore not the same.
Right.
Okay. And if the definition of "same" also can include corresponding so closely as to be indistinguishable, we know the first one and the reasons set forth were clearly distinguishable from the second reading, right?
Correct, yeah.
And therefore the first reading and the second reading were not the same.
Correct.
Okay. And so given those definitions of "same," is it clear that the first reading and second reading do not qualify as the same that was to be considered and voted upon?
I would agree with that.
And therefore did not comply with the 2-reading rule in the city charter?
Yes.
And you knew that the mayor was going to be for it, even knowing there was a forged document, right?
Correct.
We can't have a passed statute that's got half felony problems and half is okay, right?
Right.
And you've already agreed multiple times that the same one did not get 2 readings here, right?
Correct.
Did you ever get an explanation from the mayor as to why she was continuing to support an ordinance that had the taint of a felony, or what looks like a felony forgery?
No, I did not.
It sounds like, though, the mayor never offered any argument to you as to why she was, because let me back up. We see the mayor at the first reading repeatedly telling Councilman Hunter, it's changed, it's changed, it's changed. She's clearly advocating during the meeting for passage of this ordinance, right?
Right.
And you made it clear that she was communicating with you between the February meeting and the April meeting, that she was communicating with you about wanting to get it back on the agenda.
Correct.
And that the mayor was also communicating with you in that same time window and letting you know that even though it's a federally altered document, she's supporting it.
Correct.
I'm going to play the deposition of Mike Holbertson. Are you ready?
Yes.
This is Exhibit 27.
Okay.
The phenomenon you described earlier where if one new restaurant opens, one closes, because this is not a destination hotel, it runs the risk of doing that here in Corpus, right? That's correct. And that's another reason that there should not be
public money spent on it. It does not help the economics. It doesn't, right? Which is the whole reason you're supposed to be giving public money is to help the economics. That's correct.
Do you understand that, Clint?
Yes, sir. No, I do. Yeah.
And the word we used even some during the deposition was sometimes one project will cannibalize another. Do you know what that means?
Yes, I do.
In other words, and Homewood Suites is not like a Disney hotel.
Right.
And so it's not a destination hotel, doesn't bring more people to the city.
Right.
And therefore, because of that, it would not be qualified to receive incentive money given the CCPD guidelines, right?
Right. If it's based on economics, like Culbertson was saying.
Another point associated with that clip being, though, that if the project is one of the type that he identifies cannibalizing, right, and therefore does not support a incentive grant and also does not have infrastructure, those are two reasons that it should never have even gotten out of CCPD, right? And we know that there's one way to get something on an agenda, and that's to have 3 councilmen sign a piece of paper.
Right.
That didn't happen here.
That did not happen.
So the other 2 possibilities are either you put it on the agenda or the mayor put it on the agenda. Am I right so far?
You are.
Did you put it on the agenda? One way to get something on an agenda, and that's to have 3 councilmen sign a piece of paper.
Right.
That didn't happen here.
That did not happen.
So the other 2 possibilities are either you put it on the agenda or the mayor put it on the agenda. Am I right so far?
You are.
Did you put it on the agenda?
Technically, I did, but at the direction of the mayor and maybe other council members.
But other council members can't direct you unless they have 3 that sign something.
Right.
So the technical reason, or the true reason, if you're following protocol here, I think that it got on the agenda for the April 2024 agenda, right, is, if I'm understanding you, is you did it, but it was at the direction of the mayor.
It was at the mayor did recommend or ask that I put it on.
And she has the power to do that.
She does.
Yes.
Yes.
Okay. Whereas no other single councilman has that power, except a single councilman can request it of you to exercise your power.
Correct.
Yeah.
My apologies. For purposes of optional completeness, there at page 131.
For the day, but they are required to manage all of their parking on the property. So no on-street parking, nothing across the street, has to be off the street on the private property. And like I said, we don't expect that to be a high traffic volume.
You said that you recommended
and then
on the merits
just
of the
getting
2
the
million
special permit to be a law office.
Right?
Let's say that law office shuts down.
That ends up.
Does it go back to the original zoning, or can you explain that process?
Absolutely. Then that's another very good question. So many times with staff we're deliberating, should we or should we not, what our recommendation would be.
We'll get back to that. I don't need to do that right now. And I was about to say, Your Honor, you're presiding. That concludes our offer with regard to Mr. Zanoni, other than maybe 1 or 2 lines of optional completeness I would locate tonight.
Okay, thank you.
Meteorologist Carly Smith is here now with the very latest. Carly.
Yeah, we're going to start with the impacts here locally. Yes, there will be some local impacts. Now, we're not expecting a direct landfall at this point in time based on the current forecast, but we are expecting some rain. So we do have a weather impact alert for heavy rainfall, tropical downpours Thursday evening through Friday morning. So be ready for heavy rain. There is a flooding risk. There is a low chance for tropical storm force winds if there is a southern shift in the track, but right now it is expected to stay
I agree
what you need to do
reconvening
is, have some rain gear ready, drive safe. Now, most of this rain will be overnight.
That members of this tribunal are material witnesses with personal knowledge of disputed adjudicated facts and therefore cannot simultaneously act as neutral fact finders.
Here's the latest radar image and cone stacked on top of each other. So you do see rain racing out ahead of the storm. We may even see a little bit of rain here earlier than Thursday evening. That'll be worth keeping an eye on as well. There is a risk of severe weather across southeast Texas right now with these bands racing out ahead of Bertha. Right now, 45-mile-per-hour winds.
Christi. 1041.
Attention. Satellite contact to is now overhead at 2,249.500 meters. Elevation 21.2 degrees.
One 24. Snowboard.
For a suspicious person, caller advised on his ring camera he had a white female with black hair pulled into a ponytail and a sleeveless shirt, knock on his door, and attempt to open the door, and then leave on foot approximately 5 minutes ago. He advised there was a box that was delivered that was on the doorstep. Unknown if she took the box with her when she left on foot, and he is en route to that location now. So your vehicle is unconfirmed, expired number 25 on the 17 Ford. Your subject eligible expiration of 30. It's showing, it's showing clear.
Transmitted over 60 on 2,240.000 megahertz. Transmission over 16 has stopped.